David Client and Sean Eisenberg on behalf of the petitioner. We also have our client here this morning.
All right, welcome all. And on behalf of the respondents.
Your Honor, Alan Miller here on behalf of the respondent Thomases, Randy Thomas and Cedric Thomas are here today as well.
And so we have a signed pretrial order, although before we went on the record, the parties indicated they had some other matters they wish to raise before reaching the evidence. So I'll start with the petitioner and let's take them one at a time. Mr. Klein.
Sure, Your Honor. So I think maybe if we start with the easier ones. So I think that we have an agreement in terms of admissibility and authentication documents that are listed on each of the exhibit lists. I only have issues with three of the exhibits, which are part of the 13-611 claim. And then also the motion to bifurcate the 13-611 issue. We don't have any objection to that. If it streamlines things, that's great. I think that it could be handled maybe even over a later Zoom hearing if the court needs to take things under consideration. So those are the first two things.
Let's just address them as they come up here, so we don't forget anything. So I take it the motion to bifurcate is unopposed, and so the issue of.
Honor, if I may, I'm sorry. I don't think that we need to bifurcate anymore. In fact, I think that the issues are so intertwined that we just need to do it all at once and let's just get it done.
Okay.
I do not agree to bifurcate. I think it'd be quicker to just go ahead and get it all done.
Well, I'll put it this way, with efficiency in mind, is we're going to hold off on the amount and reasonableness of attorney's fees until I first make a finding on whether there's liability. Maybe we'll decide that. I mean, I would anticipate being able to decide that today, and then we can, at that point, see where we are. And I would also is there actually a dispute as to the amount and reasonableness on the part of the plaintiff, having looked at maybe the documentation provided by the respondents?
Initially, I think we got it on Wednesday. I think both of us had a lot of invoices, but I didn't see anything out of line or anything.
Okay, so something to think about is whether that's even something that would need to be proven, meaning that if there is a finding of liability on the claim, the amount just flows automatically from it.
Actually, if I can, I'm going to amend myself on that. So there are some counterclaims, I think, that were, not allowed to be added by the court. So I think some of those fees would have to come out.
Okay, so there's still things to sort through. All right, and so as noted, again, we'll just be focusing on the liability and in the case in chief, and we wouldn't have to address the amount of reasonableness until we revisit that later today. All right, what else? I guess so in effect, I'm granting the motion to bifurcate on those two issues.
All right. The other thing was just in terms of admissibility, authentication of documents. We had Mr. Miller and I have discussed that beforehand, just to streamline things. I'm fine with that approach as long as he still is. The only issues that I have are with on their exhibit list under the 13-611 attorney's fee claim are numbers 5, 6, and 7. Happy to get into argument on why I don't think those should be admissible. If the court would like.
This is on defense exhibits 5, 6, and 7?
Correct. So
okay.
There was an attorney involved pre-litigation. It was not Mr. Miller. And I think she's on the witness list as well. Number 5 and number 6 are settlement communications. Those are barred by 24-4.
I'm sorry, say that again. Settlement negotiations?
Settlement negotiations between me and that attorney, and then also our firm, Mr. Eisenberg, and Mr. Buckmore, with Mr. Miller's firm. And then number 7, which is an email from my client to a police officer during the course of this litigation. Number one, I don't think that's relevant to the issue of attorney's fees. For attorney's fees under 13-611, there have to be bad faith conduct in the underlying transaction. So I don't see how that's relevant or applicable to this case.
The email was sent March 12th of 2025?
2025, correct.
All right. And
Your Honor, that's not an email from his client. That's an email from Ms. Thomas.
Or excuse me, from Ms. Thomas.
It involved a police report, a police incident that occurred in February 18th to be exact.
Right.
Now, as far as the motion in limine regarding those three exhibits, Your Honor,
Mhm.
I would point the court to Christie versus Rainmaster Irrigation, Inc., 299 Georgia Appeals 383. It states, under OCGA 24-337, proposition made with a view to compromise are not proper evidence, but one of the requisites for invocation of this rule is that the purpose of offering the evidence is to prove the validity or invalidity of the claim or its amount. We are not offering it for that purpose. Therefore, evidence offered for another purpose, such as showing bad faith, may be admissible. It goes on to state that the evidence in this case was offered to support the company's claim for attorney's fees. Because the evidence was limited to Rainmaster's claim under OCGA 13-6-11, which is exactly what our counterclaim involves, we find no error in admitting anything having to do with settlement. Settlement negotiations are clearly admissible under a counterclaim for 13-6-11. And the case that I cited has been shepherdized and it is still good law. In addition, Your Honor, under a 13-6-11 claim, the only evidence that is admissible is pre-litigation evidence having to do with under the rising out of the transaction. So here we have a fence that was apparently on Miss Martin's property, and Ms. Thomas received notice of it in April of 24 after she had given notice of this tree issue in February of 24. The lawsuit was filed in October of 24, but the litigation did not join until March 5th of 25, because that was the date that the answer was filed. And the reason the answer was filed so late is because there were 3 extensions of time given by the plaintiffs to the defendants strictly for the purpose of settling the case. And those 3 extensions of time to answer the complaint were specifically given to try to reach some sort of settlement. Therefore,
Understood. So, Mr. Klein, if this email was sent in February, which predates the filing of the answer, that answer includes the counterclaim, which is the vehicle for which these 13-6-11 fees are sought. Wouldn't that email then predate the filing of the claim?
It would predate it, but 24-4-408 still covers settlement negotiations. They're trying to prove their claim.
That's for the first 2 exhibits, right?
For the first, yes, for 5 and 6.
So 7, the email, your argument was that it's not underlying, but it does predate the filing of the claim, does it not?
The email from Ms. Thomas to Sergeant Strickland, no, this case was filed in 2024.
No, your case was, but his counterclaim wasn't filed until March 2025.
Well, there was still active litigation at that time. They're trying to use these settlement negotiations and that, let me just talk about the settlement negotiations. So they're trying to use the settlement negotiations to prove that there was some kind of bad faith conduct.
No, and I get that, but I'm just trying to cabin this. I'm focusing solely on the email 7, because that's what you challenged.
Sure.
And that doesn't relate to settlement negotiations. That's relating to, an email conduct intent. And your argument was that doesn't predate, it is not underlying the lawsuit, right?
Well, that's correct. I mean, that is during the lawsuit, but prior to their filing of the counterclaim. But I don't see how that's relevant to any portion of their counter. I mean, what does that have to do with attorney's fees? If it's litigation conduct, because the lawsuit was filed at that time, they hadn't filed a counterclaim, then I guess they can claim something under 915-14 or some kind of discovery abuse under 911-37. But
So this is what I'm trying to hone in on is that, the language that we in 13-6-11 case law is it has to arise from conduct underlying the transaction.
Right.
And it has to predate essentially the filing of the claim.
Right.
But there's nothing ever so specific that I've been able to find that kind of distinguishes between the main claim that's brought in a complaint and a counterclaim that's brought in the answer. And so would that starting date and time only be the complaint as you are kind of arguing here? Or does it not also mean that it's his claim, the answer, that's the starting point? We judge it, that starting point of what's underlying based on the thing that kicks off the claim. I haven't found any case law that says and gotten into that nuance. And under the language that we do have, I would think that it's the date the counterclaim is filed is that kind of mark in the sand.
Well,
Unless you found something differently.
yeah, I mean, they're trying to use these extensions of the answer that I gave them as professional courtesy to try and get this email in, because the claim existed at the time that I filed this lawsuit. We just gave them extensions to file an answer because we were trying to get the thing resolved. So, you know, I think that would be unreasonable. I also don't think I don't think it's relevant.
All right. Okay. Well, on Exhibit 7, I think on the main issue you bring up in terms of its, as a matter of law, being irrelevant because it is after the date of your complaint filing, I would deny that argument. In terms of this other relevance, we'll see what comes up. And I don't even know what the email says, so I don't know if I could really judge its relevance at this point. All right, so on to 5 and 6 in settlement negotiations. How under Rule 408 is this barred entirely and not just for the specific purpose of bad faith?
Well, they're trying to prove a claim. I mean, the claim here is 13,611 for attorney's fees. And, you know, I want to cite to the 2 cases, Oglethorpe Power, 332 Georgia App, 693, 2015 case, and Puckett versus John Bailey Pontiac Buick GMC truck, 311 Georgia App, 138, 2011. Those talk about, again, you're looking at underlying transaction. You're not looking at settlement negotiations related to that underlying transaction. This was an attorney that was engaged. I think it was a friend of the Thomases that contacted me via email with a settlement offer that said, in email chain, said confidential for settlement purposes only. So those communications that we had were settlement negotiations. I believe that she's going to come up here and testify on Zoom about the settlement negotiations because she was only involved for a period of 15 days. So if these types of communications be used against my clients at trial, then there's no purpose of even in negotiating in settlement negotiations. That's what the purpose of 244408 is so that you have confidential settlement negotiations that don't affect the validity or invalidity of claim, which here is 11 claiming that they're going to try and use the settlement negotiations saying, well, we should have accepted those settlement offers. We were acting in bad faith. Therefore, they're entitled to attorney's fees. That's exactly what 244408 is supposed to be protected.
All right, we'll have to look at those cases both sides have given. I mean, I know that the language of the rule is explicit that says to prove liability for any claim, but attorney's fees are not technically a claim. They're just a derivative form of damages. So I would think that might be it's not as explicit as we might think, but I'll look at those cases and
John, if I may, just very quickly.
Yeah.
The case, in that case, Christie's attorney next objection on the ground that the statement was part of a larger settlement.
I'm going to read it. You don't need to read it to me. I'll read it and then we'll get back to you. I think it's likely that I'm going to deny the motion because that's also my understanding of 408, but I'll look at it.
Okay.
But to your point though, on one of the letters again, now one of them's from 2026. Now that's well after, you know, the complaint and the answer. So how would that show conduct underlying the transaction, Mr. Miller?
Well, that in and of itself is another attempt to settle this case. I mean, the bad faith is in essence the fact that the Thomases have been trying to settle this case since day one. And the bad faith is shown by that refusal to settle this case reasonably. And I plan to get into quite a bit of that with my cross of Miss Martin. And all of that occurred before, well, except for the letter from King Buttermore in January of 26, where he certainly offered a settlement. I guess that would technically be inadmissible because it's settlement after the counterclaim was filed. But
so unless your questioning is in some way revealing intent before the pleadings, because subsequent actions can show how people felt and acted back in time, I think there's probably going to be a cutoff point at some point. I mean, just because it's stretched on for a year and a half, I don't think that means everything that's come up in that year and a half is relevant to a 13611 claim. As Mr. Klein points out, we have other avenues for litigating post pleadings stubbornness, but what we're here for today, that hasn't been raised, right? So I think we'll just have to take that up based on the questions as asked. And again, I don't know what's in this 2026 letter, but if it's really not in any way giving me anything that relates to pre-counterclaim evidence, then it's probably going to be inadmissible.
I understand.
All right. So that covers 5 through 7 on defense. Some of this, again, I'm just going to have to see in context. And again, after looking at the cases, what else pre-trial, Mr. Klein, did you have?
The only other thing I wanted to point out, I know that they have a motion to amend the pretrial order, which you can address first, but in the pretrial order at contention B, I'm not sure exactly what page it's on, but that's fine. But basically, the respondents say, quote, the respondents stand ready to execute any document and agree that no fence in the bush, no lawn astroturf will ever be built or planted upon petition of property. If that's still the case, I don't understand why we would need to go forward with an injunction, or maybe there could be some kind of a consent injunction. But I just wanted to point that out to the court because they're basically admitting in the pretrial order that they're not going to build anything on our property.
So what do you want me to do?
I need to talk to Mr. Miller about that.
Okay.
Well, I
Cell
don't think
phones haven't been working the last week. I mean, come on. What are we doing?
there's no reason that this court needs to hear anything about an injunction, Your Honor. That is one of their claims. It was one of their claims now. If the injunction is moot, just like we argued at the hearing. So there's no reason for an injunctive relief, period.
Well, and the reason why we didn't discuss it entirely was because the last of the encroachments were literally removed yesterday. So, I was getting ready for this trial.
All right. Well, as I mentioned, we're going to have 2 pleas to take. And so you'll have at least 15, 20 minutes. Y'all can talk. We have conference rooms. We can split you up. One of you can take the jury room. One of you can take the other conference room. And I think at the very least, it would be in y'all's interest to streamline some of these issues. I will reiterate, which is what I said at the motion hearing, which is I just, without, having gotten into the facts and making any determinations, I just don't see how this is not just throwing good money after bad at this point. I mean, y'all are still billing hourly, right? For today. So if you end at noon, it's going to be cheaper than if you end at 4 o'clock. I think it's in everyone's interest to let's get to the heart of it if we even need to. And also what you're even asking for at this point. I mean, realize you could both walk away with nominal damages. And if that $1 is, is worth it, fine. It's your money. I'm on salary. So you tell me what you want to do. Okay. Anything else, Mr. Klein?
Nothing from petition.
Okay.
I
Mr.
have
Miller.
3 trial memorandums. May I approach, Your Honor?
Sure.
The only thing I'd say for this, Your Honor, is, this is the first time seeing this. I guess I can conduct research, but I didn't know there were going to be trial memorandum.
I mean, I would treat this as if he was just making an opening or a closing. He's just
Sure.
putting it in writing, which I appreciate.
Sure.
All right. What do you, I mean, it's just things for me to read. Understood. I'll take a
Well,
look.
It would be in the nature of the first memo is on duty to mitigate. We dismissed our negligent maintenance counterclaim, leaving only the nuisance claim that the court allowed us to amend our counterclaim. Under a nuisance claim, there is no duty to mitigate. So there can be no argument that Brandy or Cedric should have pruned back the tree.
Even starting at first principles, I haven't had a chance to bone up on tree law. Do you have any of that for me?
Well,
I don't know if I've ever seen it in writing.
I do know that if it's a nuisance, then there's no duty to mitigate on the part of the plaintiff.
What I was more curious about is, I've always been heard as a homeowner myself, if the tree's on your property, but then it falls, where it falls is who's responsible for the damage. I don't know if that's what we're getting into today or anything along those lines.
Well, we will be getting into a little bit of it, Your Honor, because
Yeah.
Brandy and Cedric certainly put Miss Martin on notice that she had a tree with dead limbs that were hitting their house every time there was a storm.
And what I'm getting at, like, when it comes to trees specifically, those,
The duty.
with
duty is
where the
on
duties
tree
fall.
Owner, once they have a notice of a dying or dead tree or tree branches, the duty is on the tree owner.
To remove the tree entirely or just to trim it?
Take care of the problem.
And if something's over your property, the tree's extending over your property, do you?
Well, normal
Well, just let me
tree
finish
law-
my thoughts, Mr. Miller. It's going to be a long day if I can't just get my
Go
thoughts
ahead.
out, right?
Go right ahead.
I'm going to need more specifics of if a tree is extending over your property line, I guess this is going to your duty to mitigate, but you're saying that you don't have the right just to go ahead and chop off those limbs and that onus falls on the other side. That's what your duty to mitigate memo is getting at?
That's right.
Okay.
So with a nuisance, there is no duty to mitigate.
All right, fair enough. Mr. Klein, anything you want to respond to
Very
there?
briefly, I want to cite to the case of Willis versus Maloof, 184 Georgia App, 349, 1987 case. It talks a little bit about the Georgia self-help doctrine in that as long as you go up there and trim the branches on your side of the property and you don't damage the tree, you can do that at any time.
Is that in the context of a nuisance case?
I'm sorry.
Is that in the context of a nuisance claim?
I'm not sure if there was a nuisance here. I think they were claiming a trespass or, that the tree had been damaged, but they talk again, I mean, if you have branches over any property and you're not going to kill the tree by removing those branches, then remove the branches. And evidence is going to come out today that they could have done that back in 2021. So that's our position on that.
Okay.
And that would be evidence of some sort of duty to mitigate, which is
Right.
not a nuisance case.
Okay. Again, without having, I'll study this and we'll see exactly where, as a matter of law, the liability falls depending on the facts asserted. But again, I'll just say that in the amount of time it will take you to prove this and defend this, even if it's just 2 hours, I'm going to guess you could hire a tree trimmer and still save money. So anyhow, noted. Got the memos. What else?
The second one distinguishes nuisance from trespass, Your Honor. On Tuesday, the plaintiffs added a nuisance claim of their own. In addition to their trespass, they also added a negligence per se and a negligence claim. I guess that has to do with the building of the fence in the first place back in 2020, that it was built negligently because it was actually on Miss Martin's property and not on the Thomas's property, even though they thought it was on their property. It would be our right to now assert a statute of limitations defense as to that new claim for negligence, which involved an act that occurred back in 2020. So we would say that any negligence claim or any negligence per se claim is barred by the statute of limitations if it happened back in 2020. It's not a continuing act because they finished the fence in 2020.
Okay. And let me start there.
The next
Let
memo,
me just take it one at a time so I can have closure. Mr. Klein, I'm not hearing so much any kind of a procedural objection that you added these new claims, but he's saying that statute of limitations is now a live issue as a result. So any dispute there?
I mean, that's fine if he wants to assert that. I think there were things done, including grading and astroturf that took place after that. So, wants to assert that, we can put up evidence.
Okay, so we've got that as a live defense and all accompanying issues of tolling, intent, et cetera, notice. All right, Mr. Miller.
the next memo was distinguishing nuisance from trespass, Your Honor. They added the nuisance claim on Tuesday and that they have a trespass claim and they're not the same thing. There's case law cited there. A claim of nuisance may not be brought based solely on a claim of physical taking of the property. They have a trespass claim, although it's of course an innocent trespasser, but nonetheless, they have a trespass claim that cannot have a nuisance claim. They added one on Tuesday and this memo is directed towards that. Then the last memo deals with covenants and restrictions. And the fact of the matter is, the evidence will show that Ben, Randy, and Cedric built the fence. They built the fence as they understood it to be parallel to a chain link fence and on their own property. And they also advised the neighbors, and the neighbors, prior owners of the property that Ms. Martin lives in now, were all for it. They showed no complaints. They loved the fact that they built a privacy fence, and they basically acquiesced and agreed to it. Ms. Martin, when she bought the property in April of 23, she would have certainly known about the fence, certainly seen the fence, certainly visited the property. She connected a section to it in the front to totally enclose her backyard with her own fence. And that was done sometime in 23, we believe, 2023, before all this started. So it's our argument based on that memo that certainly the collateral agreement that was entered into by the prior owners of the property passes to the new buyer, Ms. Martin, and she is bound by it because it's an agreement to allow a fence to be in the location that it's in. So it runs with the title. And that's what that last memo deals with. Thank you, Your Honor.
All right, thank you. So I'll be on notice and can get into that either upon appropriate motion or on the conclusion of the evidence. Anything else to take up on your part in term before we would start testimony?
No, Your Honor.
Okay. All right. Then.
Well, one
Yes,
thing,
okay.
I'm sorry. I do have a notebook of all our exhibits. That's
Is it both sides?
prepared. I have a I sent them a copy, but I also have another copy for them for when I cross-examine Ms. Martin. But I do have a notebook, and they've all been admitted now. So I would like to give it to you.
That'd be appreciated. Is this a joint collective, all the exhibits, or this is just the
Fine.
just respondents? Okay.
We've got,
You got it.
yeah, we have the same. There's,
We'll take it. Thank you, sir.
Thank you.
All right. And last thing is a matter of housekeeping. I think I'm familiar with the contentions, the allegations, the basic facts. I don't need anything in by the way of an opening statement. I think we'll get right into the evidence. I also think that that it's in I want to make sure that we finish this today. And to that end, I know the parties have provided time estimates. I think that, again, knowing the nature of the claims, I think the witnesses that are planned to be called, Mr. Klein, is it still 3 witnesses on your part?
just 2. So the surveyor who's on Zoom, Ms. Martin, I guess myself for attorney's fees that we.
All right, that's if we get there. So two witnesses, we'll say, for case in chief, kind of phase 1. And on your part, Mr. Miller, 1 witness?
Randy and Cedric.
Okay, 2 witnesses. All right, so to that end, I think right now I would impose the time limitations, again, take into consideration the estimate of time that's been given, the issues, the complexity of the issues. And I would set that time right now. I'll keep it in live display up here on the clocks, but it would be, I think would say 2 hours for each side right now. And so when your witness is testifying, the clock's going down. If there's an objection, I'll pause it, play timekeeper. If it's an extended objection, if it's a short one, I can roll on. I'm not going to time it or stop it just for that. And then when it's cross, flip sides, and then your clock starts going down. And at the end, if you run out of time after 2 hours, the expectation would be that that's when you rest. If you need more time, you can move for it. And I'm going to take into consideration exactly what you need with that extra time, how much extra time you're asking for, and how you use the time that you were given. So if, for example, we were repetitive in the questions or got into tangents, then I might look on that less favorably for extra time. So we'll have petitioner in red, respondents in blue, and it'll be counting down from 2:15. Any questions on timekeeping, Mr. Miller?
Yes, Your Honor. Does the cross exam include my time?
It would. It would.
It would be, he would be able to take up my 2 hours.
No.
Exam?
Your directs and your crosses are your own time. So no, he can't wind down your time.
Okay,
That's your own. When you're speaking, it's your time.
got it.
Any other questions about how that'll work?
No, Your Honor.
Okay. Then unless there's anything to take up, we'll go off the record for a moment. Let me check in with my criminal attorneys. I saw Ms. Foster walk in.
I run to the bathroom.
Absolutely. I think we'll go off the record. And again, this is your chance to try to streamline some more things or have any final conversations you need to.
Do you need to clear anything from?
No,
Okay, thank you.
you can hold in place.
Oh, I'm sorry.
I'll get you.
Ms. Foster, we ready?
Yes.
Okay, what do we want to take up first?
Let's do Mr. Thomas first. He's
Okay.
on Zoom, so we need to admit him.
All right, so do we have Mr. Thomas on Zoom and can we add him to the screen, please?
Brick, Judge, can you give me
I
a
think
second? Let me just.
I'm gonna be right here, so. I had to mess with this stuff. And then.
If you turn on the video and unmute yourself.
Need to say that a little louder. All right, we have Mr. Thomas with us. If you could come on the video, sir. You have his phone number? You might want to give him a call.
Can I have the indictment, please? The indictment?
Hello.
There we go.
Okay.
Okay.
So I have your permission to sign the indictment on your behalf.
You want to do Khadijah right next as well? I'm gonna keep it.
Thomas.
Give it to me when you're ready for that.
For you.
Can you turn that microphone on? That might be a problem. He's not hearing you.
Yeah, I can't hear anything.
There you go. Can you hear me now?
Yes, sir.
Do I have your permission to sign the indictment on your behalf?
Um.
Either
Yes,
that or you can be here and sign it.
yes, you can sign it.
All right, thanks, Mr. Thomas.
Good one.
Judge, do we have a Mr. Levy in the waiting room on Zoom?
No.
Okay.
Quarter on. No, that's not.
Oh. No?
He's on.
It's good?
He's on.
Okay. All right. We all good?
We are, Judge.
Okay.
Mhm.
We're on the record now with 26 SC 001 319 State versus Rontarius Thomas joining us by Zoom. His counsel, Mr. Pitts, and the state through Ms. Foster is here in court today. Mr. Pitts, any objections to proceeding virtually?
No, Your Honor. In fact, we requested it.
And you have permission to sign the indictment on his behalf?
Mr. Thomas gave me that in open court this morning.
All right. Mr. Thomas, you can hear me all right?
He is muted.
Yes, sir, I can hear you.
All right. You can keep yourself off mute. And we'll just really try to speak up and into the microphone and maybe
Okay.
really turn up the volume on your phone. So I'd like to be able to see your entire face. And at any point, if you can't hear us, just interrupt, ask us to repeat. And if you need to speak with your attorney privately, just let us know, okay?
Yes, sir.
All right, Ms. Foster, again, speaking up for the microphone, if you could swear in Mr. Thomas, advise him of his rights.
Can you please raise your right hand? Can you hear me?
Yes.
Do you swear or affirm the testimony you shall give at a matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
You can lower your hand. Could you please state and spell your true correct legal name?
RONTERIUS. Thomas, THOMAS.
Are you at this time taking or under the influence of any alcohol, drugs, or medicine?
No, ma'am.
How old are you and how far have you gone in school?
26. I don't know. I've graduated high school.
Are you able to read, write, and understand the English language?
Yes, ma'am.
Do you understand that you are charged with the following offenses on the indictment? Count 1, aggravated assault. Count 2, terroristic threats. Count 3, possession of a firearm during the commission of a felony. Count 4, possession of a knife during the commission of a felony. And count 4, obstruction of a law enforcement officer.
Yes, ma'am.
Do you understand that you have the right to plead either guilty or not guilty to these charges? And if you plead not guilty or remain silent, you can have a jury trial.
Yes, ma'am.
Have you had enough time to speak with your lawyer about all the facts and circumstances known to you regarding the charges in this indictment, including any potential defenses?
Yes, ma'am.
Do you need more time to discuss the case with your attorney?
No, ma'am.
Are you satisfied with your attorney's services?
Yes, ma'am.
Counsel, are you satisfied your client has a full understanding of this proceeding?
Yes, I am.
And have you reviewed the indictment in this case?
I have reviewed it. We waive reading. I know of no defects.
Thank you. Mr. Thomas, were you arrested on these charges?
Yes, ma'am.
Your Honor, the state is unaware of any outstanding warrants related to these charges. Mr. Thomas, do you understand that you're entering a guilty plea to the following offenses? Aggravated assault reduced to disorderly conduct, which carries a maximum of 12 months. And count 4, willful obstruction of law enforcement, which carries a maximum of 12 months. Your Honor, the state will be no processing count 2 and count 3. Do you understand, Mr. Thomas?
Yes, ma'am.
Has your attorney advised you of the minimum and maximum sentence for each charge you are pleading to?
Yes, ma'am.
Do you understand this negotiated plea of guilty, which means the state will recommend to the court a sentence of 12 months probation?
Yes, ma'am.
Count 1 and count 4 will be ran concurrent. The special conditions will include no weapons or replicas of weapons, 40 hours of community service, mental health treatment, no further violent contact with the victim.
Yes, ma'am.
I'm sorry, mental health evaluation and treatment if necessary, no further violent contact with the victim, a family intervention course, no guns or drugs unless a valid prescription, and no further violation of the law.
Yes, ma'am.
Are you aware that the court does not have to accept that recommendation, and the court can sentence you to the maximum on each charge and can run those sentences consecutively or one after the other?
Yes, ma'am.
Do you understand if you are placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of the sentence?
Yes, ma'am.
Do you understand the general conditions of probation?
Yes, ma'am.
Do you understand if you violate any laws or conditions, the court could bring you back for a revocation, which means you could spend additional time in custody?
Yes, ma'am.
Do you understand this is a guilty plea, which is permanently recorded on your criminal history?
Yes, ma'am.
Do you understand if you are charged with a crime in the future, this plea may be used to enhance sentencing, including on a federal case?
Yes, ma'am.
Do you understand that if you are currently on probation, your probation may be revoked based on your entering a guilty plea today?
Yes, ma'am.
Are you a United States citizen?
Yes, ma'am.
Do you understand that there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there will be from a conviction following a trial?
Yes, ma'am.
Do you understand by pleading guilty? I apologize. Do you understand that you waive any and all defenses, including any mental health defense, by entering a plea of guilty?
Yes, ma'am.
Do you understand that by pleading guilty, you're giving up the following rights? I'm going to say them one at a time to make sure you understand. The right to trial by jury, the right to remain silent and not incriminate yourself, the right to see or hear the witnesses against you and to question them, the right to assistance of counsel hired by you or to court-appointed counsel if you cannot afford an attorney, the right to the presumption of innocence, which means the state must prove you're guilty of each charge beyond a reasonable doubt, the right to testify on your own behalf or remain silent, and the jury will be told they cannot use your choice against you, the right to present other evidence of your own and call your own witnesses if you choose to, and the right to appeal if convicted of these charges after a trial.
Yes, ma'am.
Counsel, are you satisfied your client understands these rights they'll be waiving by pleading guilty to these charges?
Yes, I am.
Mr. Thomas, has anyone forced, threatened, or promised you anything to get you to enter a guilty plea?
No, ma'am.
And is it your decision to waive these rights we just talked about and enter a guilty plea because you're in fact guilty?
No, ma'am.
Mr. Thomas, she needs to repeat that and you need to listen to it.
But say it one more time, ma'am. I ain't hear.
And is it your decision to waive these rights we just talked about and enter a guilty plea because you are in fact guilty?
Okay. Yes, ma'am.
As to indictment number 26 SC 001319, how do you plead to count one reduced to disorderly conduct
Guilty.
and count 4 willful obstruction of law enforcement officer?
Guilty.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
No, ma'am.
Mr. Thomas, I don't know what you're looking at, but please pay attention to Ms. Foster when she's talking.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes.
Do you understand what you're doing here today, Mr. Thomas?
Yes, I do, but I really don't understand the question.
If you could just
Have
break it
full-
in, yeah, go ahead, Mr. Pitts.
Do you have full knowledge of what's
Yes,
going
I
on here
do.
today and what
Yes,
the charges
yes.
are and what you're doing?
Yes.
And you're doing this willingly and voluntarily?
Yes.
Okay. Thank you.
Do you understand that you do not have a right to appeal directly from your guilty plea? But if you believe that there's some error in your guilty plea, you can apply to the appropriate appellate court to request a discretionary appeal, which is outlined in OCGA 5-6-35.
Yes, ma'am.
Do you understand that you have only 12 months from today for a misdemeanor charge to file a habeas corpus petition challenging the voluntariness of this guilty plea?
Yes, ma'am.
Your Honor, if this case were to proceed to trial, the state would show that Your Honor, the state can give a factual basis unless the defense stipulates.
We'll stipulate, Your Honor.
Just give me the basics of the victim as a position and the reason for the reduction.
Yeah, so the victim did want to join on Zoom, but I guess he wasn't able to be here. The victim is okay with the charges as reduced. They are from Louisiana, I believe, and he basically called the police to try to get the police to de-escalate the situation. But when the police arrived, they did let him know that, that the defendant did have a knife in his hand, and at that point they were going to arrest him. He believed that this is the best outcome for Mr. Thomas, especially with the mental health evaluation and treatment being included. Nothing further from the state.
All right. And is Mr. Thomas eligible for first offender treatment? Has he been advised of that possibility, Mr. Pitts?
We discussed first offender before the state agreed to reduce this to a misdemeanor. We were planning to enter it as a first offender for a felony, but as it's now a misdemeanor, my advice is hold on to that. He's still quite young.
All right. Okay. And so, Mr. Pitts, anything else?
Yes, Judge. The victim in this case, Mr. Levy, is Mr. Thomas's cousin. As the state rightly stated, Mr. Levy has told me on the phone that he is from Louisiana. There, they can reach out to police merely to have a situation de-escalated, but when police arrived here, they essentially told him that in Fulton County, if you call the police, somebody's going to jail, which was quite shocking to him. He is comfortable, and they both tell me that they're in a good place with each other as cousins. Mr. Thomas resides in Memphis, Tennessee. Mr. Levy resides in Dallas, Texas, so there's no issues between them getting into further trouble like this. So we will be asking the court to permit Mr. Thomas to phone report for misdemeanor probation as he lives in Memphis, and that's where he's visiting us via Zoom from today.
And no objection from the state, Your Honor.
All right. And so, Mr. Thomas, to confirm, this is your decision. It's a free and voluntary decision on your part.
Yes, sir.
And Mr. Pitts, you're satisfied your client is competent and that it's entered knowingly and voluntarily?
Yes, Your Honor.
All right. Well, I agree. I'll make those same findings that there is a sufficient factual basis and that this plea is entered voluntarily and intelligently. And I'll sentence you, Mr. Thomas, as recommended by the parties, which on count 1 reduced to disorderly is 12 months. I also see you served over a month already in pretrial confinement, so it would be 12 months to serve 1 month with the balance on probation. Count 4 is the same sentence to run concurrent. Your special conditions are as mentioned by the state: no weapons, no drugs or alcohol without a valid prescription, 40 hours of community service. You complete a mental health evaluation and follow any recommended treatment, no violent contact. You complete the family violence intervention program. Was that here? I mean, are they living together?
No, Judge.
They're-
One lives in
they're
Memphis, one lives in
cousins.
Dallas.
Yeah, so we can
One,
take,
it's a pretty onerous program.
we can scratch that. Your
Okay,
Honor.
we'll leave that off. We've got the community service, we've got the mental health treatment. And then, sir, your probation can also be phone reporting. And so do you have any questions about anything we've covered here today?
No, sir.
All right, well, we've got your contact information. So misdemeanor probation will be reaching out to you. You need to return that call and you'll follow up with them from here on out, okay?
Yes, yes, sir.
All right, unless there's anything else for the record, Mr. Pitts?
Last thing real quickly, I have provided his contact information, phone number, address, and email address, as well as the cousin's phone number for an emergency contact to Ms. Fortis this morning. And I will provide Mr. Thomas with a copy of the disposition as soon as we have it.
All right. Okay, well, then that concludes this matter. And Mr. Thomas, best of luck to you, and we'll be off the record. You can log off, sir.
Thank you.
Judge.
All right, and then we had Mr. Bray. If we could bring out Mr. Bray. And we have Mr. Bray and Mr. Ray. Is Mr. Ray still a bond motion?
Ms. Ray.
Ms. Ray, excuse me. That's still a bond motion, right?
It's gonna be a plea, Your
That's a
Honor.
plea now, okay.
Even better.
You're welcome to stick around after this is done. If you want to watch this, seems quite invigorating.
Tree law, right, Judge? Tree
Tree
law.
law. Tree law.
I
Just join one of the tables.
was actually thinking if the state would consent, we need to do more of those in our arena.
More bench trials?
Yes.
Richard Marks, we did 2 of them with him. It was remarkable.
Ready? All right. I need your autograph right there before we get started, Mr. Bray.
He also agreed to an 11-person verdict once because it was a hung jury. What's that? And he won it. Yeah, he won that one.
Remember I was on vacation, then I got the text, and I was like, that's.
Why did you agree to that? Oh, he must
Oh,
just,
you won.
he had that feeling. He
Okay.
knew. All right, we ready with Mr. Bray? Then we're on the record now. 25 SC 006-402, State versus Ricardo Bray, present in court with his counsel, Mr. Pitts. State here through Ms. Foster. And Mr. Bray had previously been on a trial calendar, but the parties had mentioned accountability court being explored. Is that still this outcome here? We've come up
It
with
is
something
not,
else.
Judge. Accountability Court has been their usual helpful selves. They will not continue evaluating him because they have discovered that he apparently, in their evaluation of his GCIC, his Georgia criminal information, has a warrant from a municipality for a misdemeanor in the state of Arkansas. Not an extradition, not a hold, just a warrant for a misdemeanor.
And that's
So they won't
disqualifying.
continue their evaluation. So.
All right. Well, Mr. Bray, at this point, the state's going to swear you in. They have to advise you of all the rights you would waive by entering a plea. All right. So listen very carefully. Ms. Foster.
Mr. Pitts, 1 second. Please raise your right hand. Do you swear or affirm that the testimony you shall give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
Yes, ma'am.
You can lower your hand. Could you please state and spell your true correct legal name?
My name is Ricardo Bray, Recardo, last name Bray.
Are you at this time taking or under the influence of any alcohol, drugs, or medicine?
Can you repeat that, please? No.
How old are you and how far have you gone to school?
I am born in 75, so I'm what? 50.
Actually, you're 51. You had a birthday this
51,
week.
yeah.
And how far
April
have you gone to
25th.
school?
I think I went to the 10th grade.
Are you able to read, write, and understand the English language?
Yes, ma'am.
Do you understand that you are charged with the following offenses on this indictment? Aggravated assault?
Yes, ma'am.
Do you understand that you have the right to plead either guilty or not guilty to these charges? And if you plead not guilty or remain silent, you can have a jury trial?
Yes, ma'am.
Have you had enough time to speak with your lawyer about all the facts and circumstances known to you regarding the charges in this indictment, including any potential defenses?
Yes, ma'am.
Do you need more time to discuss the case with your attorney?
No.
Are you satisfied with your attorney's services?
Yes.
Counsel, are you satisfied your client has a full understanding of this proceeding?
Yes, I am.
And have you reviewed the indictment?
I have reviewed it. We waive reading. I don't believe there are any defects.
Mr. Bray, have you been arrested on these charges?
Have I who?
Were you arrested on these charges?
Yes, ma'am.
You under the state is unaware of any outstanding warrants related to these charges. Mr. Bray, do you understand that you're entering a guilty plea to the following offenses? Aggravated assault, which carries a minimum of 1 year and a maximum of 20 years.
Yes, ma'am.
Has your attorney advised you of the minimum and maximum sentence for each charge you are pleading to?
Yes, ma'am.
Do you understand this negotiated plea of guilty, which means the state will recommend to the court a sentence of 7 years to serve 1, time served on that 1 year. The special conditions will include no weapons or replicas of weapons, an anger management course, continued mental health treatment, no drugs unless valid prescription, no further violations of the law, and no further contact with the victim in this case.
Yes, ma'am.
Are you aware that the court does not have to accept that recommendation and the court can sentence you to the maximum on each charge? It can run those sentences consecutively or one after the other.
Yes, ma'am.
Do you understand that if you are placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of the sentence?
Yes, ma'am.
Do you understand the general conditions of probation?
Yes, ma'am.
Do you understand if you violate any laws or conditions, the court could bring you back for a revocation, which means you could spend additional time in custody?
Yes, ma'am.
Do you understand this is a guilty plea which is permanently recorded on your criminal history?
Yes, ma'am.
Do you understand that if you are charged with a crime in the future, this plea may be used to enhance sentencing, including on a federal case?
Yes, ma'am.
Do you understand if you are currently on probation and parole, your probation and parole may be revoked based on your entering a guilty plea today?
Yes, ma'am.
Are you a United States citizen?
Yes, ma'am.
Do you understand then that there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there would be from a conviction following a trial?
Yes, ma'am.
Do you understand that by pleading guilty to a felony, you cannot use, receive, possess, transfer, or own a firearm, and that if you did, you could be charged with another felony offense?
Yes, ma'am.
Do you understand that you waive any and all defenses, including any mental health defense, by entering a plea of guilty?
Yes, ma'am.
Do you understand that by pleading guilty, you're giving up the following rights? I'm going to say them one at a time to make sure you understand. The right to trial by jury, the right to remain silent and not incriminate yourself, the right to see and hear the witnesses against you and to question them, the right to assistance of counsel hired by you or to court-appointed counsel if you cannot afford an attorney, the right to the presumption of innocence, which means the state must prove you are guilty of each charge beyond a reasonable doubt, the right to testify on your own behalf or remain silent, and the jury will be told they cannot use your choice against you, the right to present other evidence of your own and call your own witnesses if you choose to, and the right to appeal if convicted of these charges after a trial.
Yes, ma'am.
Counsel, are you satisfied your client understands these rights they'll be waiving by pleading guilty to these charges?
Yes, I am.
Mr. Bray, has anyone forced you or promised you anything to get you to enter a guilty plea?
No, ma'am.
And is it your decision to waive these rights we just talked about and enter a guilty plea because you're in fact guilty?
Yes, ma'am.
As to indictment number 25ST006402, how do you plead?
Guilty.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
Yes, ma'am.
You understand that you do not have a right to appeal directly from your guilty plea, but if you believe that there's some error in your guilty plea, you can apply to the appropriate appellate court to request discretionary appeal. That procedure is outlined in OCGA 5-6-35.
Yes, ma'am.
Do you understand that you have only 4 years from today for a felony charge to file a habeas corpus petition challenging the voluntariness of this guilty plea?
Yes, ma'am.
You under the state can't give a factual basis unless the defense stipulates?
Defense is prepared to stipulate.
Your Honor, the victim was the family member of the defendants. He did state that, he was suffering with pain and anxiety and that he did want to see the defendant serve jail time. The defendant was in custody for over 200 days, and we believe that jail time is sufficient. And he's just asking to put this behind him as well. Nothing further from the state.
Any probation issues, Mr. Kuzu? Mr. Pitts?
Yes, Judge. As the state stated, the victim in this case was a family member, a cousin, and Bray himself was distraught over the passing of his mother, and there was something said that sent him over the edge. When I first met him, he very tearfully stated to me that he didn't mean for this to happen. He's been of a position that he was prepared to resolve this all along. As we've already let the court know, we attempted to present this to the Behavioral Health Treatment Court for resolution. Mr. Bray does take medication at the jail. I've spoken with him. He is familiar with Grady at 10 Park Place and knows that that's where he can go to continue receiving his medications. He and I have spoken at length about how important it is for him to continue the medication because it keeps him focused and in a good place. And when he's off it, it is not a pretty picture. He anticipates that at least initially he'll return to the family residence here in the Atlanta area on Fairburn Road. He notes that he has been informed that his cousin, the victim in this case, has moved to Noonan, Georgia. He also is contemplating a move himself to the Pine Mountain, Georgia area, where his father as well as his son reside. In addition to that son, Mr. Bray has 2 other adult children. He lets me know that he is an over-the-road truck driver. He's looking forward to getting back to work doing that. So he would like the court to understand and permit him to undertake that employment. He does hold a CDL, he tells me. And with that, Judge, we would ask the court to receive the plea as negotiated.
All right, Mr. Bray, so I just need to confirm you understand the nature of this charge? What this charge is about, aggravated assault?
Just have to say yes or no.
Oh, yes.
And I just also need to make sure this is your decision and it's a free and intelligent decision on your part.
Yes.
Okay. And Mr. Pitts, you're satisfied your client is competent?
Yes, Your Honor.
Okay, I will find that there is a sufficient factual basis and that the plea is entered voluntarily and intelligently. And I'll sentence you, Mr. Bray. Again, I just want to ask for the record, is he eligible for first offender?
He is not, Your Honor.
Okay. Then I'll sentence you, Mr. Bray, as recommended, which on aggravated assault is 7 years to serve 6 months with the balance on probation. You get full credit for that 217 days that you've already done. The special conditions, no weapons, no drugs or alcohol without a valid prescription. You take an anger management course. Mental health, you keep following any treatment you've been prescribed. And your cousin apparently doesn't want any contact with you, so you shouldn't be in any way reaching out to him in any form while under this probated sentence. I'll put in a special condition here as well that you can leave the state for purposes of work, just in case that's an issue with probation. And for any technical violations like failing to report, those will be handled by your probation officer with a sentencing cap of PDC or RSAT under the sentencing options system. Do you have any questions, Mr. Bray, about anything we've covered here today?
No, sir. Oh,
All right. Well, I wish you the best of luck. That'll resolve your case with us here today, okay?
Thank you.
All right, Mr. Kuza from probation will be meeting with you before you leave.
Yes, sir.
We're off the record. Take care.
Thank you.
Thank you, Judge. That concludes my business. May I be excused once I
If you
watch Mr.
insist.
Simonov's bit? So,
All right.
thank you.
Okay, then I believe we have Miss Ray coming out next. And then from there, I think we'll pause and y'all have a bunch of probation cases to talk through and that sort of thing.
Yeah, we're talking.
Yeah, so that we'd probably take up at a lunch break.
That's fine.
Oh, they didn't transport everybody? No. Okay.
We'll talk about all of them and
Yeah.
see how many orders we can
right.
send you.
All right.
This one's Ray.
Was on for a bond hearing.
It's a plea. It's a plea, Judge.
Well, I mean, but it was on.
Yes,
Not
yes,
anymore. All right. All good. We're on the record now with 26 SC 001428.
Oh, Judge, I'm sorry. If I could just have 1 second.
What do you mean?
This gotta be consecutive. We can't rock concurrent. Position firearm during.
Okay.
Yeah.
So two.
So, yeah, 2 on that consecutive probation.
Okay,
Gives us
understood. That's fine.
5 days.
And this is State versus Khadijah Ray, present in court with her counsel of record, Mr. Simonoff. Case having been recently arraigned. And State here through Ms. Foster. I understand the parties have reached a negotiated resolution in lieu of a bond hearing today. And so, Ms. Foster, if you could swear in Ms. Ray, and Ms. Ray, listen very carefully to these questions, and she's going to advise you of your rights.
Please raise your right hand. Do you swear or affirm the testimony you shall give in the matter currently before this court shall be the truth, the whole truth, and nothing but the truth?
Yes,
You
ma'am.
gotta speak it to the mic.
Yes, ma'am.
You can lower your hand.
Thank you.
Can you please state and spell your true, correct legal name?
My name is Khadijah Ray, Khadijah, last name Ray, Ray.
Are you at this time taking it under the influence of any alcohol, drugs, or medicine?
No, not at all.
How old are you and how far have you gone in school?
I'm 46 years old and have some college.
Are you able to read, write, and understand the English language?
Yes, ma'am, I am.
Do you understand that you are charged with the following offenses on the indictment? Count 1, aggravated assault. Count 2, simple battery, family violence. Count 3, possession of a firearm during commission of a felony. And count 4, possession of a firearm by a convicted felon.
Yes, I am.
Do you understand that you have the right to plead either guilty or not guilty to these charges? And if you plead not guilty or remain silent, you can have a jury trial.
I do.
Have you had enough time to speak with your lawyer about all the facts or circumstances known to you regarding the charges in this indictment, including any potential defenses?
I have.
Do you need more time to discuss the case with your attorney?
Not at all.
Are you satisfied with your attorney's services?
I'm very satisfied. Thank you.
Counsel, are you satisfied your client has a full understanding of this proceeding?
I am.
Have you reviewed the indictment in this case?
We have.
Do you waive formal reading of the indictment?
We do so waive.
Do you waive any and all defects in the indictment for the purposes of this plea?
Do so waive for the purpose of this plea.
Ms. Ray, have you been arrested on these charges?
I have.
Your Honor, the state is unaware of any outstanding warrants related to these charges. Ms. Ray, do you understand that you're entering a guilty plea to the following offenses? Aggravated assault, which carries a minimum of 1 year and a maximum of 20 years. Count 2, simple battery, family violence, which carries a maximum of 12 months. Count 3, possession of a firearm during commission, which carries a maximum of 5 years. And count 4, possession of a firearm by a convicted felon, which carries a maximum of 5 years.
I am.
Has your attorney advised you of the minimum and maximum sentence for each charge you are pleading
Yes,
to?
he has.
Do you understand this negotiated plea of guilty, which means the state will recommend to the court a sentence of 7 years probation? Your Honor, I'm going to go through the counts because we're going to split them up. Count 1 will be 5 years probation. Count 2 will be the 12 months probation, which will be concurrent. Count 3 will be possession of a firearm during commission. 2 years probation, that will be running consecutive.
I think that one does have to be 5.
Then we can switch and it can be 5 on that one and 2 on the aggravated assault.
Okay,
Yeah, but it's all correct consecutive.
so it will be 5 years probation. The count 4 will be 2 years probation. The special conditions will include no weapons or replicas of weapons, no further violent contact with the victim, Eternity Robinson, Fourth Amendment waiver, forfeit the firearm, family violence intervention course, mental health evaluation, drug and substance abuse evaluation, and complete any treatment if recommended. No drugs unless no drugs unless a valid prescription, and no further violation of the law.
Yes.
Are you aware that the court does not have to accept that recommendation and the court can sentence you to the maximum on each charge and can run those sentences consecutively or one after the other?
I am.
Do you understand that if you are placed on probation of any kind, you cannot violate any criminal laws of any governmental unit or any special conditions of probation without being subject to revocation for the balance of the sentence?
Yes, I understand.
Do you understand the general conditions of probation?
I do. Yes, ma'am.
Do you understand if you violate any laws or conditions, the court could bring you back for a revocation, which means you could spend additional time in custody?
I do.
Do you understand this is a guilty plea which is permanently recorded on your criminal history?
It's fine. Yes, ma'am.
Do you understand if you are charged with a crime in the future, this plea may be used to enhance sentencing, including on a federal case?
Yes, ma'am.
Do you understand if you're currently on probation and parole, your probation and parole may be revoked based on your entering a guilty plea today?
Yes,
Are you a United States citizen?
I am.
Do you understand that there may be other adverse or unfavorable consequences as a result of this guilty plea conviction, just as there will be from a conviction following a trial?
Yes,
Do you understand that by pleading guilty to a felony, you cannot use, receive, possess, transfer, or own a firearm, and that if you did, you could be charged with another felony offense?
I am. Yes,
Do you understand that you waive any and all defenses, including any mental health defense, by entering a plea of guilty?
yes,
Do you understand that by pleading guilty, you're giving up the following rights? I'm going to say them one at a time to make sure you understand. The right to trial by jury, the right to remain silent and not incriminate yourself, the right to see or hear the witnesses against you and to question them, the right to assistance of counsel hired by you or to court-appointed counsel if you cannot afford an attorney, the right to the presumption of innocence, which means the state must prove you are guilty of each charge beyond a reasonable doubt, the right to testify on your own behalf or remain silent, and the jury will be told they cannot use your choice against you, the right to present other evidence of your own and call your own witnesses if you choose to, and the right to appeal if convicted of these charges after a trial.
yes,
Counsel, are you satisfied your client understands these rights they'll be waiving by pleading guilty to these charges?
I am.
Ms. Ray, has anyone forced her to promise you anything to get you to enter a guilty plea today?
not at all. No, ma'am.
And is it your decision to waive these rights we just talked about and enter a guilty plea because you're in fact guilty?
Yes, ma'am.
As to indictment number 26 SC 001428, how do you plead?
Guilty.
Is this guilty plea freely and voluntarily given with full knowledge of the charges against you?
It is.
Do you understand that you do not have a right to appeal directly from your guilty plea? But if you believe that there's some error in your guilty plea, you can apply to the appropriate appellate court to request a discretionary appeal that is outlined in OCGA 5-6-35.
Yes,
Do you understand that you have only 4 years from today for a felony charge and 12 months from today for a misdemeanor charge to file a habeas corpus petition challenging the voluntariness of this guilty plea?
yes,
Your Honor, the state can't give a factual basis unless the defense stipulates.
We'll stipulate.
Your Honor, this case involves a mother and a daughter. Speaking with the daughter, in pertains to the bond motion, she did want her mother to get out. She did think this was the appropriate resolution for this case, and that a family violence intervention course is also appropriate. Nothing further from the state.
All right, and Ms. Kuzia, I believe she is on probation here in Fulton County.
no.
So
She doesn't have a hold.
a 20
I don't have probation, period.
there's a 20 SC case. Just want to double check
I
that.
think they only gave her 3 years.
Okay.
Yeah, I've done that.
All right. Okay, Mr. Simonoff.
Yes, Judge. Ms. Foster is correct. This is an incident between mother and daughter. From my understanding, Ms. Robinson does not want her mother to remain in jail. Ms. Ray, for her part, has been dealing with some serious medical issues. She's been to Grady at least once while in jail. She's got some very serious liver issues that she is anxious to get out and address. I think that Ms. Foster is correct that this should be an FVIP case, that there needs to be some kind of family reconciliation plan in place so that Ms. Ray and her daughter can find some semblance of peace and amicable relations. Ms. Ray is not eligible for first offender treatment. However, we are asking that she be given full credit for the 48 days she has served in custody for this case. Otherwise, we ask the court accept the plea as tendered and apply the sentence as proffered.
All right, thank you, counsel. And Mr. Ray, I just want to emphasize, preparing for a bond hearing today and seeing that the magistrate had previously denied bond, I just want to impress upon the point that, there's no reason whatsoever you should be having a gun. And especially when you've got prior cases, more than one, not even around one. And so that that is a real cause for concern here. So of course, I want you to mend that relationship with the daughter, but I want to emphasize again, you just stay away from any guns whatsoever.
Sir,
All right, but you understand the nature of these charges that you're entering a plea to today?
totally understand, yes.
All right, and this is a free and voluntary decision on your part.
Yes,
Mr. Simon, you're satisfied your client is competent, and that there is a sufficient factual basis?
Yes, Your Honor.
Well, I agree, and I find there's a sufficient factual basis, and that this plea of guilty is voluntarily and intelligently entered, and so I'll accept the plea. I'll sentence you, Ms. Ray, as recommended. On count 1, aggravated assault, the sentence is 2 years to serve 1 month with the balance on probation. Count 2 is 12 months to serve 1 month to run concurrent. Count 3 is 5 years probation consecutive to count 1, and count 4, 2 years serve 1 month concurrent to count 1. Special conditions: no weapons, no drugs or alcohol without a valid prescription, no violent contact with your daughter. You will be subject to a Fourth Amendment waiver. You have to complete the Family Violence Intervention Program. That's a long program, but it is important. Mental health evaluation and any recommended treatment, alcohol, drug evaluation, any treatment. You're going to forfeit that firearm. And for any technical violations like failing to report, those are handled by your probation officer with a sanctions cap of PDC or RSAT under the sentencing options system.
yes, sir.
Do you have any questions, Ms. Ray, about anything we've covered here today?
No, and I totally understand and I appreciate it.
All right. Well, I do wish you and your daughter the best, and we should have that filed today, and hopefully you'll be out before too long, and that'll resolve your case here with us. Okay.
Thank you so much.
All right. Take care, Ms. Ray.
Luck.
Yes.
All right. We're off the record. Kamisha, you can pack back up because we'll need the witness stand. We're all done.
Oh,
I don't think we'll be going back on the record for any of these revocations. You can let me know. Okay. I'd say you're probably done. Yeah.
okay.
If we need to go on the record, we'll do it Monday or Wednesday, whatever we need to do. Okay. All right. Y'all can just give me notice, give me the details when we get our lunch break. All right. He is sticking around. All right. No. Oh. All right. All right. If maybe Ms. Sue, you can maybe try to track him down, let him know we're ready for him to resume.
Yes, I've traded in the trees and the fences. Don't have to deal with those issues myself.
Yeah.
That's why I ran. Also, to the floor.
You are not poor. I heard how much y'all get TVs off. No, yeah, I'm poor. Hi. Thank you. Was I really going?
No, I.
Oh, yeah, oh, thanks.
Okay.
I'm gonna ask the attorney. I'm gonna be asking.
And I'm new, so I mean, let's.
So you already know.
Oh, yes.
Yeah.
That's not my fault.
No, yeah,
Okay.
yeah. The Georgia public division, a lot of us.
Oh, yeah, oh, yeah.
Fulton, you niggas say.
They make a.
No, yeah, that's what.
I know.
That's what I was told.
Okay, here's the picture. Excuse me.
Yeah, I'm coming back.
Okay, okay.
Yeah. We're working on it.
Okay, I need to get out of here.
Yeah. You find him?
Yeah.
Okay.
Oh, nobody told me.
I said it.
Oh, I didn't hear you. Yeah, and then he invited us back there, the invited us there. Oh, that wasn't there, thank you. Yeah, we understand. Thank you. You said it to her, we understand, thank you.
You found the tree loft. All right, well established apparently. He rules of negligence. Thank you. So yeah, you put them on notice.
So that's not this.
We'll have to dig into all that. There. Yes. All right. All right, have a good weekend. See ya.
I don't remember who had the witness on Zoom, who was going first.
That's me.
Are they still in the meeting? What's their name?
Mr. Bernhard, Gerald Bernhard.
You can tell them to get up in there.
Didn't
Yeah.
drop off.
Yeah.
Got it.
We also had
Signing on now.
Melanie Nealis
I don't see
in the
her.
afternoon,
Oh, no.
in the afternoon. I need to call her and she'll get on.
You ready? Okay, we are back on the record for our bench trial and all parties and counsel are present. Thank you for your patience. I think the plan of attack here, we'll see how far we get, but I'd say we get at least through one witness, direct and cross before we break for lunch. Brief recess, and then we'll come back and resume. Anything to announce or take up on behalf of the petitioner?
We tried for a while out there, but haven't gotten anywhere.
All right. And then in which case, petitioner can call their first witness.
Your Honor, we'd like to call Gerald Bernhard, and he's on Zoom. All right, I think Mr. Bernhard's on mute.
Nice job. Down there, I guess. There they are.
You just,
Can you?
all right, Mr. Bernhard, if you could, I think on your end, there might be a button on your screen to unmute yourself.
Okay,
There you are. Can you
Yeah.
hear us all right, sir?
yes, sir.
All right, we're gonna, we have the deputy here who's gonna swear you in.
Raise
Okay,
your right hand for me. Raise your right hand.
that's right.
Do you swear affirm to the testimony matter of this case you should give is the truth and nothing but the truth to help you?
Yes,
All right.
I do.
You can lower your hand. Would you please state and spell your name for the court?
Gerald Bernard, Gerald Bernhard.
All right, good morning, Mr. Bernard. Can you hear me okay?
Yes,
All right. We've previously met or talked over the phone. My name's David Klein. I represent the petitioner, Miss Martin, in this case, and just have a couple questions for you this morning.
all right.
How long have you been a licensed land surveyor in Georgia?
I've been licensed since 1996, and I've been surveying since 1978.
Do you hold any other certifications other than your license?
I also am licensed to do hydrology.
Can you briefly describe your education and training in land surveying?
Yes, I took courses in land surveying, and I also have been experienced for 48 years.
And approximately how many boundary surveys have you taken during the course of your career?
I'd say 10 to 15,000.
Have you been previously qualified as an expert witness in Georgia courts?
Yes, I have.
All right. And Mr. Bernard, how are you being compensated for today's testimony?
I'm being compensated for drive time, which I'm not driving, but also $150 an hour for testimony.
And is the opinion that you're going to offer today in any way contingent on the outcome of this case or how you're being paid?
No.
All right. Your Honor, I move to qualify Mr. Bernard as an expert in land surveying.
Any objection?
No objection.
You can proceed.
Mr. Bernard, you were retained by Ms. Martin to survey the property at 920 Wendover Drive, Northeast in Atlanta. Is that correct?
Yes.
As part of your work, did you review the deed for the property at 920 Wendover Ave?
Yes, I did.
Does the legal description in Ms. Martin's deed match the boundary lines shown on your survey that we'll get to in just a second?
Yes, they do.
When did you first perform a survey of this property?
I believe it was April of 2024.
Would it have been in February of 2024?
It could have been.
Sometime in 2024?
Yes, that is correct.
All right. What is the standard methodology, just generally, that you use to establish a boundary line when it comes to residential surveys? What are you looking for? Uh-oh. You might have frozen. Oh.
I'm sorry.
Can you hear me?
Okay, I'm sorry. Yeah.
Okay. Can you just take me through your methodology in performing a boundary line survey? What are you looking for?
We're looking for the property corners, where the street's at, any fence lines that, might be close to where they're at. And once we find at least 2 pins and the road located correctly, then I calculate where the pin should be that I didn't find. And then I go back out, which I went out with the crew. I go back out and stake out where they're at. And then I found an open top pin where I'd calculate where one went, and it hit perfect. And so we staked out where the other ones were at, and there were no pins there, and we set them.
All right. So the first time you went out to the property, you couldn't locate a pin. Is that right?
Yes, that is correct.
Do you remember which pin that was?
I believe it was on the east side of the property in the rear, the open top pin.
Was that located behind a fence?
Yes.
Okay. And so eventually you had to come out and do another survey or updated survey of the property. Okay.
That is correct.
All right. Despite being unable to access that pin during the original 2024 survey, were you able to still determine what the boundary line was between the two properties?
Yes, sir.
How were you able to do that without having access to that pin in the eastern side of the property?
I calculated up from the road and the pin I found and calculated where it went. And before, I would set any pins, I stake them out to where I've calculated to see if they're there. And I found that one particular.
And I think you testified it's common in your profession to establish a boundary line even when a pin is inaccessible or missing?
That's correct.
All right. Based on the 2024 survey, so the first time that you went out to the property, what did you determine regarding the fence? Was it over the property line, on the property line, behind the property line?
It was over the property line.
Okay. And so it encroached on Miss Martin's property, is that correct?
Your Honor,
That is correct.
As witness, I object.
All right. In the interest of time, I'll overrule the objection.
Were there any other items besides the fence that you observed over the property line?
No.
Okay. In your professional opinion, was the 2024 version of the survey reliable and complete enough to establish the boundary line even without access to that one pin?
That is correct.
Okay. I'm going to show you, I'm going to pull this up on the screen.
Okay.
I have, I need to be enabled, sorry. Thanks. Okay. Can you see this document, Mr. Barnard?
Yes.
Okay. This is exhibit P1. It's actually attached to a letter that I sent, but I'm just going to focus on the survey. Is this the original version of the survey from 2024?
Yes, it is.
All right. And then I'm going to pull up what's exhibit P3. Is this the updated version of that survey?
Yes, it is.
All right. And is there any difference between these two surveys?
They could be a slight difference in our profession. That anything that's within 800ths or less, we hold it and put down what the deed is.
And
So
on
it could be less than a tenth off, but not
That'd be a-
anything more.
that'd be a tenth of an inch.
Tenth of a foot,
Okay.
and that's
In the
professional standards for land surveyors.
okay. And between the two surveys, the fence was still encroaching. Is that correct?
That is correct.
And were there other encroachments as well that were still encroaching?
Not that I can see. No.
Based on your two surveys, how far over the property line was the fence? Can you give me some kind of estimate on that?
It's approximately a foot to a foot and a half.
Okay.
In some areas, as you see, it bends out and then comes back in.
And approximately how long was the fence from top to bottom?
I would say it was about 110 feet.
Mr. Bernard, as part of your company's work on this property, was the boundary line physically staked or marked?
It was marked.
Let me pull up another exhibit here for you. Okay, can you see this exhibit, which is marked as P5?
Yes.
All right. Is this one of your stakes here?
I don't see it.
Let me zoom in a little bit more.
Okay. Yes.
Okay, that would be one of the stakes that your company placed?
Yeah. Yes.
All right.
On the property line.
And those stakes would have been placed at the initial survey date in 2024, is that correct?
That's correct.
Would you say that the boundary line here was clearly and accurately marked?
Yes.
Was this stake visible to someone standing in the backyard of either property?
Yes.
Mr. Bernard, in your professional opinion, is there any ambiguity about where the boundary line falls between these two properties?
No, sir.
And both your 2024 survey and then the 2025 survey with the updated pin position, they reached the same conclusion about that boundary line. Is that correct?
That's correct.
Mr. Bernard, in your professional opinion, before a homeowner builds a fence on or near a property line, should they obtain a survey?
Yes.
Why is
They
that?
should have their property line staked to make sure the fence is on their property.
And before placing this stake on during your 2024 field site visit, you didn't see any other stakes or markings about the boundary line, correct?
No,
What about before doing grading work near a property line? Should a homeowner get a survey?
yes,
And what about for installing artificial turf? Is it your professional opinion that they should get a survey?
yes.
All right. Thank you, Your Honor. No further questions.
Let me ask one before we get to cross. I just, sir, if you could look at P3 again, I want to make sure I am understanding this diagram right.
I'm just going to pull this up, Your Honor.
Okay. And if you could perhaps zoom in on the plot itself.
All right, sir.
All right, so just I want to make sure. So like the dotted line, you know what? I forget my shapes, but maybe a rhomboid of some kind. That would be
Yes.
the house.
That would be the dotted line is the setback lines.
Or it says BSL.
Yes. Like
what is that?
back set line, side set line. It's building set line.
Okay. And so that's the structure.
Yes.
Okay.
Well,
and
it's
then
not the structure. It's where you can put the structure in.
I understand. Okay, thank you. And then the
Uh-huh.
next dotted line closest to that, if I go from to the right of the page, is that the fence line as you surveyed it?
Yes.
And then the solid line is the actual boundary line that you surveyed. Is that accurate?
That is correct.
All right. And so the encroachment that you were focused on where you couldn't locate the pin originally, that's on the right side of this diagram?
Yes.
And that fence then travels all the way around and actually goes into the other neighbor's yard on the left side of the house?
That is correct.
All right. And cross, or if you want to follow up on any of those points.
Thank you, Your Honor. I'm gonna put up another survey. It's the same one, but it's highlighted.
All right, sir.
Now, Mr. Bernard, we've never met before, right?
No, sir.
My name is Alan Miller and I represent the Thomases, the defendants here. I just had a couple questions about your survey. As the judge just pointed out, this line at the bottom of what was the fence is showing a little line that goes perpendicular to the fence. Do you see that?
Yes.
Do you know who owned that fence? Sir, did you hear me?
I'm looking at it right now. It looks like it would be the person that we did the survey for.
Okay. And that fence came out and connected with the fence that was determined to be the Thomas's fence, right?
Which one is the Thomas's fence? I know
The fence
the
that's-
Martin's to the left, is that correct? And then the Thomas is the one we surveyed for?
No, you surveyed for the Martins
Okay,
and
Okay.
their house is in the pink
yes,
lined area. And then it shows at the bottom on the right side, it shows a connecting fence that
yes,
you've identified as Miss Martin's fence.
that
And
is
then it
correct.
connected to the fence that's indicated on your diagram as the Thomas's fence, right? Do you see that?
I see it as being the Martin's fence going down. and over to the connecting together. I don't see it connecting to any other fence line.
Okay, well, if you follow that little perpendicular line towards the middle.
Yes. Yes.
Connects with the, what's indicated as a fence there. And it's your
Yes.
understanding that that was the Martin's fence?
Yes.
Okay, and that goes around, just like the judge said, it goes around to the other side, and it actually shows a fence over the boundary line on the other side of Miss Martin's property, correct?
It shows a encroachment on the western side of the property.
Okay, so do you have an understanding as to where the Thomases are in relation to
No.
this survey?
No, I don't.
Okay. Well, getting back to this fence, it shows an encroachment by Miss Martin's fence on the property to the left of Miss Martin, right?
Yes.
Okay. And you were actually retained on February 21st, according to an affidavit that you gave in this case on November 17th of 2025. Do you remember giving that affidavit?
Yes, I do.
Okay. In the second paragraph, or not second paragraph, but the second paragraph on the second page, it states that on or around February 21st, 2024, I visited the Martin property to perform a survey, correct?
Correct.
So you were actually out there on February 21st of 2024. Do you know in the initial conversation why it was that Miss Martin wanted you to survey the property in the first place?
No, I didn't take the survey order. I just performed the surveys.
So did you talk to Miss Martin about being retained to do the survey then in
No.
February of 2024?
No. That
Okay,
goes
so-
through the office.
Okay. So you don't know why she wanted you to go out and do a survey then?
No, sir.
Okay. And your first visit in February 21st, 2024, did you meet with an attorney there by the name of King Buttermore?
No.
You don't remember meeting with him?
No, I did not meet. I don't actually perform the actual surveys. The survey crew does. I go out and look at the property. I just visit it to see when they're doing it, how to reproduce it. And I tell them, then I leave. I just supervise, that's all.
So was it some guy by the name of Nate that actually did the survey?
That is correct.
So you didn't actually do the survey?
No, I supervise the surveys. Actual registered land surveyors hardly ever go out and survey property. They
Okay.
have field crews that go out and do the work. And then we supervise the field crews work and agree with it or not agree with it.
Well, in paragraph 9 of that same affidavit, you indicate that at this visit to the Martin property, which was February 21st, 2024, you were unable to access a pen located in the northeastern corner part of the
That is-
Martin property, which is
that is
indicated as
correct.
CP on the original survey, right?
That's correct.
And that same pen on this page is indicated as OTP in that right corner. Is that correct?
That is correct. That is correct.
And you couldn't access that pen, so your survey, when you agreed to with me that the survey as of February 21st or 23rd of 2024 was incomplete?
Well, actually what I did is I went back out there and had the survey crew stake it out to set the pin, but I found the pin then and it was within the tolerance of acceptable survey standards.
Well, you were unable, is that true? You were unable to access the pen at this first initial visit? Is
I
that true or
didn't
not?
find it. I didn't find it.
Okay. And then you were engaged again, more than a year later, according to your affidavit, on about October 1st, I was engaged again by Ms. Martin to update the original survey. So
That's correct.
would you agree with me that at least from February 21st of 2024 until October 1st of 2025, your survey was incomplete because you could not access that pen?
No, I wouldn't say it incomplete. I calculated in where it went And with the business the way it is, sometimes it takes a while before we go back out and set pins.
Well, the survey was incomplete because you couldn't access the pin, right?
I couldn't find it. I
Okay.
could access the area it was at, but I didn't find it.
Wasn't it true that the pin was actually under a portion of the fence in that corner?
Not on the eastern side.
Well, I'm talking about the location of the OTP on this diagram on the
That is
survey.
correct. It wasn't under a fence or near, as you can see on the survey, you see the fence is well inside the property.
And was that October 1st, the first time that you were contacted about coming out and actually getting access to that pin?
Yes,
You weren't contacted in February of 25 that you had full access to the pin, that you could go out there and do it at that point in time?
yes,
Now I'm talking about back in February of 25.
I know. I
Were you
didn't
contacted
find
then?
it. That's what I'm telling you is I didn't find it at that time. My survey crew didn't find it. I sent the survey crew back out at a later date, which was a year later or not quite a year later, and they found that pin. And
Didn't
it
they
was
have
in
to-
the area that I calculated off the first survey, same area within tolerance.
Well, you'd agree with me that the survey was not complete until you actually were able to access that pin, wouldn't you?
No, I wouldn't say that. I said
Why
it was
not?
complete. I would say it was complete. The just pin that I'd calculated hadn't been set yet. But the survey was complete. It was good. There was no problem with it.
Now, when I asked you that question, I meant February of 25, not February of 24. And I think you misheard me there. Did anyone contact you in January, February of 25 and inform you that you had full access to that pin?
Not that I know of, no.
So no one contacted you until October of 25 and gave you access to that pin because it was underneath the fence, and the fence,
No, it
portions of the
wasn't
fence,
underneath the fence.
Wait till I finish the question. And you had to actually take some of the fence away, take it down in order to access that survey pin, which is located in that upper right corner, correct?
No. The fence, as you see where it's dotted line, is inside the property. The pin is outside the property. I mean, outside the fence line. It wasn't under the fence or anything.
So you're saying that the fence did not need to be removed or taken down in order to get to that survey pin?
Not that I know of, no.
All right. Now, the boundary line that you marked, that you say was marked in the front with that wooden post that's placed in P5, I believe it was, right?
I'm not sure what picture it was, but it was placed. Stakes were placed where the pins were set and also stakes on the property line. And you could see from one pin down to the stake and from that stake to the front pin.
Right. But the stake, the wooden post that you saw in P5
Yes,
was right next to the corner of the fence, right?
yes,
And then you had the survey pin in the back, which was close to a chain link fence, right?
that is correct.
And those were the only two markers that marked that boundary line, correct?
I can't remember.
Well, there were
It's
no
been well, I
flags.
can't remember, but all
There were
I
no-
know is you could see from one pin to the stake and from the stake to the front pin.
I understand that.
You
But those two
yeah,
markers, go ahead.
those markers, I put it there so you could see where the fence was.
My question is
There.
simply, those were the only two markers on that boundary line, correct?
Rear pin, that stake, and the front pin. That's correct.
There was nothing in the middle between the wooden stake and the survey pin in the back, was there?
No.
Thank you.
Can you redirect?
Just briefly. Do you mind taking that down? Thank you. All right, Mr. Bernard, David Klein again. Just a couple follow-up questions. You understood that the 920 Wendover property was located to the west of the 930 Wendover property, is that correct?
That's correct.
Okay. And there were also some questions about whether the 2024 survey was complete. You previously testified that you can complete a survey even with a missing pin. Is that correct?
That is correct.
Leading as a witness again, Your Honor, we'd object.
All right. Again, it's going to depend on the context and the subject matter. And in this particular situation, I'll allow it. So it's overruled.
Did anything change between the two surveys?
Yes. We set the pins on that sideline and put a stake on the property line.
Okay. Did the property line change in any way that you're aware of?
No.
And the February 2024 survey and the October 2025 updated survey, those were both certified by you?
That is correct.
Okay. Do you remember anything about an access agreement?
No.
Okay. No further questions, Your Honor. Thank you.
Can you recross on those points?
So, Mr. Bernard, you have no knowledge of any access agreement that was entered into in July of 2025?
No.
And did anybody ever mention anything to you about an access agreement that was available as early as February of 25?
No.
Actually, Your Honor, facts, not evidence.
No further questions, Your Honor.
Overruled. All right. Can Mr. Klein be excused? Excuse me. Can Mr. Barner be excused?
Yes, he can be.
All right, sir. Thank you for your time. You can log off.
All right, sir. Thank you.
All right. Why don't we just at least get started with the next witness, Mr. Klein?
We'd like to call Bianca Martin to the stand.
This case, you should give nothing to help you.
Yes.
While speaking, moving to the mic with the state, spell your name for the court.
Brianca Martin, BRIANCA MARTIN.
All right. Good morning, Miss Martin.
Morning.
What is your current address?
920 Wendover Drive Northeast, Atlanta, Georgia, 30319.
When did you purchase that property?
April 21st, 2023.
What is the property next door to yours?
930 Wendover Drive Northeast.
And is that located what direction?
Am I right? If you're facing the property, so I think that's east.
Who owns that property?
Brandy and Cedric Thomas.
After you moved in the property in 2023, can you tell me about any projects you had with the backyard of your property?
Yes, I was landscaping, just doing general beautification of the backyard.
Can you give me a couple more details about that? Like what beautification were you putting in? What retaining walls, things like that?
Yes, I plan to put in retaining walls, level out some of the property. Yes.
Okay. Obviously, this case is about a fence. So can you tell me when you first became concerned with your neighbor's fence?
Sure. During one of my landscaper's visits, the landscaper asked me about the fence to the right of my property and whether or not it was my my fence. And I said no. And I didn't think so because I had again just bought the home, but from my understanding of the conversation I had with him, the posts of the fence were facing the wrong way. And so he questioned me as to whether or not it was my fence or it belonged to my neighbor.
What did you do after that concern was raised?
I reached out to Survey Systems of Atlanta to perform a survey on my property.
And that survey was Mr. Bernard that we just heard from?
Yes, correct.
And when was that? What year, what month?
That was 2024,
Do you remember the month?
maybe February or April.
And once you had that survey completed, what did it show?
It showed that the fence to the right was on my property line, was on my side of the property.
Were there any other items besides the fence that were on your property?
Yes, artificial turf, a second fence, as well as some shrubbery.
All right, I'm going to pull up exhibits P4 and P5, which are already in evidence. And actually, I'll start with P5. All right, can you see that photograph okay?
Yes.
All right, can you explain what is being shown here? For instance, what side is your property? Where's your house located, et cetera?
My property is located to the left of the stake with the pink flag. The Thomas's property is to the right. And in the photo, I could see that the fence is to the left of the property line.
Do you know when this photograph was taken?
April of 2024.
Did you take this photograph?
No,
Who took this photograph?
the survey company.
And that stake that you can see there, who placed that?
Survey Systems of Atlanta.
Were there other stakes that were placed by the surveying company?
Yes.
Where at?
There was one that was placed between the one picture here and the street. And then they placed stakes to the left and the rear of my property as well.
All right. After you received the results of the survey, what did you do next?
I contacted an attorney.
Okay. Why did you feel like you had to contact an attorney?
The previous conversation I had with Mrs. Thomas, it was a text exchange. It was in reference to the tree, but she was citing regulations and using legal language. And at that point, I just felt uncomfortable having that conversation.
When did you have that text exchange with Ms. Thomas?
February of 2024.
All right. So this is all happening around the same time period?
Yes, correct.
All right. And you retained my law firm to send a letter, is that correct?
Correct.
This is exhibit P1. Is this a copy of that letter?
Yes.
All right. And what were you trying to accomplish through this letter?
My goal was to just establish dialogue so that we could have a legal shared understanding of what the true property line was.
And as part of this letter, it included a copy of the survey that you had performed. Is that correct?
Yes, that's correct.
Okay. Did the respondents ever remove the fence and other encroaching items after they received this letter?
No.
Was a second letter sent in response to the Thomases?
Yes.
All right. Do you remember when that was sent?
I believe June of 2024.
I'm going to pull up exhibit P9. Is that a copy of that letter?
Yes.
All right. And what were you trying to accomplish in connection with this letter?
Again, shared understanding of where the property line was so that we could work toward a solution. Um,
After the second letter, were the encroachments removed from your property?
no,
When were the encroachments removed from your property?
the last of the encroachments was removed yesterday,
And what was that?
artificial turf,
And who removed that?
the defendants,
Do you know when the fence was removed?
I believe January 31st of this year.
And what about,
30th, late January,
and what about the bushes and other encroachments?
late January as well.
All right, and this lawsuit was filed in September or October of 2024, is that correct?
That's correct.
Why did you feel like you had to file the lawsuit?
Well, the defendants had not responded to the letters that we sent, both letters, or offered access to come to a shared understanding of where the property line was at the rear of their property.
Were these encroachments causing any issues with the renovations to the landscaping that you wanted to perform in your backyard?
Yes.
How so?
Well, the design that I had come up with my landscaper required certain clearances. And it was a large project. And so I wanted to be able to do all of the work at one time versus having the people come out on separate occasions to do one part of the yard and then the second part of the yard once the boundary line was determined.
And to date, have you been able to complete those renovations to your backyard?
No.
Will you be able to complete it now that the encroachments have been removed?
Yes.
At some point, are you aware of any, no, strike that. Are you aware of any code compliance officers or anybody that has come out to your property?
Yes.
Can you tell me about that?
I discovered a report that was written by the city of Atlanta. In the report, it noted that a neighbor had called and reported a improper tree removal on my property. The report specifically said that that was her second request, and there was no violation found. Also in their report, the person noted that there appeared to be unpermitted turf and grading in the rear of the Thomas's property.
I'm going to pull up what's been marked as P13, which has been admitted. Is this a copy of that report that you found?
Yes, that's correct.
All right, and you can see here it says no violation found. Is that right?
Correct.
All right. You never had any conversations with Mr. Bedson?
No.
Okay. All right, what, your property, Miss Martin, what is the total lot size?
Maybe less than half acre, 0.45, I believe.
And I'm going to pull up Exhibit P15, which has been admitted. Is this a copy of the Fulton County Assessor's website related to your property?
Yes.
All right. And it lists the primary site as 19,788 feet or about 0.4543 acres. Is that right?
Correct.
All right. How much in terms of feet was the fence and the landscape encroaching on your property?
The distance varied from the top of the fence, which is where the stake was, to the back of the yard. So it could have been 2 to 3 feet at the top, my estimation, and maybe 1.5 feet at the back. So it was not a straight line from the street. It was diagonal, if you will.
What would you estimate the total percentage of your property that was affected by the encroachments?
Maybe 5%.
And the period of time that you were not able to use your property because of the fence, how long was that approximately?
2 years to the dates.
And if we can look again at Exhibit P15, I want to scroll down to the valuation portion of this that's listed on Fulton County. You can see that they have it from, the building value versus the land value. Can you tell me what the land value was between 2023 and 2025?
448,000 in 2023, 400,000 in 2024, and 400,000 in 2025.
Have you appealed any of those assessments?
Yes,
Okay. Is that possibly why it went down in 2024 and
Yes.
2025?
yes, correct.
Objection, Your Honor. I don't know that this witness is competent to testify to tax assessors having anything. She's not a licensed appraiser. So I'm going to object on that basis.
All right.
Can I respond to that?
Yeah, Mr. Klein.
So this is a document that's already been admitted. I'm just asking her to read from it.
Okay. And and the purpose is you're trying to establish the value of the home here?
The value of the land that was affected.
Okay. All right. Well, I'll just note, I think to the extent I don't know if she'd be qualified to say exactly the precise reason it went down or varied or up and down. But I think she's just summarizing the exhibit that has been admitted. So with that, you can continue.
All right. Thank you. All right, Ms. Martin, did you incur any costs associated with the survey?
Yes.
How much were those?
In addition to the original survey, I spent $900 for 2 separate occasions for the surveyor to come out.
And then you're also paying Mr. Barnard $150 per hour for his testimony?
Correct.
All right. And Exhibit P10, is this a copy of a receipt?
Yes, correct.
And this is paid to Survey Systems?
Correct.
What other damage, or excuse me, what other out-of-pocket costs have you incurred?
I had to pay to have the fence company remove the boards from the defendant's fence.
And who did you pay for that?
I don't recall the name of the company.
All right, I'm going to pull up.
Works, maybe? I could have that wrong.
I'm going to pull up Exhibit P16, which has been admitted. Is this a copy of that receipt? Is that a copy of the receipt?
Yes, sir.
Oh, I'm sorry.
Yes.
Thank you. All right, I want to get to the counterclaim that's been filed. Are you aware of a counterclaim?
I don't understand what this expense is for.
This is, sorry, can you explain to the court what this expense is for?
The surveyor company had to remove boards to access or to be able to set the pin in the north back corner of the Thomas's property, and I had to pay for them to do that and put them back.
And that was in, that was during 2025 when the survey company came out there again?
Correct.
Okay. Your Honor, I am going to get into the counterclaim issue. I don't know if this is a good stopping break. I can keep going, obviously, but.
Well, let me follow up on that one more time. So was it the surveyor that told you that you would have to replace the boards that are getting removed just in this one section of the fence to place the pin, or is that something that your neighbors asked?
The survey company.
Okay.
I believe, I'm not 100% sure. David, you can. I'm not sure.
And so you paid to remove and replace a fence that you thought would just be removed entirely at some point if you
To
wanted this?
locate the pin, yes.
Okay.
To complete
Uh,
the survey, yes.
why don't we keep going for a little bit?
Sure. Ms. Martin, are you aware of a counterclaim that's been filed in this case?
Yes.
And what's your understanding of that counterclaim?
Currently, that I should trim branches that overhang my neighbor's property.
And that's a tree that's located on your property?
Correct.
What kind of tree is it?
I don't recall.
Has that tree ever been inspected?
Yes.
All right, when?
Most recently, the Thomases had the tree inspected in, I forget the date, but this year, March of this year.
I'm going to pull up what is Respondent's Exhibit L, which has been admitted. Have you seen this document before?
Yes.
And what is it?
The tree inspection report from the actual inspection that they commissioned.
And what was your understanding of what this report concluded?
That the tree was healthy, it should be maintained, but there were some branches that should be pruned back.
How would somebody access the branches to be trimmed that needed to be pruned? How would you access it?
My understanding is from the Thomas's driveway.
If they needed access to your property, would you be willing to allow that?
Certainly, but my understanding is that it could be trimmed solely from their side.
Right. And where do you get that understanding from?
The arborist.
All right, and you actually obtained a proposal yourself to get the tree branches trimmed, is that correct?
Correct.
All right, I'm going to pull up what's Respondent's Exhibit N. Is this that proposal?
Yes,
Why did you obtain that proposal?
because I wanted to know first if the tree was okay or not, and if it was not, what if anything should be done to the tree?
Okay. And this statement right here, that job assumes permission granted from neighbor to access driveway to set up large rotten branch as a hazard to people and property. What neighbor is this person referring to in this report?
The Thomases.
And so is that how you got your understanding it could be accessed by their driveway?
Correct.
Are you aware of any attempts that they've made to just cut the tree branches?
No,
Would you have any issue with them pruning the tree branches?
no.
All right, Ms. Martin, did you want to bring this lawsuit?
Most certainly not.
And why did you feel like you had to bring the lawsuit?
The Thomases were not, in my opinion, cooperative with in response to the letters that we sent, 2 letters that spanned a period of 6 months.
And you are aware of the responses that the Thomases did send back to us, correct?
Yes.
Can you give the court an idea of what those responses said?
I believe the first one questioned things like, what is an iron pin? I don't recall the specifics, but it was just basic questions about what a survey is, why we needed it, et cetera.
All right, and did we respond to that?
Yes.
All right. And are you aware of any other survey being completed on your property or the Thomas's property?
No.
Can you just generally tell me how these encroachments have affected the way that you use your backyard and your own property?
Sure. Well, I have son, who's now 7, who has been, first of all, asking me for a dog. I didn't feel comfortable with the dog in the backyard because I have a slight pitch, and so I wanted, again, to do a fence in the front yard, which I could not necessarily do because of this gap in the Thomas's fence in my property line, in the property line. I think secondly, I again wanted to fix up the backyard, do a retaining wall in preparation for an event that I'm hosting actually this summer, and I have not been able to do that.
All right. How has this entire situation, the litigation, everything pre-litigation, how has that affected you?
It's awful. It's unfortunate. I think that we shouldn't be here.
I have no further questions, Your Honor.
All right. Mr. Miller, how much time would you anticipate for cross?
Excuse me?
How much time would you anticipate needing for cross?
I don't expect more than like 45 minutes.
Okay. All right. I mean, I guess, any preference on going now or coming back?
Whatever the court desires.
Anyone?
I mean, I always like keep going for honorable,
Okay.
but
All right, that's fine. We can have a later lunch. Why don't we transition over to cross?
You pop up. There's.
Let me just.
I'm gonna hand her package.
oh, sure, sure.
I'll have it. Yeah. Miss Martin, I'm gonna hand you a packet of our exhibits. Might need to refer to those. I don't have all those in PowerPoint. Good afternoon.
Good afternoon.
It's the first time I've met you, I believe, isn't it?
In person, yes.
It's good to meet you, finally. I want to talk about the purchase of the house at 920 Wendover Drive back in April of 23, was it?
Yes, correct.
Now, first of all, when you purchased the house, you certainly visited before you went there to purchase it, right?
Yes,
And you saw this wooden fence that was on the right side of the backyard?
I saw a fence, yes.
You saw the fence sitting there, and did you assume that it was the Thomas's fence? Or did you know who owned that fence at the time that you bought the house?
Can you clarify which fence you're referring to again, please?
Excuse me?
The fence on the left or the right? I just want to make sure. I understand.
The subject fence, the fence that's shown in this picture, which we've marked as Defendant's Exhibit O. That fence right there on the right side of your house, if you're facing your house from the street, that was the fence that you saw certainly when you visited the property, right?
Just to clarify, yes, there was a fence line that I saw, yes.
And you saw this fence when you were there before you bought the property and you noticed the fence. Did you inquire as to who owned that fence?
No,
Why not?
I just did not.
But you were fully aware that there was a fence there, right?
Yes, correct.
And and you purchased the house knowing that fence was there, correct?
Correct.
And then you added this connecting fence, which is much newer than the older fence. Do you see that in Exhibit O?
I see the fence, but I did not add it. It was already there when I purchased the property. It
The
was
wooden
connected.
fence
Yes,
that was connecting to this old fence,
yes,
you didn't add that?
no,
That was already there before you ever purchased the property?
correct.
Okay. Now, could you go to the next exhibit, Q? Well, for.
Okay, gotcha.
And this picture. Okay. Okay, you see Q?
Yes,
And that picture was the way this land looked that was up against the fence back in November of 2025, correct?
that's correct,
Excuse me?
correct.
Correct. And for the time period between the date that you bought the property in April of 2023 and February of 2024, when you had your survey done on February 21st, you were certainly okay with the fact that you had a enclosed backyard with a privacy fence basically all around the perimeter of the property between you and the Thomases, right?
Was I okay with it?
Was that you took benefit from that, the fact that you had an enclosed private backyard for your son, right?
No,
Why not?
I didn't get a benefit from this, from having their fence. Maybe I misunderstood your question.
So let's go back to O just for a second, please. Your testimony is that fence, the newer fence, was actually already on the property when you bought the property.
Correct,
And you knew that fence was there when you bought the property, right?
Right.
And you had a fully enclosed backyard at that point in time when you bought the property,
correct,
and that's your testimony.
correct.
Now, didn't you drive a benefit? How old is your son?
He's now 7.
He's now 7?
Yes,
Didn't you derive a benefit from having a fully enclosed private backyard due to these two fences that are shown in Exhibit O for at least the year of time before you had this survey done?
I'm not aware of what the benefit is, sorry.
You didn't feel like you had a fully enclosed private backyard that wasn't any benefit to you?
I don't know.
Now, could you show M1 through 8, please? You knew that there was an inspection done back in early March of the tree, right?
Correct,
And you have video cameras on the side of your house that probably taped the entire inspection, right?
I have cameras. Did they tape it? No,
But you have cameras on that side of the house, don't you?
I do, yes.
In fact, your P9, I think it's P9, is a invoice from ADT. I'll get back to that in a second, but there is an invoice in your plaintiff's exhibits for an ADT bill for like $3,000.
Yes,
And are you claiming that in this case?
I have not determined that with my attorney yet.
But it's one of your exhibits.
Correct,
We're putting up those video cameras?
yes.
You're expecting the Thomases to pay for those video cameras that you put up on the soffit facing their driveway?
We have not,
Overall,
we have not determined that that's a request, no.
Okay. So looking at M1, could you bring that up?
M1?
Yes, please.
I can't, I don't know how to make, oh, wait.
On the side, basically.
Is that good?
That's good.
Okay.
Now that is a picture of the tree, the subject tree, is it not?
Yes,
And that is a picture taken, as you can see, the inspector's there doing the work. And that is the way the property actually looked back in early March of this year, correct?
correct.
And that tree is hanging over the Thomas's property house, isn't it?
Correct.
And you would certainly agree with me that that tree is a danger to their home and to their property and to the people that live there, right?
No,
You wouldn't agree with that?
I agree that the limb poses a danger, correct, not the tree itself.
Okay, I stand corrected. The limbs at the top, which are
Correct.
dead, according to the report that you just pointed to, those are a danger to the property, to the home, and to the Thomas's family. You'd agree with that, right?
Yes,
Now going on to the M2.
Go back. My apologies, 1 second. And 2. Okay, I'm going to
Sure.
share again. Thank you right now.
There it is. You get rid of that. Oh, okay. So M2 is another picture of the property, right?
yes,
This is that strip. That's your top tier that's right next to what was the wall, correct?
the fence, yes.
What's that?
The fence,
That strip of, that swath of land is right next to where the fence was,
Correct.
correct?
correct,
And that's basically the condition that land has been in since day one until about 30 days ago when you covered it with mulch, right?
no, that's not correct.
Well, that's a picture from March 3rd, isn't it?
It is,
Okay. Can you go to M3? You see that? Do you see this in the bottom left corner? A piece of glass there
um,
in that picture?
no,
Go to the next picture, please. M4. Do you see the can in M4?
I see something. If you say it's a can, I believe you.
And there was broken glass and cans in that area? I mean, that's the swath of land that we're talking about?
Yes, the one I wanted to develop.
And that's the condition of it back on March 3rd of this year, correct?
Correct.
Now, the fence encroached by about 1.5 feet in the back and maybe 3 feet, 2 to 3 feet in the front. Is that correct?
That sounds correct, yes.
So what prevented you from developing the other 14 or 15 feet of that property?
Well, the project is a large project and requires heavy equipment, permits, et cetera. And so my preference was to do all of the work at one time versus having to come back out and then readjust potentially after the line was clarified.
And you're talking about that estimate that you got to build that tiered structure?
That is part of it, correct?
And that estimate wasn't obtained until August of 2025, wasn't it?
That's correct.
So that estimate was obtained after this lawsuit was filed in October of 24.
Correct.
Why wouldn't you get an estimate if you wanted to do something with that property or with that land well before the filing of this lawsuit?
Well, I did. This is one of the estimates that I received.
Well, the only estimate that's in evidence right now is the one that you got in August of 2025,
Because
correct?
that is the one I decided to go with, yes.
And you got that estimate, right?
Correct, yes.
Now, we can go through that survey, but you were here. You saw how your fence actually on the left side of your property encroaches on your next door neighbor on the left side, correct?
I heard Mr. Bernard say that, yes.
Okay. And you knew that.
I did not.
You did
know
not
that.
ever look at the survey that your attorney talked about so much with Mr. Bernard?
I did, but I did not know to that extent.
You didn't realize that your chain link fence on the other side actually encroaches on your next door neighbor on the left side of your property?
Oh, yes, I did realize that, yes.
Okay. And you haven't ever done anything about it, have you?
I've
That
had
chain
a
link fence is still
conversation
there.
with my neighbor about it. That so far, yes.
Now let's go to Exhibit F. That's the text message. Now looking at the first page of that exhibit, Exhibit F, are you there?
Yes,
You guys are sorority sisters, right?
that's correct.
And you invited Brandy to some party of some sort in January of 24,
Yes,
and she couldn't go, but she explained why she couldn't make it to that party.
yes.
So you guys have been sorority sisters for how long?
I'm not sure. We probably are initiated at different times.
Excuse me?
We probably joined the sorority at different times, so I don't know the answer to that.
Didn't Brandy bring you a housewarming gift
Yes, she did.
when you moved in?
I received a flower, yes.
And did you feel like you had a good relationship with her at that point in time?
Yes,
Now let's look at the second page. And you certainly agree that the tree branches posed a serious danger to Brandy and Cedric's home and their family, right?
can you repeat the question, please?
You already certainly agreed that the tree branches, maybe not the tree, but the tree branches were what was falling on their roof, on their driveway, on their entrance to their home. And you certainly would agree with me that that is a danger to their family and to their home, right?
I agree that the branches could pose a danger. I do not know that my tree caused damages to their roof.
Well, you certainly read the text and you received it on February 4th of 2024, right?
Correct.
And that first page says that, I hate to hit you with this, but I'm wondering if the people who sold you the home talked to you about the dead tree that overhangs between our driveways. The reason I bring it up is that for the time we have lived in our house, 5 years now, that tree has dropped dead limbs on our house and driveway and damaged our roof, cars, and other parts of our house. Did you believe that, or did you just think that was a lie?
I did not know,
Didn't you feel like that was a valid concern that Brandy had?
certainly.
The history of trees in this area is pretty brutal. The house that was on our property before ours was built was literally cut in two by a fallen tree. Because of our concerns for further damage with that tree, we sent a certified letter to the previous owners after we had appraisal done of the trees in our property and the surrounding trees. I mean, did you find any reason not to believe any of this?
At the time, again, because of the legal language that was used, citing code references, et cetera, that is not my area of expertise, so I did not know what to make of what has been said. All I know I've seen is stories on the news about trees falling and what, is supposed to happen or who's supposed to be responsible for resolving it.
And this was coming from your sorority sister.
Correct.
So didn't you think that Brandy had a valid concern?
Yes.
Wouldn't you express that kind of concern if you had the situation that Brandy had going on for 5 years?
Yes, but not in a 2-page text message.
Well, let's get to the third page. Did you discuss with the prior owners the fact that they had to take care of tree limb damage to the roof of the Thomases?
No.
Did you discuss anything with them about this tree that was posing a threat to their Thomas's property as early as 2021?
No.
Why didn't you tell Brandy that?
Again, the long exchange over text message and the legal references, citing regulations, it's not something I felt competent to discuss over text message.
Well, why didn't you just walk over to her house?
First, at the time, I was at dinner, and so I couldn't have just
How about
walked
the
up.
next day?
I was not comfortable having a conversation with someone, a friend, as you say, who would engage in a conversation about the legalities of a tree over text message.
And this was coming from your sorority sister.
That's correct.
Now, on the next page, page 4, she cites to the Georgia regulations, which she is aware of, but she also says, I'm not requesting anything at all from you regarding the repair or any damages that have been done since you have been in the home. Soro, you and your family have done so much to make the property better. Don't you think that was kind of a nice thing to say from a neighbor?
Yes.
Don't you think that's kind of a friendly way to say, let's work this out?
No, I do not.
Why not?
Discussing legal matters over text message is not something I'm comfortable doing with anyone,
Even with the sorority sister.
even with the sorority sister.
Now let's go to the next page. Page 5. However, I would like you to address the tree, and in order to make sure my house doesn't sustain any further damage, I'm going to place a copy of the letter that was sent to the previous owners in your mailbox. Now, did you get that letter on
Yes.
March 27th
Yes.
with report?
Yes.
And did you have any reason to think it was made up?
Made up? No.
I mean, that was an official certified tree inspector, peace tree arborist, that had been out to the property and said, this tree is definitely a hazard. It needs to be, a level 3 inspection needs to occur to it, right?
I don't recall if he said a level 3 inspection was required. What I do recall he stated was that he performed the analysis above the fence line and he did not have access to the trunk of the tree.
But didn't you feel like at that point in time on March 27th that they sent you this letter and they sent you this report, that it was certainly a valid concern that they had about these dead tree branches?
Yes.
And she goes on to say, also, if you have any trees on your property that are posing an issue to your home, please let us know and we will have them promptly removed. Do you remember reading that?
Yes.
Did you not feel comfortable talking to her about this when she's offering to take care of any trees that are posing any kind of danger to your property?
I did not feel comfortable. No.
Now, the next page, page 6, says, hi, Soro. I don't really get into outside stuff, but I did share your message with Keith. He said he's available to talk this weekend. So that was your response back on February 4th or 5th of 2024, right?
Yes, correct.
And there's nothing in there about, legal stuff. I don't get into legal stuff. There's just, you don't get into outdoor stuff, right?
That's correct.
But you did get this estimate. That's outdoor stuff, isn't it?
Do you mean the estimate for my property?
Yeah.
Correct.
So you do deal in those outdoor stuff, but you don't deal in outdoor stuff having to do with trees.
Perhaps.
Excuse me?
Perhaps. I don't know how to answer that question.
Did you tell Keith? Did you tell Keith about this valid concern of Brandy's?
I told him about her text message, yes.
Did you show the text message to Keith?
I don't recall.
You don't recall.
I don't.
So even though you felt like this was a valid concern, you didn't show him to Keith so he could talk to Cedric maybe and see what we could do to work it out?
I didn't say I didn't. I don't recall if I did or not.
Okay. Now, didn't you have some trees removed on your property on March 23rd of 2024?
Yes.
And do you know what Keith told Cedric when he approached him about this tree issue?
Objection, Your Honor, hearsay.
This is offered for a non-hearsay purpose.
Explain her conduct, Your Honor.
All right, overruled.
Thank you.
Could you repeat the question, please?
Do you know about Keith's and Cedric's conversation?
Yes, I know that they had a conversation, yes.
Was that on March 23rd when you guys were having trees removed from your own property?
I don't recall the date.
What do you recall about the conversation?
Actually, not much. I just know they talked.
Do you know what Keith said to Cedric?
I do not.
Do you know that Keith said, well, I'm going to get a specialist to take a look at that tree?
I do not know that, no.
Keith didn't ever tell you that?
No.
How many trees did you remove on March 23rd?
Maybe 3,
3 trees?
perhaps. I don't recall the specific number, but
Now, knowing Brandy's concern that you consider to be valid, since February 4th of 2024, why wouldn't you just walk over to her house and say, let's discuss this and let's get it resolved?
again, I am not comfortable having legal conversations, conversations with people when they start quoting legal doctrine, because I do not know if that's true or not. And I, again, just was not comfortable having that conversation.
Did you ever tell Brandy that?
No,
Why not?
because at the time, I decided to get an attorney to represent my concern because I wouldn't have wanted to approach her with something that I did not have a legal basis for, a valid legal basis for.
Well, how about get the attorney and say, let's all meet together with the attorney and let's work this out.
Well, that was the purpose of the first letter and the second one.
So you decided to lawyer up first and then send a letter saying remove the fence.
Yes.
Well, that's not exactly what the letter said, is it? But before I get to that, the last document in that exhibit is a picture. And this picture was enclosed with the text message, wasn't it?
Yes.
And it shows the damage to their lamp over their garage door from your tree's tree limb.
I do not know that to be correct.
That's what Brandy said happened, right?
That's correct.
She wasn't asking you to pay for it, but she was showing you this damage. Did you have any reason to believe that that was not the damage that had just occurred in early February of 24?
I did not know.
Did you have any reason not to believe this?
And with no evidence, yes, I had all the reason not to believe because I did not know if that was caused by my tree or something else.
Wasn't this picture and isn't the statement from Brandy enough?
No.
Why not?
All kinds of things can happen to a lamp.
I mean, this is your sorority sister you're talking about.
It is.
Okay. Now, during the entire month of March, you never attempted to talk to her, contact her, text her, or anything, did you?
No,
And the reason would be because she cited some statute in her original text.
correct.
Any other reason?
No,
And you got your survey done on February 21st of 24, which would have been about 2.5 weeks after the text from Brandy, right?
correct.
And I suppose that survey had nothing to do with the text from Brandy on the 4th, did it?
No, because I contacted the survey company in January of the same year. Initially,
Well, Mr. Bernard said he was contacted on February 21st, did he not?
perhaps he was as a supervisor, but I emailed the firm in January to initiate the survey.
So the only reason why you didn't try to work something out was because Brandy had cited a statute in the original text. Is that correct?
Yes,
That's the only reason.
yes.
Let's go to Exhibit N, which is the estimate you got. Now that estimate was obtained on March 13th of 2025, right?
Yes,
And it was obtained because you wanted to see what it would cost to prune the tree back?
no,
Why was it obtained?
the estimate or the proposal was obtained for me to understand the condition of the tree and what, if any, work needed to be done to it.
Okay, and the estimate says large rotten branch is a hazard to people and property.
Yes.
Did you believe that?
Yes,
And that was March of 25. That was actually a week after the answer and counterclaim were filed in this case. Did you ever send this to Brandy?
no,
Did you ever authorize your attorneys to send that to Brandy and say, listen, $1,300 and we're done with the tree issue?
yes.
And why didn't you offer to pay $1,300 in March of 25?
Well, this lawsuit had been going on for a year, almost a year.
No, the lawsuit was filed in October of 24.
At 6 months. It had been going on for 6 months. And because the counterclaim was filed, I thought we should handle it through the legal process.
Why didn't you simply offer to take care of the pruning back of the tree and then Brandy would remove the fence? Why not do that right from the beginning?
I don't have an answer for that. I don't have an answer.
All right, let's look at this letter that your counsel pointed out, which we have as Exhibit G2. Now, this letter in this third paragraph states that you will allow Miss Martin's surveyor to access your property in order to locate an iron pin located on the northwestern corner of your property to more accurately depict the location of the boundary line between the two properties and mark the boundary line with flags. Do you see that?
Yes.
Now, do you know if the boundary line was ever marked with flags?
There were 2 stakes placed that had flags on them on that side of the property line, yes.
There were no flags on that boundary line, were there?
If you don't recall, if you don't refer to the pink tape as a flag, in my opinion, that's a flag
There was a wooden post
with the pink
with the
flag
pink
wrapped
tape
around
on it.
Yes.
And then there was a survey pin in the back, but there were no flags coming down that boundary line, were there?
No,
There were never any flags coming down that boundary line, were there?
no,
That's correct, isn't it?
that's correct.
So on April 23rd of 2024, your attorney's letter says that first place, we need to get access to the property to locate this pin to make the survey accurate, right? That's what it says there.
Okay.
Is that right?
I'm sorry, where are you reading from?
The bottom paragraph. Says
Yeah.
to more accurately depict the location of the boundary line. She didn't have access to that pin in the back, and the reason was because the fence was on top of it. That's why you had to pay to have it removed, right?
I am not aware that the fence was on top of it. I don't know that.
But you're aware the fence had to be removed
Correct,
to get to the pin, right?
correct.
And Mr. Bernard didn't know anything about that, did he?
I don't know.
You heard his testimony.
I did.
He didn't know anything about removal of the fence, did he?
I don't recall what he stated.
Now, your next sentence from your attorney on April 23rd, 2024 says that once the updated survey has been completed, after viewing said iron pin, that you move your fence and other items back to your side of the boundary line. So, wasn't that survey not completed under Mr. Bernard's testimony until as late as October 25 last year?
No, now I did hear him say it was complete. Both surveys were complete, according to his standards during his testimony today.
Well, he had to re-access the pin, and the pin wasn't accessed until September 30th, 2025, correct?
Yes,
And that access agreement that we mentioned with Mr. Bernard that he didn't know anything about, weren't you given access to that pin as early as January or February of 25?
I don't recall the date.
Well, this access agreement that had to be entered into wasn't entered into until July of 25, correct?
I don't recall the date, but yes.
Well, it's in evidence.
Okay.
It's dated. And then Mr. Bernard didn't get out there until the end of September of 25.
Yes.
Do you know why it took literally 10 months for him to get out there and actually access that pin so he could more accurately depict his survey or complete his survey?
I do not know why.
And you know that the fence was removed in January of this year, right?
Yes,
And the turf has been removed as of yesterday.
yes,
And the bushes were removed about a month ago, right?
yes,
So everything's gone.
yes.
Now, once the fence was removed, why didn't you just go out there and remove the turf and back down the bushes and go ahead and start your project?
Well, I had surgery,
Oh,
and so
I'm
I have
sorry.
not had the time to do that.
Well, you do know that the completed survey was never provided to us until October 30th of 2025.
I do not know. If
Well, I
that's
have an
okay.
email and evidence that proves that it was not provided to us until October 30th of 2025.
Okay,
Now, getting back to Exhibit F. You can take that down if you like. Thank you. Well, actually, it's Exhibit 1 of the attorney fee side of our exhibits. Now, Exhibit 1, are you there with our exhibits? Defendant's Exhibit 1 is the last text. Do you see that?
I'm getting there. One moment. Yes, I have it.
Now, did you receive that text on April 24th, 2024?
Yes,
And it said that left you a voicemail. Would you be glad to speak to you about your concerns regarding the fence and happy to look into it? I won't be calling your attorney, though. We could have a neighborly conversation about this and address any of your concerns. We were not given the courtesy of a discussion ahead of legal engagement. You would agree with that, right?
I do not agree with that.
Did you ever give Brandy an opportunity to discuss this prior to hiring Mr. Klein?
No,
Okay.
because
Because of that statute site.
correct.
But it's true that you didn't try to discuss this with Brandy in any way, shape, or form before April 24th, 2024.
That's correct.
We were not given the courtesy of a discussion ahead of legal engagement. Please let us know when you would like to stop by. We would also like to talk with you about the tree. So why not take Brandy up on her invitation?
Well, sir, this text was sent at almost 10 o'clock at night. It started on my son who was asleep. And when it was sent after repeated phone calls at this time of night, followed by a text. And I saw it the next morning and I was taken aback.
So the repeated phone calls where Brandy left you voicemail messages too, didn't she?
Correct,
And you never responded to any of that, did you?
correct,
You just lawyered up.
correct.
Isn't it true that Brandy's door was always open through this open invitation to discuss this situation and resolve it as neighbors do?
In my opinion, no,
Why not?
because neighbors don't speak like this to neighbors and cite legal statutes and regulations and send text messages this is long when you want to have a neighborly conversation, in my opinion.
And those letters you discussed about in the summer of 2024, none of those letters that were sent back and forth between Brandy and your attorney discussed this tree in any way, did they?
I think there were references to the tree. Maybe on her side, but there were references in the
Are
community.
you sure of that?
No, I said I think. I'm not 100% sure.
Well, and those letters were just questions from Brandy as to this survey and how it was incomplete and what a pin was and those kind of things, right?
I don't understand your question.
Well, you said before that because of the questions in the letter that you felt like there was no resolution coming. And so you authorized filing of this lawsuit in October of 24, did you not?
I don't know how to answer your question. Can you maybe restate it? I'm not sure what you're asking.
Well, I thought you said before that there were questions that were asked about, basic questions about a survey pin
Yes.
in these letters from Brandy to Mr. Klein, right?
Yes, correct.
And in those letters, Brandy was simply asking, what is a survey pin? How does this work? Is this survey any good because it's dated 2013 and those kind of things, right?
Yes.
And how would that make you think that you have to file a lawsuit because of those questions that are being asked by Brandy of Mr. Klein?
Well, the first response alone did not make me think I needed to file a lawsuit. There was a second request as well. And the request was to allow access to locate the pin, which was not allowed or granted. That was the request, to allow me to complete the survey as a neighbor.
So you never took it upon yourself simply to walk over to her house and say, let's work this out.
No, sir, I did not.
Isn't it true that the Thomases never, ever refused to move their fence though, right?
I saw that the fence was removed in January of this year.
But isn't it true back in February, April 24, June, July, August of 24, they never, ever said, we're not moving this fence. In fact, they said just the opposite with their first attorney in November of 24, did they not?
I don't recall.
In November of 24, November 18th of 2024, Melanie Nealis suggested that if you prune the tree back, which would cost all of $1,300, we would remove the fence and we don't even need you to complete the survey, which was uncompleted in November of 2024. Were you aware of that settlement offer?
I want to put an objection just on the record that this compromises settlement negotiations and should not be admissible or discussed during testimony under OCGA 24-408.
All right, well, having reviewed Rule 408 and the case law cited by counsel and consulting with Millich's rules on Georgia Rules of Evidence, it does show it's fairly explicit that evidence can be relevant to other matters such as supporting and explaining a party's petition for attorney's fees. So objections preserved but overruled.
Thank you, Your Honor. So were you aware that in November of 2024, your attorney and Ms. Nealis had several emails between them that Ms. Nealis is prepared to testify to, that was an offer of, we'll remove the fence if you'll just prune the tree back. This was November of 2024.
I'm aware of the communication. That is not all that was requested, as far as my understanding is.
Go to Exhibit 5. Defendant's Exhibit 5. Third paragraph of that email. You see it?
Yes.
My clients nonetheless have a desire to put this matter behind them amicably and quickly. Purposes of settlement only and without any admission of liability, my clients will agree to move the fence no later than February 28th of 2025, subject to the availability of qualified contractors. In exchange, my clients request that your client hire professional tree service to trim the offending tree to the satisfaction of the arborist to be retained by my clients no later than February 28th, 2025. Each party will bear their own respective cost. There's nothing else in there about anything but trimming the tree back and moving the fence, is there?
There is a statement about each party bearing their own cost. That is a request.
So you bear your costs, they bear their costs as
Yes.
far as any attorneys.
Yes.
But the main thrust of that settlement offer was simply prune the tree back for $1,300 and we'll remove the fence without a completed survey, right?
Sir, my understanding is that the survey was complete. The first and the second one were marked complete by the survey company. And at that time, I did not think it fair that we both I eat attorney's fees for this matter.
So you refused the settlement, didn't you?
Yes, correct.
And certainly the pen was never accessed until September 30th of 2025.
I believe that's correct, yes.
That was because the fence had to be removed, right?
Correct.
Now, were you aware of the 3 extensions of time to file an answer here and file a counterclaim?
Yes.
And weren't you aware of the fact that those 3 extensions were specifically given to try to work out a settlement?
I did not know the reason.
But you knew there were 3 different extensions,
Yes, correct.
all the way from November until March to try to work out some sort of settlement?
I knew there was an extension. I did not know the reason.
Now, in February of 2025, February 18th, you called the police, didn't you?
Yes,
And you called the police because you alleged that that Brandy's landscapers were throwing trash on your property, didn't you?
I don't know that I used the word throwing, but generally speaking, yes, they were landscaping over the property line, yes.
And they were throwing trash on your property. Isn't that the allegation that you told the police?
I don't recall using the word trash.
And didn't you have a conversation with the officer where you were yelling and screaming at him because he wouldn't do a report?
Conversation, yes. Yelling and screaming, no.
Okay. And didn't you call his supervisor to try to get a reprimand of him because he wouldn't do a report?
No,
You didn't call the supervisor.
no,
Are you sure?
positive.
Now, this exhibit that you talked about earlier, P13, this letter, which is the Code 508 investigation, the 920 Windover. How did you find this?
On the City of Atlanta's website.
So you searched the city of Atlanta's website back in, it's like it's dated June of 2024.
Yes,
And do you know who actually made this complaint?
I do not.
So this could be not even the Thomases, right?
I don't believe that's a possibility.
Do you know whether or not the Thomases are the one who made this complaint, or is it someone else?
Do I know definitively? No. But based on his comments about artificial turf and grading, neither of my other neighbors have that in their backyard up against my property. So I don't know who else it could be.
Well, there's no indication on this P13 as to who called, is there?
Correct.
And if Brandy and Cedric both deny that they made this call, you would have no evidence to prove them wrong, would you?
No.
Now, the independent or the access agreement took a very long time for it to be worked out and actually signed in July, did it not?
Yes.
And were you aware that you were given full access to the property as of January, February of 2025?
I do not know that.
And you then had called the police in December and January of 2025 and 2026, right?
Which date were you referring to?
Were you called the police because the girlfriend parked in the wrong direction?
No, sir.
Did you call the police because of that?
No, sir.
So you didn't call the police then?
No, sir.
Do you know why it took so long for this access agreement to actually be signed from January of 2025 until July of 2025 when it was actually finally signed, and then the inspection to locate the survey pin didn't occur till September 30th of 2025? Do you know why it took so long?
I do not know.
Wouldn't you agree with me that by hiring an attorney and sending a letter like this was escalating this situation to a potential lawsuit as opposed to trying to work it out with your neighbor?
No, I do not agree with that.
Why not?
The request was to complete the survey. And if the findings, resulted that there was an encroachment, that the items be removed. And that was my expectation, that we would work through the survey and respond accordingly, whatever it turned up.
And you certainly don't blame Brandy nor Cedric for the delay in actually getting this access to the survey pen, do you?
I don't know.
And you refused to settle this matter pretty much at every turn before it was filed into a lawsuit in October, right?
My request as a homeowner was to have the items removed from my property.
So, but for the fact that you had some attorney's fees that you chose to retain a lawyer for, you would have settled in November, to prune the tree back, and then they would remove the fence? Is that correct?
I can't answer that. In November, the request was for me to remove the tree in its entirety, if I recall correctly, not prune it back. The pruning request came much later.
Taking a look at him. Defendant's Exhibit 5. There's nothing in there about taking out the tree, is there?
Which item are you looking at again?
Paragraph. Third page.
Which exhibit? I'm sorry.
Clients will agree to move their fence no later than February 28th. In exchange, my client's request that your client hire professional tree service to trim the offended tree to the satisfaction of the arborist. There's nothing about taking out the tree in November 18th of 2024, is there?
I'm sorry, sir. What exhibit are you looking at again?
I'm looking at Defendant's Exhibit 5.
Okay.
Third page.
Is this the same paragraph you just read? I just want to make sure I'm looking at the right exhibit. The email?
Yes. November 18th of 2024. Email from Melanie Nealis to David Klein.
And the question again, I'm sorry.
And the third paragraph has nothing about removing a tree. It says simply trim it back, correct?
Yes, along with other things.
Along with the fact that the parties take care of their own cost, right?
Yes,
And that was the part that you were unwilling to agree to, right?
correct.
But don't you think it's reasonable, considering the fact that Brandy had a valid concern that you throwing the tree back for $1,300 at that point in time, and they would remove the fence and pay for the removal of the fence? Don't you think that's a reasonable settlement?
My understanding from the arborist is that I cannot go on their property to do anything to my tree because it overhangs their property.
But they were willing to allow you on their property on November 18th of 2024, were they not?
I don't know that.
That's what the offer says, does it not?
That I was allowed on their property, I don't see that written here.
Excuse me?
I don't see that written here, that I could have access to their property.
Ma'am, don't you agree that you have actually been the one who has been so stubbornly litigious?
I do not.
Don't you agree that you've been the one who has caused all this unnecessary expense and trouble?
I do not.
And you're not a licensed state of Georgia certified general appraiser, are you?
I am not.
And you don't know whether or not those type of appraisers that are licensed even use tax assessor mass appraisals in determining fair market value, do you?
I do not.
And as far as that 5% that you gave before, what is that based on?
An estimation that I heard from one of the surveyors.
Okay, so that's not based on any kind of calculation that you did.
No.
That's based on hearsay.
My understanding of their assessment, yes.
No further questions, Your Honor.
All right, let's see if we can finish with Ms. Martin. Do you have any redirect, Mr. Klein?
I do, Your Honor. All right, Ms. Martin, was there any indication that the Thomases have ever tried to prune the tree that we're talking about that since you've been in the property?
No,
Would you have cared if they tried to prune the tree from their side of the property at any time?
no.
There were a lot of references to you two being sorority sisters. Can you kind of explain how good of friends you are? Or like, what does that mean that you're sorority sisters?
It means we are a member of the same service organization. There are 350,000 members across the world, and we each join at different colleges or places in our lives.
Okay, so you didn't go to college together?
No,
Okay. So you were joining different, or the same sorority at different colleges?
correct.
All right. Do you get nervous or anxious when legal issues are brought up?
Yes,
Why is that?
because I am not a lawyer, and I don't want to say or do anything to that's not correct.
Have you ever had to deal with legal issues in the past?
Yes,
Did those cause you nervousness or anxiety?
yes.
Did Mrs. Thomas ever come over, knock on the door, and try and talk to you about this situation?
No,
We saw a lot of text messages, but did she ever try to call you, to your recollection?
after the lawsuit was filed.
Now, I want to pull up what is already in evidence as Respondents Exhibit 2. All right. Do you recall us receiving this letter in response to our initial demand in May of 2024?
Yes,
All right. I'm going to scroll down to the end of this document, and you'll see this letter that's attached. Do you recall seeing that letter before?
yes.
Was that the letter that was dropped off in your mailbox? Or what? How did you receive that letter before?
It was put in my mailbox, yes.
Okay. Was it put in your mailbox around March 27th of 2024?
Yes.
Do you know who put it there?
Miss Thomas, she said she was going to in the text message.
Okay. And I'm going to go ahead and just read this portion right here. As my wife Brandy stated to Brianka, we are not asking for damages to be paid at this point. However, allow this letter to serve as notification that going forward, unless this tree is properly addressed, paying for damages caused by this tree will now transfer to the Martin household. Do you recall reading that around this time period?
Yes.
What did you think of that?
Made me nervous and anxious, and I did not want to have the conversation without the proper representation.
And
Any conversation about tree or other things.
And shortly after you received this letter, you retained my law firm. Is that correct?
Correct, yes.
And then also here it says, unfortunately, the seller of your home sold the house without addressing the tree, therein transferring the liability to address this to you. How did you feel upon reading that at the time?
Nervous, anxious, unsure, all of those things.
Did this look like a friendly letter from a neighbor to you?
It does not.
How did you feel? How did you receive this letter what did you feel like when you received this letter?
I felt like there was a attempt to place blame or liability for a matter that I had didn't have much information about.
And then I want to pull up Respondents Exhibit 4, which is already in evidence. This is another response that we received once we sent a letter. Do you remember this response in July of 2024?
Yes,
All right. And this is from the Thomases, is that correct?
yes.
And so in this letter, they say we decline the option to use email communication. Is that correct?
Correct.
And under section 1, they say the Martins may not have access to our property to validate an assessment that they have updated multiple times. There have been multiple assertions about the validity of their survey. This should be sufficient for them. Do you remember reading that around this time?
Yes.
What did you understand them to be saying there?
They would not allow the survey access to their property, the surveyor.
And then under section 3, it says, because we have not had our own independent survey since we moved in, we will be commissioning one ourselves. Do you remember reading that at the time?
Yes,
Have the Thomases ever commissioned a survey to your knowledge?
not to my knowledge.
They've never shared a survey with you?
No.
I'm going to go ahead and pull up Respond as Exhibit 5. You never had any communications with Miss Nealis, correct?
No.
And if you look at this, she first reached out on November 11th of 2024. Is that correct?
Yes.
And by that time, we had already filed a lawsuit. Is that correct?
Correct.
Had you incurred attorney's fees in sending letters, drafting a lawsuit, having a lawsuit served at that time?
Yes.
And back in when we were in the letter writing phase, what did you believe? If you could access the property, get this survey done, do you think there could have been a resolution at that time?
Yes.
And yet in July of 2024, we weren't allowed access. Is that correct?
Correct.
So why did you feel you needed to file a lawsuit at that time?
Because the survey could not have access to their property, and they did not allow access to complete the survey.
And by the time that we received this settlement offer from an attorney on November 18th of 2024, do you know how much in terms of attorney's fees you had incurred by that point?
Not exactly, but more than I wanted to spend.
And they were also asking you to trim the tree, is that correct?
Correct.
And within this settlement offer, it says in parenthesis, to the satisfaction of an arborist retained by my clients. Is that correct?
Yes.
So you didn't know what arborist was going to be retained?
No.
You didn't know what that arborist was going to recommend?
Correct.
And at the time the only thing that you had was a report from 2021 from Peachtree Arborist, right?
Correct.
And that indicated that you needed to actually remove the entire tree, right?
Correct.
All right, no further questions, Your Honor.
Recross on those points.
Thank you, Your Honor. Very quickly, Ms. Martin, the first paragraph of that letter, Defendant Exhibit 2, states that it should be noted this is the first time we are hearing of the Martins' concerns via letter from your law firm. So you had never brought it up with the Thomases about this encroachment, had you?
No.
And why was that?
Legal references in a text message plus additional legal references and accusations of liability in a letter that was placed in my mailbox.
You certainly chose to retain counsel, did you not?
I did.
And Brandy Thomas did not retain counsel in the summer of 2024, did she?
I don't know when she retained counsel.
Well, she's the one who's authoring all these letters we're talking about, right?
I suppose so, yes.
And she says Mr. and Mrs. Martin never engaged us in conversation, although we have invited them to do so at any point. Isn't that true, that they invited you to do so at any point?
Any point after speaking to me over text message with legal references and sharing a letter in my mailbox placing liability for a matter I had no information about.
And leaving several voicemail messages for you on April 24th,
That's correct.
which you never responded to.
Correct.
It says never engaged in this conversation, although we invited them to do so at any point, at any time, should they need anything, whether assistance or a concern. Does that sound like somebody who's trying to threaten you with legal action?
In the context of receiving a text message with legal references and a letter with legal language, yes, it does.
Well, you never responded to that letter of 32724, did you?
I did not.
You had your attorney do it.
Yes.
And as far as Defendant Exhibit 4, once again, this is a letter from Brandy, correct? Or Cedric and Brandy. So as late as July 25th of 2024, Brandy and Cedric were not retaining any attorney to represent them, correct?
What's the date again? I'm sorry, I can't see it.
Defendant Exhibit 4,
That's correct.
July 25th, 2024 letter.
Yes, that's correct.
So that's from Brandy and Cedric again.
Yes.
And they are still trying to get some kind of relief from this dangerous tree. Would you agree with me that was, in fact, a danger as far as the branches, right?
Sorry, what's the question again?
They were still trying to get some kind of relief from this dangerous tree that you've already agreed with me has dead branches on it that fall on their house, on their driveway, and potentially on their family.
That's a loaded question. I agree with some of what you said. I disagree with other parts of what you just said.
Well, there was never any response to the July 25th, 24 letter, was there?
Response from whom?
From your attorney or anybody else?
Not that I'm aware of.
And you were fully aware of this letter on July 25th, 2024, right?
Yes. I don't recall the dates of when, I know we responded to them. I don't recall if it was for the first letter or the second one. I don't recall.
And she says that she'd like to get her own survey, right?
Yes, which I have not seen.
Which what?
I have not seen.
Well, why didn't you have your attorney contact her before you filed suit and said, have you got the survey? Is it done? But you filed suit instead in October of 2024, right?
What's the question again?
After the letter of July 25th, 2024,
Yes,
where Brandy says she wants to get her own survey
yes.
to verify your incomplete survey. Why didn't you contact her before you filed suit and said, do you have the survey? Can we work this out?
I don't know the answer to that question.
You didn't make any contact, did you?
I don't know the answer to that question.
Your attorney didn't make any contact to her before he filed suit in October 2024, right?
I don't know the answer to that question.
No further questions, Your Honor.
All right, ma'am, you can step down.
Thank you.
All right, why don't we'll take at least 45 minutes. If parties come back earlier, we'll get started earlier. So let's be back here no later than 2:15. We got that cafeteria on the first floor if you want to just have a quick bite. And again, we can start as early as 2 if you're back here by then. Otherwise, well, let me first close this loop. Mr. Klein, do you anticipate presenting any further evidence?
No, Your Honor.
All right, so at this point, the petitioner rests, and we'll take it back up at the latest 2:15. We're in recess.
Thank you.
Your laptop?
Yeah, you can, but they'll probably lock it up. It's on.
Always is. We're allowed to leave our stuff here?
Excuse
Are we allowed to leave our stuff here?
Yes,
Okay.
yes, absolutely.
I'm probably fine. Like. This wasn't built first.
Yeah. Improvements to that house. Oh, bad. We probably find pictures to show. That was never there. I cannot believe she did that.
Testify to it.
Yeah. Yeah. But she had to lie and perjure herself. That's over the top. See here. Damn thing.
Maybe him up first.
Okay.
And then finish with
Oh,
you.
what are we doing?
I don't know.
Cedric.
I don't know where you want.
Okay, so Devon Jackson, I was telling you about,
You.
he got a gang case.
Oh, okay. Yeah.
And then the guy, Greg Ross, that they just transferred from.
I
Concept
used
to us,
43 minutes.
He's a codefendant on the gang case. So because Devon Jackson had
Cross.
those older
We got
cases, all the
only 20
codefendant
minutes
cases
for
now came to us.
Awesome. And guess what? It's a conflict now because somebody in our office had one of the other co-defendants in the game.
The
Oh
other thing
my
I was
God.
thinking is to
So,
that point
I
of
don't
why
know
they could
who's gonna
not
end
have
up
access to the yard.
I mean,
Tiger-
So exhibit
guess what?
P5
It's game.
shows that our pool was under construction at that point. There was a ton of building material. That was an active job site. And so it would have been unwise of me at that point
Yeah.
allow access
Okay, I didn't know like.
without some sort of agreement there.
All right. Let me write this stuff down real quick. So. P5.
P5, yes. You see this material here? This was all material that was being used to construct our pool. So that also is why I was like, wait, time out. You know, she's incredibly litigious. They've not been responsive to requests. It would have been great to speak to her on any occasion. And so there were many reasons why allowing somebody on the property for a purpose I didn't fully understand without some prior thought or continued
Incentive.
thought. Also why I was like, well, oh, we have the pool survey.
Hey, can they still hear us back in the back? Because he's off.
Oh, can I turn it on?
Red light is, the red on, yeah, it's on right now. You can tap it. Yeah, touch it. Yeah, red light.
get something.
You guys wanna stay here, you can, we got a conference room up here that you guys can do.
Okay.
Friday.
That'd be great.
Yeah, 2 hours left. Look at that, there's almost exactly 2 hours left.
Yeah. That's good.
Yes, I sustain for a few more minutes.
Yeah.
Yeah. Got short. Name seated, court will come to order.
Ready? All right, we're back on the record. All parties and counsel are present. Anything to take up on behalf of the respondent before we proceed with your case? Mr. Miller?
Would I have an opportunity for a directed verdict motion?
Why don't we do it this way, just, in the interests of using everyone's time most efficiently? Just as a technical point, I think it'd be a motion for an involuntary dismissal since it's a bench trial. There are no verdicts to direct here. But I would say, why don't we just state the grounds to preserve them? And then you're going to be arguing many of the same points during your summation, and we can just bring it all up there and again. So, and I'll defer ruling.
Points. There's no claim for nuisance. The claim of nuisance may not be brought based solely on a claim of physical taking of property. That's what's going on here as far as the trespass. So we would make a motion for directive verdict on any nuisance claim that the petitioner added on Tuesday. Same goes for the negligence and negligence per se. They're barred by the statute of limitations. They were added on Tuesday. And the
The applicable statute of limitations here being 2 years? What would it be?
20 till the filing of the lawsuit, it's more than 4 years.
4 years. All right.
And then the motion for directive verdict on the covenants and restrictions in our memorandum, trial memorandum, where a deed of sale does not mention certain restrictions. But the property owner had notice of such restrictions. The restrictions are binding upon the purchaser. Well, that's the other point, but Ms. Martin has testified she was well aware of the fence, well aware of where it was located, at least at the point in time when she moved in. It's gonna be our evidence, she connected to it, but she said she did not build that new fence on the side of the house. But nonetheless, she was aware of the fence. She bought the property. She lived there for almost a year before she started making any noise about the trespass. And that agreement runs with the land, runs with the title, based on the case law we cited in our trial memorandum.
Well, what evidence has been introduced so far that any kind of formal agreement or covenant was?
Doesn't require a formal agreement. All it requires is notice under the cases we cited that she denied connecting to the fence, but nonetheless, she had notice of the fence, the full enclosure, and under the case law we cited in that trial memorandum, it's not required that there be a formal agreement.
She would have to have noticed that the prior landowner came to some kind of understanding or acquiescence, or I'm just saying that she didn't introduce testimony about what the prior landowner was up to, so.
We introduced testimony that she knew about the fence.
But that she showed up, she sees a fence there, but she has no idea of the circumstances of how it got there.
I think that first case, Your Honor, the Atlanta Association of Baptist Churches versus Gowan. Surrounding the purchase lot, the deed contained no notice the lot had been purchased would itself be subject to such a restriction. The purchaser was nevertheless on notice that said property could not be used to build a church. That, in effect, is the same thing going on here. She had noticed that there was a fence in that location. She derived the benefit from it for at least a year before she started making allegations of trespass. But that would be our additional point, Your Honor.
Okay, well, I'll take a closer look at that, and I'll defer ruling on those motions. They're preserved. And so I think we would then transition to any evidence that the respondents wish to present.
We would call Ms. Brandy Thomas.
All right.
And I have the correct understanding that I've used up 43 minutes of my 2 hours.
No, that's been counting down from 2 hours. So you used 1 hour and 20 on cross.
You swear upon testimony that you said you have this nothing. That's it.
I do.
You said it, Michael.
Yes, my name is Brandy Thomas. That's BRANDITHOMAS.
Okay. Tell us first, where do you live?
I live at 930 Wendover Drive Northeast, Atlanta, Georgia, 30319.
And when did you move in?
We moved in April 2018.
And Miss Martin is right next door at 920
She is.
Wendover Drive? And she moved in April of 2023, right?
That is correct.
So you guys lived there for about 5 years before she did.
Yes, that's correct.
Now, what do you do for a living?
Right now, I'm transitioning to a new role. I'm Vice President and Chief Audit Executive of Uber Technologies. That's coming up. But prior, I was Vice President and Chief Audit Executive of General Motors. I also sit on 2 boards of directors. I sit on a public company board of directors called Next Power, where I'm chair of the audit committee. And then I serve on a private company board here in Atlanta called Serta Simmons Bedding, where I'm also chair of the audit committee. I also sit on the NomGov committee as well as the compensation committee.
Now, you're married to Cedric, right?
I am.
And do you have any children?
We do. We have 2 children. Our oldest, CJ, Cedric Jr., is almost 21, and he is a junior at NYU in New York City. And our youngest, Bailey, is 14. She's in the 8th grade at Pace Academy.
Okay, and do they live at the address?
They do. Well, CJ is away at school a lot of the year, but Bailey lives with us at 930 Wendover. That's correct.
Okay. Now, share on this picture.
We need to make sure you're added as a co-host, and then you should be able to share away.
Now, you heard Ms. Martin testify earlier that she did not build this rather new-looking fence on Defendant's Exhibit O. Do you see that? Randy?
I do see the exhibit, yes.
Now, is that true?
That is not true. Brianka, I'm shocked that you would be up here.
Only address
I'm sorry.
me. You don't need to address anybody
Sorry.
else.
I'm shocked that she would testify that she did not build that fence. As a matter of fact, to Brianka's own testimony, when I came over and welcomed her, we had a conversation about how it was great that she had made so many improvements on the house because the prior homeowner had done absolutely nothing to maintain it. So anybody can see in this picture that the fence is brand new and was recently built.
And to your knowledge, when did that fence get constructed? Shortly after she moved in?
It would have had to be constructed shortly after she moved in, yes.
And it was connecting to your fence, which is the older fence?
That is correct. Well, you can see our fence was built in 2020, so it's older, gray, weathered. This is a brand new fence that was put into place by the current homeowners.
Okay, and now you remember the testimony regarding a code enforcement complaint?
The first of that I heard today. So I remember the testimony, yes.
Did you guys make that complaint?
We did not. As a matter of fact, to Brianka's own, Ms. Martin's own testimony, there was a code violation allegedly about our turf. I don't know why we would call code enforcement on ourselves. It's not a logical argument, and we certainly never called. We have really worked hard to take the high road over this last 2 years, and I'm really surprised that we are here. This could have been resolved from day one in April 2024 with a simple conversation.
Now, she had mentioned something about in her prior testimony about how you guys were sorority sisters, but you're really not that close or anything. Does your sorority have any sort of theme with the sorority sisters that you would like to tell the court about?
There is. So Ms. Martin's right. We probably pledged at different times, but we all subscribe to the same tenet. One of our major songs says, "We help each other." And I, through this whole thing, have tried to be helpful to Ms. Martin. I've tried to give her the benefit of the doubt. I've tried to communicate with her, and I've adhered to that testimony. And my hope was that Ms. Martin would behave in the same manner, and I have not experienced that.
Okay. So you heard also Ms. Martin testify that she had learned from the landscapers that the fence was on her property. Do you remember when the landscaping that she did actually occur? Did it occur before February 21st of 2024 or after?
Did the landscaping occur? So her property was largely unlandscaped for a very long time. So to the best of my knowledge, her landscaping happened after February of 2024.
Okay. And did you receive an Amazon package in the last few months?
I did. It has been impossible to communicate with Ms. Martin about anything. I have reached out and offered many, many attempts. One of the most recent was a misdelivered Amazon package where I've been told to communicate through her attorneys. I can't even go over there and say, hey, here's your package. So I reached out to her attorney, no response from her, no response from her attorney. The package is sitting in my garage. I don't know what to do with it. I'm afraid to get rid of it because she's so litigious. I don't know what to do in this case. It's been perplexing for 2 years and it's been an exhausting endeavor.
And did you not notify her counsel once you received that Amazon
I
package
did.
by mistake?
I did. It was misdelivered.
Now, you saw a picture identified as P5, which showed a stake and some construction, something in the right side of that picture. It was P5. What was going on at the point in time when you told Mr. Klein that he did not have a right to come on your property?
We had a construction project going on, and it was a major construction project. So there were, at that point in time, I think, well, as we discussed, I had not retained any counsel. I was in good faith attempting to negotiate and go back and forth and write letters between myself and Ms. Martin's attorney. So it's me, Ms. Martin's legal team, Ms. Martin's experts, all of that. And so by trade, I am a risk manager. It felt incredibly risky given that construction project and given everything that I had experienced to that point to just carte blanche allow someone on my property for a purpose that I didn't understand. And I'm also glad that I didn't, because when I finally retained counsel after Ms. Martin sued me, I was advised by my attorney to say, hey, before you even do that, it's a good idea to put in an access agreement, both for your protection and for hers. And that's what ended up happening.
Now, the settlement agreement or the settlement proposal that was offered back in November of 24 by Miss Melanie Nealis, it talked about an arborist that was had to be pruned, the tree had to be pruned back to the satisfaction of arborist. Who was going to pay for that arborist in November of 2024 when Miss Nealis made that offer to Miss Martin?
We would have paid, we ourselves would have paid for that arborist and been glad to do it.
Okay. So let's jump back to the beginning. In 2018, was there a chain link fence that ran parallel to the wooden fence?
There was a chain link fence.
Please tell the court how it is that you built this wooden fence back in 2020, running parallel to that chain link fence.
So in January in 2020, we got a pandemic dog. And that side of the house between where our home was and the chain link fence was the side that we decided would be where the dog went to the bathroom. And so as a courtesy to our neighbors, we approached them and said, hey, we would love to protect your line of sight by building this fence. And we talked and we agreed. They had dogs. We're all dog lovers. And they said, we think that's a great idea. And I said, well, I'm going to put it right in front of the existing chain link fence, which we understood to be the boundary line at that time. So there was agreement between the previous owner and ourselves for the construction of the wooden fence, and it benefited everyone. Our yard is pretty meticulously landscaped. That's the only sort of unattractive side of our yard. It's also where our trash cans sit. And so we did it as a cordial, we had a very cordial relationship with our previous neighbors.
And that's where your dog Went to the bathroom.
And to this day, that's where that is.
All right. So exhibits 13 and 14 are pictures of that are already admitted to evidence. Are pictures of this black chain link fence at the point in time when you bought the property.
Yes, that's correct.
And then exhibit B is a picture of the fence removed. The fence has already been removed, but it still has that black post there.
That's correct.
And that black post went to the chain link fence, correct?
That black post is in the same location where the chain link fence was.
Okay, now tell the court a little bit about what happened with the neighbors, the prior owners in 2021.
Yes, so the prior owners in 2021, we had debris continuously falling on our home and property from that tree. There are large limbs that fall constantly. So it fell on cars, it would fall on our home. Even we had a caregiver that would come and I had an assistant at the time, and they would constantly complain, in addition to my father, about things falling from that tree. And so the previous homeowners, although they didn't remediate the tree, they said, hey, we'll pay for any.
Your Honor, hearsay.
They said to me.
Well, hold up.
Oh.
Any response, Mr. Miller?
Just explain her conduct, Your Honor, in building the fence in the first place.
All right, but it would not be to the issue of whether the limbs were in fact falling or, but with that caveat, noted that it's not for the truth of the matter, you can continue, ma'am.
Okay. They agreed and paid for damages done to our house. We had our roof punctured, we had water damage. They would come out and have their crews, and we never had to see a dime. We did not pay a dime out of pocket. They would just cover the cost of those damages. There were times where we didn't ask them, just like we didn't ask the Martins, to cover the damage, just to preserve the cordial relationship. We're all very busy people, and I'm not interested in coming to them for every concern that we have. We try to be good neighbors.
Okay. And there's Exhibit D, which is the invoice, and a photo of the wooden fence back when before it was removed as, I guess it's D1. Let's jump towards the text of February 4th, 2024.
Okay.
Now, I'm not going to go through it, but because we've been through it before, but Ms. Martin seemed to testify that because you put in there per Georgia regulations, if you have been notified that a tree is threatening a property, the burden of repair falls on the homeowner where the tree resides. Now, why did you put that in their text? And why did you send that text to her? What happened around early February of 2024?
Speaking to the intent of that text, I wanted to make her aware of the concern with the tree. Primarily, my thinking was, hey, you've lived in the house less than a year. You could go back to the people who sold you the house and you could say, hey, you didn't disclose that this was an issue. I was letting them know that it was an issue that was disclosed. And I assumed that she would go back to the homeowners that sold her the home and say, you never talked to us about this risk. She could have negotiated, and I would have been happy to support her. I would have provided anything that she needed to support that because they knew it, we knew it, and it was very well documented. The second piece is we moved to Atlanta in 2017 and we bought the home in 2018. We didn't know at the time about tree regulations. I wanted her to know this was not personal. This was not something I thought or made up because we had our own education around trees and what to do. And, how we started this conversation this morning, what the tree laws are, which we came to understand, hey, if you notify someone on your adjacent property that a tree is a risk and you do it in an official way, that's why we sent it via FedEx eventually, then your obligation at that point has been served as a homeowner to put someone on notice. So I just wanted to share my knowledge with her. By nature, I'm a very detail-oriented person. It's my job. It's what I do for a living. And so the length of the text was more explanatory and just trying to be helpful and giving her good context for what we were talking about. At no point was it to threaten anything legal or civil or anything at that matter.
Now, at the end of that text, there's indication that Ms. Martin said, I don't really get into outside stuff, but I did share your messages with Keith. He said he's available to talk this weekend. Did he ever come by and talk this weekend?
He never did,
The weekend following that text?
never did.
Okay, now what happened on March 23rd,
So.
2024?
Certainly. March 23rd, 2024 was a Saturday morning, and we woke up delighted because we heard chainsaws, and we saw in the middle of our yard, there were Miss Martin's people that she had hired to take down those 3 trees in her front yard, standing in our front yard, belaying large branches off of a tree. And I remember at the time I thought, this is great. I'm like, oh, she didn't respond to us, but she is biased to action. I like this. I think this is great. I was thinking, how could you ever take down 3 large trees for cosmetic issues and not address the clear and present danger of those limbs? The second I received a communication like that, if it was from Ms. Martin, I would have acted on it. So we allowed the whole day to go by because I wanted to give the benefit of the doubt that the tree would be remediated. And as the day drew nearer and nearer and the workers began to conclude their work, that's when we realized, oh my goodness, we should have a conversation with them because I don't think this includes the tree that we've been trying to get resolved or the limbs that we've been trying to get pruned back with them.
No, are you aware of a conversation or attempt to have a conversation by your husband Cedric with Keith?
Yes, I suggested he should.
What happened in that conversation?
My understanding when Cedric came back, he told me that Keith blew him off and didn't seem to know anything about what we were talking about and said, I guess I should have a specialist come out and take a look at it.
Did that ever occur?
It did not.
Now, there's a letter G1 that's marked as G1. It's March 27th, 2024. Why did you send that letter to or drop it off in Ms. Martin's mailbox?
One, we said we would. So in my very long text to Ms. Martin, we gave her a heads up that the letter was coming. We wanted to share with her what we had shared with the previous neighbor. And by the way, we had shared another one with the neighbor on the other side. So this wasn't any different treatment than we had done with our neighbors. And it's very commonplace in our neighborhood to do that. Second of all, we hadn't received any follow-up or any response about something that was a clear and present danger to our home and our property. And so at that point, what else could we do besides, provide official notice that this tree was a problem, because that was our understanding of what we should do to protect our home, our property, and our family.
So did you receive any contact after you delivered that letter in March 27th of 2024?
I did not.
And then the next receipt was this April 23rd, 2024 letter from Mr. Klein, correct?
That's correct.
And did you understand this letter?
Not at all. I was shocked.
And at the bottom of that letter, what was your understanding as to when you were required to remove the fence?
There was no requirement to remove the fence. That was not my understanding at the time.
It states that once the updated survey is completed, we would request you move the fence.
Yes, that is correct.
So what was your understanding as to when this survey was going to be completed?
Yes, I misunderstood the question. Once the pin was located wherever it was at that point. But at that point, when I received the survey, I didn't even know what a pin was or what we were talking about. It also included an exhibit that was on an 8.5 by 11 sheet of paper. It was so small, it was almost in one corner. So it was even hard to legibly read the exhibit that was sent to my home.
Okay, so after you received this letter on April 24th, what did you do as far as trying to contact Ms. Martin?
So immediately, Ms. Martin testified that it was 9 o'clock at night, which that's correct. When I texted her, we had company that evening. Our pastor was over our home, and he handed us the FedEx envelope on his way out of our house. And so immediately I opened it and I read it and I was surprised. So I immediately called her and I said to her via voicemail, What is this all about? Why are we talking through attorneys? Brianka, I don't understand. I don't understand why we're communicating this way. Everything that I've asked of you, I've always given you a heads up. We've always had open communication. I would prefer not to communicate through attorneys. I would prefer to speak to you neighbor to neighbor. Then I called her once. Then after I hung up, immediately I sent her a text saying, Brianka, let's talk neighbor to neighbor. This is the first I'm hearing of this. I would also love to follow up and talk to you about the tree, but I will not be calling your attorneys. I would like to have a conversation with you, my sorority sister, one-to-one in a neighborly conversation. Let's talk. By the way, see the rest of my texts. This is the way you engage with a neighbor when there is a concern. You speak to them first. You don't lawyer up. I don't get it.
During that summer of 24, you wrote a letter on May 2nd,
Yes,
like immediately after the letter of the 24th of April.
correct.
And then you wrote another letter in July after receiving a letter from Mr. Klein on June 20th.
Yes.
Just very briefly, why did you write those letters and what did you say in the letters?
Well, the first letter was to clear, I am not an attorney. I am not a surveyor. I am not a real estate agent. I had not dealt with matters of PINs. I did not understand the issues that were being asked or what was being asked of me. So the May 2nd letter was clarifying questions so that I could get my head around what we were even talking about. My hope was in that time that Brianka would respond to an email or a text and that continued open door so I could get clarity, but I had no recourse but to speak through attorneys. And that was a slow process. I wanted to get this done. The letter on May, what was it? You asked me about the other
July
letter.
25th?
July 25th was also further clarifying and thanking her lawyers for responding and saying, hey, I would like to get my own experts assembled and get my own assessment of what's going on because I'm still not an expert. And I say very clearly in that memo, I am interested in resolving this as quickly as humanly possible. Give me time.
And then did you receive any contact after you wrote that letter on July 25th?
I didn't, and that surprised me because we had established a period or a practice of I would send a letter, they would at least acknowledge receipt through a response. And I never got a response, but I immediately sprang to action to follow through on what I committed in that letter to do.
Did you try to get a survey in August of 2024?
I reached out to a company, yes, on August 10th, and I received 2 quotes, one for about $800 and one for about $1,300. There were 2 different kinds of surveys. I didn't understand the difference between the 2. $1,400 about, I believe, the second one was.
And why didn't you follow through on getting that survey or get that done in that time period of August, September, and then October is when the lawsuit was actually filed?
Yes.
What was going on?
Yep. So a couple of things. There were some practical reasons there. I mentioned in the exhibit earlier that there was construction equipment and materials in our driveway. There was an active construction site in the back of our home. And so, again, at this point, it's just me, Ms. Martin's full legal team, all of the experts that she had brought to the table. At this point, I've not engaged anybody to help or support me. And so given the fact that the back of our home was an active construction site, I thought it was wise to seek counsel as to what would be the right way to do this. Also, by that point, I had made no less than 3 attempts to reach Ms. Martin directly so that we could settle with no response. At that point, the trust wasn't there. So we're talking an active construction site. We're talking about somebody who is not responsive, immediately litigious. And at that point also, she had derived benefit from the fence because she had a secured place where her 7-year-old son could play. Like there was a clear benefit there, and there wasn't anything as in regard to in the letter that would make me feel like this was escalating to the point where I was shortly after going to receive a lawsuit. Now, in the background, what's happening here is that I travel extensively for my job. I was contacting the survey from Zurich, Switzerland, person. I then move on to France. I then go to South America. I make 2 domestic trips, 1 trip out to Scottsdale to deal with the health issue. It's back to school. So it's an incredibly busy time. I also in that time have board meetings for General Motors. I have my board and committee meetings for Next Power. I have my board and committee meetings also for Serta Simmons Bedding. So amongst all of these things going on, I am actively trying to move this forward. I also remembered that that construction project had a survey associated with it. And so also then from Paris, I reached out to the construction people and I said, hey, I think you all did a survey. Can I use that? And here's the situation. They said, we don't think it will be helpful because it's on the other side of the yard. It really doesn't concern the area of the Martins property. And so my next step was to then go back home and see, because I have the drawings of the original plans of our house, to look at that and see what the encroachment issue might be. So I'm through all of this very diligently working and taking steps to, in good faith, move this forward as I committed in the letter.
Now, the lawsuit gets filed in October, and tell the court just generally who did you retain first? And Exhibit 5 of the defendants is what?
Right.
If you could take a look at that.
Exhibit 5.
The emails from Ms. Nealis.
Yes. 1 second. Can you tell me what tab that is in the book?
Well, in November,
Yes,
you retained Ms. Nealis, correct?
I did. Yes, that's
Right.
correct.
And what was the offer that was made at that point in time?
The offer, well, first I'll say before that, I expected to hear back from Ms. Martin or her attorneys, and it went silent until I received that lawsuit. And at that time, I said, oh my goodness, I can't believe this. At that time, I still don't have legal representation. So I called Ms. Nealis and I said, hey, you know what? I just want to resolve this thing quickly. Can you put something together where we both can win? Agree that if she prunes the tree back, that we will move the fence without even continuing this survey business. Let's just get this over with. And she agreed to put that together and put it in front of Mr. Klein and his team and see if we could really get this resolved.
And the emails, you've seen them before, those are all true and accurate of her discussions with Mr. Klein, correct?
They are. That's
And she was
correct.
retained for about 2 weeks, right?
She was retained for about 2 weeks because I really felt that this would settle quickly.
And did you hear from her as far as what Mr. Klein thought about the settlement?
I did. She sent me a text message saying that Mr. Klein thought it was reasonable, that it should settle quickly and amicably, and he thought it was a fair settlement.
So the lawsuit's filed, and you can't get it settled in November through Ms. Nealis. And then there are 3 extensions of time to file an answer. What was your understanding as to why those extensions occurred? And just tell the court a little bit about that.
I think this is an important detail because we presented the settlement offers, and then it would go silent. We would not hear anything from Ms. Martin. We would not hear anything from her attorneys. And so what they were doing is running down the clock. And then at the last minute, we're waiting for a response, and my attorney would reach out and say, well, can we get an extension? So it feels like it's been characterized so far that, you know, Ms. Martin and her attorneys graciously granted all these extensions. In every case, it was we had presented something and they were not moving forward on providing us an answer. As a matter of fact, on that settlement offer, we never received a response. We had that I had that text message exchange with with Melanie Nealis saying he felt like it would settle, and then we never heard anything, and the agreement expired.
Okay, so it never settled. And then tell the court a little bit about what happened in February with this police officer.
Yes, okay. So in February, that was after we granted the access agreement to them. So immediately when we weren't able to settle, I did not want to use any more of Ms. Nealis's time. It's correct, she is a licensed attorney, but she was a friend of mine who agreed to represent us for that limited purpose. I paid her for that. And so I then retained King Buttermore, and he immediately provided an access agreement on February 2nd. I believe the same day he sent it is the same day that Cedric and I signed it, immediately saying, okay, we agreed to settle without you having to do all this. We agreed to do what you wanted to do, us to do. But if you insist on going back and finding this pin for whatever reason, let's immediately give you access.
And that was February 2nd of 25.
It was February 2nd of 2025.
So that would have been before the answer was filed.
Correct.
And what happened with the police officer?
Yes. So I am working from home, February 2025, and a police officer comes to my home, and I'm shocked. I answer the door and he says, sorry to bother you, ma'am, but your neighbor. Oh, how am I supposed to describe it?
It's part and parcel of her contact before the litigation occurred or joined, Your Honor. I think it's admissible.
Can I respond to that? Oh,
Well, I mean, right now, the hearsay alleged is, I'm sorry to bother you. I don't really know what truth is asserted there, but to the point, we'll see what actually is coming through there. We shouldn't just relay a conversation verbatim, but we'll see what the actual content is. No matter what, it's not as, it'll be to show issues of intent. So overruled, you can answer the question.
Okay. He said, we got a call from your neighbor, and she is alleging that your landscapers are throwing trash into her yard. And I said, well, my desk faces out. I can see almost my entire front yard, which is where the landscapers were at that time. And I said, they wouldn't do that. They're incredibly professional, but let's go out right now and see what the matter is. And so I walked the perimeter bordering Miss Martin's property with the police officer, and we find nothing. They had been doing mulching, and we found nothing. And I took some video at the time to show that there was nothing on Miss Martin's property at that point in time. It was just beautiful landscaping that was done. And so the police officer said, I don't see any evidence of what Miss Martin is talking about. And he says, so then he goes to my driveway and then contacts Miss Martin. I go to my landscapers to just reassure them and say, I'm so sorry. I know it's weird that the police are here. Everything is okay. When I walk back to the driveway is when the police officer had Miss Martin on speakerphone where she was screaming. I heard it myself at the police officer for not filing a police report, insisting that a crime had been committed. I stood there and listened, and I said, Brianka, again, this could have been a phone call. We could have just talked. If you had a concern, immediately Brianka hung up on the police officer. And police officer said, ma'am, I don't see any evidence of anything that she's saying here. And he then left.
Now, when was the access to the pen when did the access to the pen actually occur? Was it September 30th of 2025?
It was end of September 2025, but we did not receive any notice that the pin had indeed been found. At least the first I heard about it was at the end of October 30th, 2025.
And that was because the fence had to be dismantled in order to get to the survey pen?
That is correct.
Or at least that was your understanding, right?
Yes,
Okay.
that is correct.
Now, what occurred in February of 2026
February of 20.
when your roof got damaged and Shingle
Yes,
Pro had to
yes.
come out?
So there was another storm that came through, and my roof was punctured due to a falling limb from the tree. We have pictures that show the perspective of the tree from the house. That is the only tree that actually is at the angle that would do that damage. And what happened was the roof was punctured, and once again, we had water damage into our primary bedroom. So the places that the arborist said were in danger, indeed, we've got more fall down from that. And so I hired a roofing contractor to come out, repair the roof, and then we had to have some interior drywall repair and repainting of a ceiling to remediate the damage.
Okay, and Exhibit K is that exhibit which shows that estimate or that invoice which shows the cost $1,075, right?
That is correct.
And you had to pay for the tree inspection that occurred on March 3rd as well.
That is correct.
And that invoice is in the evidence, but that was $425, right?
That's correct.
Okay. So when did you actually obtain or see for the first time this Exhibit N, which is a save a tree estimate for pruning back the tree, which was $1,300, the Exhibit N?
Oh, incredibly recently. I would say within the last couple of months, it was presented to me. I was surprised that Ms. Martin even got the estimate. I didn't understand her intent there.
Okay, so we're getting short on time, so I'm going to go ahead and ask you the last few questions here. When you look back at this entire neighbor dispute, is there anything that you would have done differently?
I believe that I treated Bianca with fairness, with respect the whole time. I tried to understand the situation at hand. I was biased to action in terms of following up on everything. I put multiple settlement offers on the table. I left the door wide open to conversation with her, and that is something that I never, ever received. It was never reciprocated. At any point, we could have had a conversation. This could have been over April 24th, 2024. Instead, here we are 2 years later in Fulton County taking court time to do this, which I will never understand.
And did the only thing you really wanted was to prune the tree back?
The only thing I ever wanted was to prune the tree back. And honestly, after we put the notification in their mailbox, I was done with the matter. We could have had a glass of wine after that, just like we did with our previous neighbors.
So what would you like the court to award here, as far as you're concerned?
Yes, I would like the court to award my attorney's fees for certain. We did not have to go here from moment one. I said, let's talk. Why are we going through attorneys? I've spent tens of thousands of dollars defending this lawsuit after putting multiple offers on the table. She never had to retain an attorney, not once. That was never a requirement. There was nothing in my conduct. There was nothing in my behavior that said, yes, you need to lawyer up. So I would like the return of my attorney's fees because this has been a long road. I just want to say, I have a communication to my lawyer, King Buttermore, where I say, I want to express candidly but respectfully that I'm struggling to understand the expectations at this point. It appears that Bianca continues to delay and sidestep obligations in her own lawsuit. We push back in the moment, yet the burden repeatedly returns to us to fix the situation, requiring us to rearrange our schedules to accommodate her missed commitments. She maintains a regular work schedule. Meanwhile, I balance a demanding job, serve on 2 boards, and travel frequently. Even so, I have worked hard to remain flexible and to uphold my responsibilities in what has become a remarkably petty situation of her own making. Her repeated delays continue to interfere with my ability to participate effectively in my own defense, while she seems able to dictate timing entirely on her own terms. I am simply sharing the reality that her ongoing reliability has had meaningful consequences for me, professionally, personally, and logistically. Her delays have affected my work schedule, required unexpected time off, disrupted our home life through unannounced visits from individuals she has hired, and generally imposed burdens that she herself does not seem to experience. It fits a consistent pattern over nearly 2 years. I sent this last fall to King Buttermore. From missed communications by her counsel to her own failure to meet obligations, it is difficult to understand how there can be no remedy or consequence for such sustained documented behavior. And as a result of that, I do believe that I am due my attorney's fees, and I just want her to enjoy her home in peace.
Thank you. Your witness.
Thank you, Your Honor. Good afternoon, Mrs. Thomas. My name's David Klein. We never met in person. Good to meet you, though, here today. I do have some follow-up questions for you here, and I'm going to be putting exhibits up on the screen. So if you need me to zoom in or anything like that, just let me know. I want to start out with an affidavit that you submitted in connection with this proceeding. And give me 1 second. Okay, can you see that okay?
I can, yes.
All right,
thank
so
you.
this is Defendant's Exhibit J. And I want to go down to, this is your affidavit, is that correct?
That is correct.
Okay, and this was submitted February 2nd of 2026?
That's correct.
Okay. Under paragraph 5, can you read that first sentence to me?
The subject fence as constructed prior to the sale of the Martin property to the petitioner is shown in the exhibits attached hereto, marked as Thomas Exhibits 1 through 6. These pictures are true, just the first sentence?
Yeah, just the
Okay.
first sentence.
Mhm.
And so I'm going to go down to this first exhibit here, the Exhibit 1.
Yes,
So this is what the fence looked like at the time prior to the purchase of the Martins' purchase of their house. Is that correct?
that's the fence as it was constructed. Yes.
Okay.
It was there when they bought the house.
And your testimony previously was that this side fence here that's connected to your fence, that Miss Martin put that in. Is that correct?
The previous owners never did any improvement, and so yes, Ms. Martin put that in.
Okay, but you're saying that this, in this affidavit, that this is what it looked like at the time the Martins purchased the property?
No, I'm saying what the straight fence, so the one with kind of the grass stain at the bottom is what it looked like at the time they purchased the property, not the connecting fence.
Okay. But again, paragraph 5 says the subject fence is constructed prior to the sale of the Martin property. Strike that. You indicated that you're both sorority sisters. However, you went to different schools, correct?
We did.
You didn't know each other before Miss Martin moved in?
We didn't.
All right, I now want to go to Respondent's Exhibit 2. And I want to scroll down to that March 27th letter
Yes.
that was attached. So here's that letter, is that correct?
Yes, that's the letter.
You and your husband wrote that letter and placed it in the mailbox of the Martins?
We sent it via FedEx so that we would have tracking to demonstrate if there were damages that we had notified them officially.
Okay. And did somebody help you and your husband write this letter?
They did not.
So I want to read the first sentence of this third paragraph. It says, according to Georgia law, if properly notified, it is the responsibility of a property owner where a tree is rooted, especially if the tree is identified as being diseased or dead by an arborist, to take financial responsibility for damages done to the reported property. Where did you get that information from?
We moved from California to Atlanta in 2017 and brought our home in 2018.
Okay.
And through the dealings that we've had with trees with our previous neighbor, we educated ourselves on what our responsibility was and what our neighbor's responsibility was and how we could protect ourselves. In addition, behind our home, there was a large tree that went from not the Martin side, the other side, and fell across the back ravine and hit a house on Peachtree Dunwoody. And so that was incredibly scary to us, given the history of our home being bifurcated into the previous home. So we did our research, and it was that's our understanding of what Georgia law was. So it was independent research.
All right, this last sentence of that same paragraph says, however, allow this letter to serve as notification that going forward, unless this tree is properly addressed, paying for damages caused by this tree will now transfer to the Martin household. Do you remember writing that?
My husband wrote it. I remember reading it. Yes.
Is that a fair and respectful way to treat your neighbor?
Absolutely, especially since when I first notified her of the tree damage, I said, look, we haven't talked about this. I'm not asking you for anything at this point because that wouldn't be fair. But at that point, she had committed to talk to us about the tree, had not followed through, then had other tree work done on our property and had not followed through to do anything about it. And so I think it's well within our rights to ask if there's any further damage going forward that she address it. This is not anything outside of what's required by the law. I actually think that this is a courtesy to let her know, just like she knew to expect this letter, to say, hey, going forward, we tried to do this with you. And so we have to. I don't want to do that. I would have rather had this resolved.
And this last sentence in the last paragraph, it says, unfortunately, he, the sellers, sold you the house without addressing the tree, therein transferring the liability to address this to you. You think that's fair and respectful to say that to a neighbor?
I think it's helpful. And this is the reason, because again, they had lived in the house for less than a year. They would have been within their right to go back to the previous homeowner and say, you never disclosed this to us. So please give us $1,300 so we can cut back that tree. I would have provided any support or documentation that the Martins needed. I was prepared to be on their team. That's demonstrated in the February 2nd or 4th text. I said it back then, and I'm consistent. And that is one thing that I have been consistent and biased to action through this whole thing, and in good faith tried to protect ourselves and tried to even help the Martins out with this issue.
So you want to be on her team, but you're talking about damages and transferring liability to them.
To the previous owner, absolutely.
Okay.
That's being on Bianca's team, absolutely.
But talking about damages caused by the tree are now going to transfer to the Martin household. That's being on her team?
That is also, that's being on her team. I would want that heads up. It's more than I got from you all before you filed the lawsuit. I didn't even get a heads up saying the lawsuit's coming.
Do you see how somebody could take this as a legal threat where they have to go and obtain counsel?
I don't. I will never comprehend that, sir. I'm sorry.
Okay, that's fair. All right, so I want to go to my letter now that was sent. We'll pull that up. Give me 1 second. All right, this is Exhibit P1. Do you recognize this letter?
I do, yes.
Okay. And in this letter, we inform you that a survey had been completed and we attach a copy of that survey. Is that correct?
That's not how the copy looked that I received. It's much bigger, but yes, in essence, that's correct.
The copy was much bigger?
No, this is much bigger than the copy that I received. It was very illegible, the one that I actually received in the mail.
Okay. And within this letter, I'm looking at the second paragraph, about halfway down. It starts with, the survey is accurate. However, the survey was unable to access an iron pin located in the northwestern corner of the Thomas property, which is your property, due to the fence. And then I say a copy of the survey is enclosed, which shows your fence encroachment.
I see that.
Do you recall reading that at the time?
I do.
Now, you responded a little while later, which is Defendant's Exhibit 2 that we were looking at previously. So you responded via Federal Express to me. Is that correct?
It was within a matter of days.
Sure.
Yes, not
I'm
a
just
little while, yeah.
trying to say you did respond to
I
that
did.
letter.
This is my letter,
Okay.
correct.
And what exactly are you saying in this letter?
I am asking, well, first of all, I am saying, hey, this is the first time I'm hearing about this. So establishing that I had no prior background to really absorb or understand the letter that you sent to us. I'm also saying, to your point about looking out for your neighbor, this is not the tone that we have set with the Martins. We've always been open and accessible to them. And so I'm surprised that we're here. And it then goes on to list a series of questions that I had about the letter that you had sent. And it also makes you aware of the tree situation because that was never discussed or ever addressed in any of the communications that you sent with us. So I thought it was important to make sure that you were aware.
And I think it's page 4 and 5. Here are those questions, right? It's like
Correct.
1 through 10.
Yes,
Okay.
correct.
And in this letter, you didn't provide an email address or any kind of phone number to reach you, right?
I did not.
Now, if we go to the second letter that I sent, let me just pull it up. This is Respondent's Exhibit 3. And do you recognize this letter?
I do, yes.
Okay. And I answer your questions 1 through 10. Is that correct?
Yes, you provided responses, yes.
Okay. And again, here I say, we look forward to hearing this from you soon. Again, if we can communicate via email, that would speed up this process. Here's my email.
That's
right?
correct.
And you never communicated with me via email. Is that correct?
I exchanged letters with you, but not by, let me just provide context there. I have 3 different jobs. I have 3 different email addresses. I get no less than 100 emails in each of those email addresses every single day. This was of utmost priority to me, and so I did not want to risk that falling to the bottom of my email inbox. I travel extensively. The way that I manage my life, sir, is that I'm very methodical. Things come into my desk, they get placed on my desk, and I deal with those letters expeditiously. And so this was my way of making sure that I never missed a communication from you all, because that's why I expressed the frustration that I did in my letter to my attorney saying, I'm quick with it. Why are they delaying? I don't understand why this is taking so long. So it was an interest to make sure that these things stay in front of me, front and center.
And I just want to look at number 7 here, the question I'm responding to. So again, I say, can you give me your email address? You were questioning the survey because you
Yes.
couldn't increase the size of it, right?
Yes.
And I wasn't able to provide you additional copy because I never received your email address. Is that correct?
I don't know why you couldn't provide me additional copy. There are lots of ways to do that.
Right.
And I would have loved to receive a FedEx with an enlarged copy again. So that would have prompted me to say, thank you, Mr. Klein. I've received your copy. I appreciate that, like I did every other communication that you sent me.
Number 8, you asked, one of your questions was about the stakes that were placed on the property boundary line. Do you remember that?
Yes, the ones in the front that Brianka testified to, yes.
Right. So you were aware of the stakes as of when?
I was aware, I'm not exactly sure the exact date. I can't testify to the exact date that I was aware of the stakes. I truly don't remember.
It would have been before the lawsuit was filed, right?
I'm saying it at the time of the letter. I can't answer that question with any specificity.
It would have been at some point, at least as of June 20th, 2024, that you knew stakes were on the property.
I can testify, yes, that I say it in the letter, but I can't give you a date that I could provide sworn testimony about.
All right. And then also under number 4, we provided you information about the survey and when that field date took place on February 21st of 2024, right?
That was in response to my question saying the date on the survey was 2013. So yes, that was in response to that question.
And at any time after my first letter or the second letter, you did not allow access to the property and you did not remove the fence. Is that correct?
That was not at hand. At that point, I was trying to understand what we were talking about so that I could figure out the best plan forward to move this forward expeditiously. I said that over and over again in every communication. Not only that, in every communication to you, I had said, hey, I'm shocked that we're still doing this. I am available to speak to Ms. Martin. That would have been the quickest way to get this done.
And you responded to the letter we just looked at from the June 2024 letter from me to you. You responded on July 25th of 2024. Is that correct?
Yes, that's correct.
And this is Respondent's Exhibit number 4 that I have pulled up here.
That's the one.
Under number 1, you say the Martins may not have access to our property to validate an assessment that they have updated multiple times. There have been multiple assertions about the validity of their survey. This should be sufficient for them.
Yes,
You did say that in that letter, right?
that's what's written.
So as of July 25th, you were not allowing access.
As of July 25th, I made that statement, but then I go on to tell you what I'm going to do.
Okay. And you said that you were going to get a survey, an independent survey.
That's correct.
All right. And you never got an independent survey.
I began the process of getting an independent survey and doing my research. Sadly, before I could finish that process, I was served with a lawsuit with the extensive travel, with the board meetings, with trying to manage this from other time zones. I was working as quickly as possible. My hope would have been that I got a follow-up to say, hey, how's that process going? I never got that. I would have even committed to a date to you if I had had that communication. Again, communication has always been open on the receiving end, like never reciprocated.
This letter, though, says that you're going to go and commission an independent survey and essentially get back to us, right?
It said I was going to commission a survey.
Okay. So whose court is the ball in at this point? You say you're going to go get a
I'm
survey.
taking action. I've testified as to the action that I took.
But we didn't receive any further correspondence in August, September, or the beginning of October. Is that correct?
I was making steps there was nothing to share at that point. I was making steps. I told you I reached out to the surveyor. I got 2 different quotes. That happened from Zurich, Switzerland. Then I followed up with another source and got some information, had conversations from Paris. That was not fruitful. I then understood that I then remembered that I had other physical documentation at my home that I can't access from that point in South America. At that point, then I went to Detroit for a business trip. At that point, I went to Scottsdale to handle a medical situation. And so had you reached out to me, I would have said, hey, I got one last step. I'm going to look at this survey. And then just like I say in points further down, we can have, I said, before I can even consider this, I have to be able to do my own research. And it's amazing how the clock runs super fast when it's in my court, but you guys can sit on an access agreement from February to May of a certain year and not do anything. It's incredible. It's incredible.
Okay. This is the first time that our side is hearing about you being in Zurich and trying to get a survey, potentially from 2 survey companies, right? This is the first time we've heard about it. There's nothing in writing that ever said that.
That I have in writing that what I was going to do. Yes, and I did it.
But to us.
It's my testimony that I did it. Yeah.
Correct. But at this time, you never told us any of that.
I told you that I was going to get a survey done, and I took steps to do that. And also, I believe I took steps to do that. I know the company that I reached out to, I've got evidence that I did that.
Even though you've reached out to 2 surveying companies, you've never hired a surveyor to perform a survey on that side of your property, correct?
It wasn't necessary because then I said, hey, let's just forget about the surveys. I'll move the fence. You cut back the tree. Why would I at that point? I'm offering you guys actually a better deal to say, let's just cut this whole survey nonsense. I'll move this. You protect my family by remediating the tree. We don't even have to do all of this. That is in November through Melanie Nealis, to which you all never responded.
I'll get to that part in a second, but when did you actually remove the fence?
We removed the fence January 2026.
When did you remove the other encroachments other than the fence?
So the shrubbery was pulled up. I'd have to look. So the AstroTurf was removed this week. Just about that. The boundary line, the full boundary line was never established. And so we called multiple companies to say, hey, can you come back and pull back the AstroTurf? They had 2 questions. Number 1, back to where? Can't answer that question. And number 2, it's such a tiny job that they weren't interested in it. I don't have the tools to be able to do it. So that is what happened with the turf. The shrubs, somewhere between March and April, but everything was open, and it took like one flick of the wrist to pull up the shrub. So it was available to Ms. Martin. When we discussed mediation, we said, hey, you're welcome to do, we won't
Right.
hold you.
Your Honor, I want to object to this. This is settlement negotiations after the counterclaim was filed.
All right, let's move on.
All right. Let's go back to this email from Ms. Niels, okay?
Yes.
Defendant's Exhibit 5. How do you know Ms. Niels? Is she a friend?
She and I met, we worked at the same company, and she's an attorney. 20 years ago, we worked together.
And she's in-house counsel for a company up in Ohio, is that correct?
She is not. She has her own firm.
Okay, but she lives up in Ohio?
She does not.
Okay, where does she live?
She lives in Florida.
Okay. So here's that settlement offer that was made November 18th of 2024, is that correct?
Yes, that's correct.
So this settlement offer is talking about, it says, in exchange for my client's request that your client hire a professional tree service to trim the offending tree, parenthesis, to the satisfaction of an arborist to be retained by my clients, no later than February 28th, 2025. How do we know what this arborist is going to say?
I'm not a professional. Ms. Martin has testified that she's not a professional. So I think it's reasonable to want a professional opinion to say the danger has been mitigated. I can't answer that question.
And then this offer was open. It was made on November 18th and it was open until November 22nd. Is that correct?
Yes, that's
All right.
correct.
So that's 4 days.
Yeah, yes,
All right. So it remained open for about 4 days.
that's correct.
Now, if we scroll back up, here's an email from Ms. Nealis, November 22nd, 2024. She says, following up on the settlement offer, is there a response? Correct?
I say that, yes.
All right. And then a couple days later, I responded, not yet. I need to speak with my client on the phone. I'm going to try and connect with her tomorrow. Thanks.
Yes,
Correct?
that's correct.
And then that same day, less than an hour later, she just says, well, they have new counsel. Correct?
That is giving you all the information you need, absolutely, to be able to move it forward.
Okay. But by this point, the offer had expired because it was 4 days, right?
Yes.
All right. I want to talk about the original fence construction. When was that built?
The original wood fence, the one that Ms. Martin attached to?
The fence that you built, I believe, in 2020.
Yes, that was constructed about summer of 2020.
Okay. And did you hire a surveyor to locate the property line?
We relied on Fence Works of Georgia, which is a professional fence building company, to manage the entire project. So they handled it from start to finish.
So no survey was obtained?
As far, you'd have to ask Fence Works.
Okay, but you're not aware of any survey?
I'm not
being-
aware of anything.
Okay. And did you have to get a permit for the fence?
I relied on Fence Works for that, but I can say, so shortly after that, we had a trash pad, like just something that makes it really easy to roll our trash cans out, done by our current landscaper. And and they told us that surveys weren't needed. We actually sit in City of Atlanta. We're not in Brookhaven. And that provides a lot of benefits in terms of not having to have a survey for small projects like that.
Okay. When was the grading work and the artificial turf and the bushes installed?
The bushes were original landscape to the house. So we were very lucky to move into something that had a really great landscape foundation. The turf was done the turf was installed. DJ graduated I would say in first quarter 2023.
Okay. Did the turf involve grading work in your backyard?
I don't know what grading work is.
Like removing dirt and trying to level things out?
No, it was already pretty level, like the landscaping was done.
So just artificial turf was put down on existing dirt?
Yes.
Okay. Did you have to obtain a permit for that?
We hired David Lovett of Garden Craft and he handled everything. So you'd have to ask him that.
All right. This was another document that was showed to you, I believe, on direct examination. It's marked Exhibit P13.
Yes.
You indicated that, well, first of all, were you ever aware of this?
No,
Okay. Have you ever talked to John Bedson?
I don't know who John Bedson is.
Have you talked to anybody at the City of Atlanta Code Enforcement Department?
I don't know.
Okay. Do you recall anybody coming out to your property on or around June 10th of 2024 or June 12th of 2024?
No, I travel so much. I might not have even been home on that date. I have no idea.
Gotcha. All right, I want to move on to the tree. So when you moved into the property in 2018, the tree was already there, the subject tree.
Yes, sir.
It was already overhanging onto your roof, is that correct?
Yes, that's
Okay.
right.
Was it causing any issues when you moved in 2018?
It's caused us consistent issues since we've moved in.
Okay.
Yes.
And in 2018, did you contact your neighbors at that time about it?
We contacted our neighbors as soon as we had the first issue with limbs falling down. Yes, that's correct.
Okay. And what was the discussion you had with them?
This discussion was saying, hey, this tree is on your property, the limbs are overhanging. It hangs over our primary bedroom suite. It hangs over our driveway. It hangs over our side yard. And it's caused damage and it's punctured at this point the roof. And, would you be willing to remediate that for us?
Okay. And did they trim the tree?
They did not trim the tree, but they directly paid for any repairs that happened. I did not have to spend a dime out of pocket. They hired the contractors, did a lovely job, and we had a great relationship with them.
Okay. Did you ever ask them to trim the tree?
I did,
Okay.
yes.
What was their response to that?
They did not respond either.
Okay.
But
Was that a certified letter that you sent them?
It was a certified letter, yes.
He's kind of cutting her off on her answers. I would object.
All right, you can let her finish her answer.
Sure.
Yes. Yes, I did send a certified letter to them.
When did you send that letter to them?
I don't know that I can testify to an exact date. I believe it was 2 communications because we did both neighbors at the same time. We sent a certified letter of our own accord, just writing to say, hey, we've got concerns about the tree. But as we did the research on tree law, then we were like, oh, we're supposed to attach like some sort of professional opinion to this because it can't just be our own personal opinion. And so we sent a second communication.
Okay. And that would have included the peach tree arborist report that was obtained in 2021?
It would have included the arborist report, yes.
You said you sent a certified letter to another neighbor, is that correct?
Yeah, the neighbor on the other side, because there was a tree also pointing to our house as well.
Since you moved into your property in 2018, how many certified letters have you sent out to neighbors?
That's it.
So 4?
No. We sent, again, let me just be clear. I wrote a letter myself saying, hey, I'm concerned about a tree that is overhanging our yard. And I understand I'm supposed to give you notice. Here it is. Thank you so much. I appreciate it. I sent it to neighbor left and neighbor right. Okay. Then as we were, moving forward, I realized that that was not sufficient. And so I sent FedEx to, actually the tree that was on the other neighbor's side was remediated through our construction project. We were able to do that, but we were not able to do the other side because it was on the Martins property. So that's when we followed up with the FedEx. So if your question is, are we just constantly badgering our neighbors with certified letters? Absolutely not. We've got great relationships with everybody on the street, except for the Martins.
All right, so the 2021 arborist report, which went with a certified letter to the prior owners of the Martin property,
Yes.
they didn't respond to that?
They did, well, they did not respond directly to it, but they were available if ever we were to want to come over to their property and have a discussion. So the same open door policy that we offered to the Martins very much applied, and we had a cordial relationship. And they remediated damage that their tree had made to the property, which is more than the Martins have ever done over the span of these couple of years.
But yet from 2018 all the way up until now, nobody's ever just trimmed that tree, right?
Nobody's ever trimmed the tree, no.
Okay. Do you agree with me that you could have trimmed the tree?
I don't, because Ms. Martin has proved to be very litigious.
What
And-
about prior to 2023?
She can finish that answer.
Yes. Because Ms. Martin has proved to be very litigious. And we've offered, perhaps that could have come up in a conversation with Ms. Martin if she had acted on any of my various attempts to say, the door is open, let's speak, let's be neighborly, let's not involve it. I wish, sir, you seem like a very nice man, but I really wish I wasn't talking to you. I wish I could have talked to Brianka directly and we could have just resolved this.
Understood. Why couldn't the tree have been trimmed by you between 2018 and when the Martins moved in 2023?
Well, because we had already, per our understanding, tried to, because we had already informed the neighbors of their responsibility, so it wasn't our liability. We were trying to follow the letter of the law. I mean, it wasn't our responsibility to trim it. It is squarely on their property.
Okay. I want to pull up an inspection report that y'all had done about a month or two ago. This is Defendant's Exhibit L, treeinspection.com. Do you remember these arborists coming out?
I do.
Okay. And this report indicates that the tree is healthy. Is that correct?
Where are you saying? Can you show me directly to where?
Sure. So let's see here.
There it is. Bullet point starts with discussion.
All right. So observations, the tree has a good structure. Saw no signs of fungal activity. There are some dead branches. None of the other drills, including on either side of the decay pocket, indicated internal decay. Generally, this report here is saying that the tree is in good condition. Would you agree with me?
No, that was never our concern. It's the branches, and Brianka even said herself, it is the dying limbs, it's the dieback at the top of the tree that has always been the issue. It was very kind of this man to do a full assessment of the tree, but what has never been a disputed fact is that the top crown, which is hundreds of feet up in the air, where the limbs are at least this big in diameter, have been an issue. So that's great ancillary information, but it still does not negate the fact that the tree needs to be addressed.
Okay. These branches hanging over your side of the property, right?
Yes, sir. Hanging over our home. Yes,
Okay.
absolutely.
And again, you've made no attempt to trim those branches yourself since 2018. Is that correct?
The liability, the responsibility to trim the branches has always been on the neighbor's side.
All right, and that's your position on that. That's what your belief is.
That's what our research about Georgia tree, especially since we've notified the neighbors. I wish, again, if we could have had a conversation directly with the Martins on the various occasions that we offered them a conversation, we could have had that conversation. But how do you negotiate with someone who won't speak to you? It's very expensive for Ms. Martin for me to talk to you.
And I want to pull up the exhibit here. Give me 1 second.
Oh. It's in there?
Okay. Sorry, bear with me one second. I'm sorry. Got it. I'm going to pull up what's Respondent's Exhibit N. This is in your exhibits, and I think you were questioned about it, correct?
I was questioned about, yes.
You were asked about it.
I was asked if I had ever seen it, and yes, recently I've seen this.
Okay. And this here, so this was prepared for Mrs. Martin, correct?
That's correct.
All right. And it was prepared last March, correct?
That is March 13th is what it says.
Okay.
Yes, 2025.
And this here says, job assumes permission granted from neighbor to access driveway to set up. You see that?
That's what it says, yes.
So at least according to this proposal, they would have to access your property to trim this tree. Is that correct?
That's what it says. I don't have any broad knowledge of what it would take.
Okay. Have you ever obtained a proposal to trim the tree?
That has been the responsibility of the neighbors ever since we notified them. I don't know why we would do that.
All right. Have you, so the answer to that is no, you've never obtained a proposal like this one we're looking at?
We've not. What we have done is paid for extensive damages, though, so we've spent our fair share of money.
All right. I want to pull up your Exhibit K, which is this Shingle Pro invoice. You've seen this before, is that
Yes,
correct?
that's correct.
All right. And when was this obtained?
This was obtained March of this year. That's when the storm came through and we had the puncture on the roof. And that was the invoice that we paid to have that repaired due to a falling limb from that same tree.
Okay. And there's a text message between you and the roofing contractor, is that correct?
No, this is the person who did our interior work.
Okay.
Yes,
So these are two separate things?
two separate things, yes, totaling $1,075.
So you asked her to break out some of the damages for the 2,500. You say of the 2,500 that I paid, how much was for the ceiling, drywall repair, and painting?
Yes,
What other items did you have worked on in your house?
we had some more painting done on the interior of our house in the basement.
And this says I have to send a bill to the lady next door for the amount that I paid you to repair the ceiling. Is that correct?
That's right.
Is that referring to Mrs. Martin?
It is, yes.
And then also you say, please answer soon because I need to send this amount to my lawyer. Is that correct?
That's correct.
All right. I now want to look at some more of the affidavits that were submitted in this case.
Okay.
All right. I think we've already looked at this one. This one was Defendant's Exhibit J. And this was your affidavit signed on February 2nd of 2026. Do you remember that?
I do.
All right. At paragraph 6, can you read that to me?
It says the subject fence and any alleged encroachments are removed. See photos depicting property as it currently exists attached here too.
All right, and at the time that you made this statement on February 2nd of 2026, that was false. Is that correct?
No, that's not true. Again, we did not have a full boundary line. We still to this day have some sort of pin that we can't see in the back and a stake in the front. So to the best of our knowledge, based on, the distance between, a connecting point between two lines can be any infinite amount of ways. And so we had no idea between those 2 points where, again, like I said, when I contacted people to help remediate the issue, I could not tell them where to pull anything back to. So at that point, based on our understanding or our guess, frankly, of where that line was, we had done everything that we could. And still to this day, I would say, I'm not quite sure, because we keep pulling things back, pulling things back, pulling things back. And it's always something more. It's always another step that we have to do. We even took the extra step when we took down our fence. So, because the request was to move the fence, we said, we're just going to take it down because we don't know where else to put it. And we actually came in further into our property because we just didn't know what to do. We spent $2,500 on that fence, and we've essentially taken the full thing down because we don't know where it belongs to this moment.
Okay. I want to look at your third affidavit that was submitted in connection with this matter. This is Defendant's Exhibit A.
Yes,
Is this your signature here?
it is.
All right, and this is dated March 30th of 2026, is
That's
that correct? And if I can go to paragraph 7, if you can read this paragraph for me.
Yes, I can. Since my first affidavit, it was brought to my attention that 2 bushes and around a foot of AstroTurf backyard extended into petitioner's yard now. That goes to the point of, I had no idea where the boundary line is. However, as there were no flags, no string, nor any other markers left by petitioner surveyor in the middle of the yard, I could not ascertain the exact new boundary line between our yards in order to remove these alleged encroachments.
All right. You were always aware, though, that we alleged that artificial turf, bushes, and fence were encroaching on the property, correct?
My main concern is, where's the boundary line? And I never received that information. I was aware that there were alleged encroachments, but again, limited communication between Brianka, myself, you all. We were not having detailed conversations. So that level of specificity was never discussed directly with me. All I've been concerned with is trying to figure out, well, I wasn't even concerned with figuring out where the boundary line is. All of this activity with finding this pin, with all of this back and forth, with shrubs, with none of that had to happen because, again, in November 2024, we put a settlement offer that would give her what she wanted. It could have been done even before that, as you guys know, because I offered a chance to speak. So
How could you give a settlement offer in November? Number one, it was with 4 days expiration, correct?
we wanted to get it done quickly. And this was a friend of mine trying to resolve it. I was like, there's no way she's not going to agree to both of us just fixing these issues.
And we also had no idea what some arborist was going to come out and say, correct?
We had no information at that point, but I was just ready to solve the issue and settle.
And by that
My own
time,
detriment, I would say.
and by that time, we had already filed a lawsuit in October of 2024, about a month before that, right?
You filed a lawsuit, that's correct.
And we filed the lawsuit about 3 months after last hearing from you in July of 2024, correct?
Without communicating to me to say, hey, where are you at? Absolutely. I think that that would be a great step for you guys to take because it wouldn't have been necessary. I mean, if Ms. Martin really wanted to save attorney's fees, if I was in her position, I'd have said, hey, check with them one more time, see where she's at. Because she made a commitment. She's followed through on every single other commitment that she's made over the course of this time. We have no reason to believe that she wouldn't. So see where she's at.
But again, I didn't have your email address or phone number,
You
correct?
had a way to contact me. Absolutely, you did.
By
You had a
Federal
way-
Express.
You absolutely, 100%. There's next day air. That's a 24-hour endeavor, sir.
I want to go back to another point. You had asked, or sorry, you had said that even today, your position is you're not sure where that boundary line is. So since October of last year, when we heard testimony that there's now a pin where it should be in the far corner, is that pin visible in any way?
I can't see it. I've actually never physically seen the pin. We just went when her survey came by and said, hey, we found it. We said, okay, great. And that's when we agreed to move the fence.
So, other than them telling you in October that the pin's now in the ground, what is the difference between what you know from the time the first survey came in and that initial demand letter, and then the one that was much later in October 25? Really visually, or, did your knowledge actually change at all between those two surveys?
Did my knowledge change between those two surveys?
And that, again, poorly phrased, but so the first survey that comes in early 24 says that it attaches that diagram, as I understand it, in P3, but they haven't put the pin in the far corner. And you have some questions about how do surveys work, what's a pin, et cetera. And then you ask for an access agreement so they can come back and confirm things. Now that they've come back since October and say, you confirmed that the pin's in the ground, is there really any difference in terms of what your knowledge of where exactly the point is, of where the line is?
I see what you're asking. No, but we were just responding to their request because they themselves said that this wasn't final until they could locate the pin. And so at that point, it's final, and we said, sure. And also to that point, we had the fence down by the end of January. If you look at the first settlement made by Ms. Nealis, what I said to her is I want to give everybody adequate time to remediate their side. And so we gave until, I think in that offer, we said by February 28th of the following year. So as soon as we had that information by which they said that they would consider their analysis final, we acted even more quickly than we gave ourselves time in the first round to take that fence down. Again, I think it's the thing I keep coming back to, Your Honor, is we never even had to go through these paces because we weren't even requiring, that was their requirement the whole time to come and find this pin. For us, we were ready to act.
The only other question I have is at the time this settlement offer was made in November of 2024, you hadn't incurred any attorney's fees at that time, right?
Up to this, as of November 2024, is that?
When Ms. Nealis made the settlement offer?
I paid her $500 to do that. So that was the first attorney's fees that I incurred at that point. Yeah.
Okay. And your settlement offer didn't make an offer to reimburse Ms. Martin's attorney's fees that she had incurred by that time, correct?
Why would it? I never wanted to talk through attorneys. That was her choice.
No further questions, Your Honor. Thank you.
Mr. Miller? All right, you can step down, man.
Thank you.
All right. Again, you need a few minutes to clean things up, that's fine, but I feel like we're starting to repeat points and that sort of thing, so I understand the point you're making. All right.
I had planned to call Ms. Nealis by Zoom, but now that the emails have been admitted, Exhibit 5, the defendants, we're just going to stand on those emails. They've all been admitted. So.
I don't know what her testimony would even add, other than just
testify just to the emails, so no need.
Okay.
But we'll call Cedric for our last 3 minutes, 3.5
That's fine.
minutes.
Take up 1 or 2 more than that, but that's fine.
What points of testimony about this case?
Yeah.
David. Thanks.
I swear.
I'm speaking to you.
Cedric Thomas, CEDRIC THOMAS.
Okay, let's get right to it because we only have 3.5 minutes. Tell us about the conversation you had with Keith back in, what was it, March 23rd of 2024?
Right. So I was coming in and he was, I think, inspecting trees that they had just cut down in the front yard. And so since I had noticed they had cut trees down in the front yard, I wanted to ask him what they intended to do about the tree in the backyard, which continued to drop limbs.
Okay, and tell the court about the conversation. What was said? What did he say? What did you say? Those sorts of things.
He basically stated that he was going to have an arborist take a look at the tree, and he kind of like blew me off based off of my own observation.
Okay, did he say when he would do that?
No,
Did he ever do that during the following, what, I guess, week
Not
after
to
the
my knowledge.
23rd?
not to my knowledge.
Okay, then did you author this letter, which has been entered into evidence as, I believe it's G1?
Yes, I did.
Why you did that?
I authored the letter for actually 3 reasons. So one is we just had a storm and we just had damages that we had to pay for the house, and we were tired of paying for damages related to a tree that wasn't in our yard. 2 is, as my wife said, we've seen large trees cause mass destruction to homes before, and also saw the anguish of the owners of these homes having to deal with insurance companies just to get the repairs done, and we didn't want to be in that situation. And 3, primarily because we served the first owner with a letter, and they seemed to be somewhat responsive, and I just didn't feel like I had any other choice.
Okay, and did you consult an attorney in order to write this letter, which is identified as Defendant's Exhibit G1?
No, I did not.
Did you have Brandy look over it?
She reviewed it.
Okay, and did you receive any kind of response from this letter?
No.
Now, what would you like the court to do here, Mr.
Well,
Thomas?
so this is a situation where I agree with my wife. We don't have to be here. We didn't have to be here, but we obviously had to defend ourselves. We spent tens of thousands of dollars in legal fees over the last 2-year period. So I would want to have that reimbursed to us, as well as the damages that we reported related to the roof. And the third thing is we would like to have the tree pruned back or taken care of so that we don't have to continue to experience these damages every time we have a storm.
That's all I have, Your Honor. Thank you.
Again, David Klein. We haven't met before. Nice to meet you today.
Nice to meet you.
Just a couple very brief questions. I just wanted to see, did you disagree with any testimony that your wife gave today?
No, I do not.
Okay. And then did you know about the stakes with flags on them since 2024 that were on the property boundary line?
I've seen the stakes, but I can't recall when I first noticed them, though.
And you guys have not hired a surveyor of your own to perform a survey, at least on that side of the property. Is that correct?
No, we did not. We looked into doing so twice, and then we also I thought that we would have to get a surveyor once we had some other construction done, but that didn't have to happen.
Do you dispute the surveys, the 2 surveys that we looked at when the expert, Mr. Berhard, was up here? Do you dispute anything in those surveys?
No, I do not.
No further questions, Your Honor. Thank you.
Any redirect?
As far as those surveys go, did were you aware that the survey was not completed until October 30th, or it wasn't delivered to us until October 30th of last year?
No, I was not.
That's all I have. Thank you.
Thanks.
All right, anything further of Mr. Thomas? Mr. Miller?
We would rely upon, as I said, Exhibit 5 for the testimony of Ms. Needles.
All right, sir, you can step down.
Thank you, sir.
defendant.
All right, any rebuttal on behalf of the petitioner?
Yeah, Your Honor.
Okay. At this time, we'll consider the evidence closed. And we can get more into substantive and legal arguments here. I mean, I would say it might be more helpful to go kind of claim by claim and then rather than just one catch-all argument, if that works, and I'll continue my habit of interrupting if y'all can bear with me. Just so I can direct to the points that I think are more pressing. So I'll just jump right into it, and you can stay seated or you can come to the podium, whatever you prefer. But count one on injunctive relief, as indicated in the order on summary judgment, Mr. Klein. How do you respond to that statute? And generally, how equity is not supposed to interfere with trespass unless you talk about trespasser who's insolvent or circumstances showing that we're going to be back here, next month to do this all over again. How do you overcome that hurdle?
Well, again, I mean, I think we've seen a pattern here. First of all, I don't even think that this is an issue necessarily anymore because of what was put in the pretrial order. I wish we could get some kind of an agreement to just agree to that. That's not something that we've been able to agree to, and obviously a statement in pretrial order is not necessarily binding on a party. The only argument I would have is that we engaged with the other side, have been engaging with the other side since April of 2024. Mrs. Martin engaged a little bit, as we've heard, prior to me getting engaged. And the last of the encroachments were only removed yesterday. That puts us, in a pattern of not wanting to move stuff, not wanting to give us access. Things don't get moved until the lawsuit's filed. You also heard evidence that they don't dispute the survey. They never retain their own survey. Property boundary line was staked. It was flagged. You heard all of that. So, I am worried to a certain extent that this could happen again, or something could be put over the property line. So unfortunately, I think we're still in a position, even though it seems like there is an agreement in the pretrial order that's not binding on anybody, that we still have to ask for an injunction.
Okay, Mr. Miller, anything you want to respond to as to that claim?
No. Your Honor, as far as the injunctive relief, as we stated in our motion for summary judgment, Georgia law strictly limits the grant of injunctive or other equitable relief to restrain a trespass to certain exceptional circumstances which do not apply here. In the pretrial, we agreed, and the pretrial supersedes all other pleadings. We agreed that we would never put a fence on her property again, nor will we plant bushes, which were actually originally placed there when they bought the property in 2018. And those bushes have been removed. And the only reason why the turf was not removed until yesterday was because she couldn't get a contractor to come out and remove the turf. But the turf is removed now. So we've agreed that we're not going to certainly plant more bushes, certainly put anything else on that property line, which we assume is where we pulled up the bushes. We don't know because the pin in the back was not identified until, was not provided to us until October 30th, which is the evidence last year. And the only thing in the front was a stake with a pink ribbon around it, but there's nothing in the middle. There were never any flags, never any string, nothing. So we just went with our best guess as to where the boundary line is. And it goes back at an angle. It doesn't go back straight. It goes back at an angle. So it's actually more in the front and a lot less in the back.
But it doesn't curve, right? As long as you know the two endpoints, you could draw a string between the two and you'd have the line essentially, right?
Essentially.
Okay.
But it does go back at an angle. So there's less in the back than there is in the front.
Sure.
So there had to be an angle cut to the turf, for example, and we didn't do that. We just took it up 2 feet in. And the bushes bushes, half of them were over the line and the other half was not. We just took them out. We just assumed that that's where they were. But the point is, there's no reason for any injunctive relief. It's a moot question at this point.
All right. Well, yeah, I mean, I think on that point, injunctive release focusing on balancing the equities, the circumstances of this case, although it's been protracted, this isn't a repeated instance where this is happening over and over again. I don't think that statute can be overcome. So I would find in favor of the respondents as to count one. As to count two, the trespass. Ms. Klein? I would like to know kind of your theory and what damages you believe you've proven and you would be asking for.
So, Your Honor, under OCGA 51-9-1, yet every person is entitled to the quote absolute right of enjoyment of private property, and they can recover damages from any person who interferes with that right. The evidence here was undisputed that there was a trespass of the fence, artificial grading, artificial turf, the grading, and the bushes. There hasn't been any other expert here to testify about any other type of survey. Both the 2024 and the 2025 surveys show the same line, show the same encroachments. Now, respondents argue that the innocent trespasser doctrine should apply. They say they relied on this old chain link fence as the boundary, but the innocent trespasser doctrine only protects individuals who enter the land of another under the mistaken belief that it is permissible to do so, and that the unintentional and non-negligent entry does not automatically subject an individual to liability, even though the entry causes harm to the possessor. That's from the McDonald case, 306 Georgia App 641. Our position is that the Thomases received notice of the encroachment in April of 2024 through the demand letters. We included a copy of the survey. We offered to send them a copy of a blown up survey via email if they needed to see more details on that. And so even under the most generous reading of their position, any claim of innocent trespass ended at the date that they were provided notice of a survey, which they don't dispute anything of the survey today. And, you know, in the pretrial brief, the respondents cited to the case of Young versus Faulkner, which is 228 Georgia App 587. In that case, the Court of Appeals held that a trespass was willful as a matter of law because the trespasser had noticed that his belief about the boundary was unsound and he just proceeded with building stuff on it regardless. The court stated there, quote, had the defendant Young wished to do so, he could have tested his belief regarding the boundary line in the courts, and he didn't do so, or he could have potentially obtained a survey. But this was just a belief that he had. The Thomases, again, received a survey showing the encroachment. They told us that they would get their own survey back in July of 2024. They never did. They never gave us an update. I had no way to contact them other than sending a Federal Express or something, you know, personal service to their address. We never heard anything. And so under their own cited authority, the Young case, that trespass was intentional, at least as a minimum after April of 2024. And they can't stand by the innocent trespasser doctrine. Now, the Thomases also point to this connecting of the fence to theirs. I think there's a dispute as to when that connecting fence was actually placed there. They're trying to say that that's some type of form of waiver. I don't believe that there's any authority for that proposition. I believe that the covenant type cases are written agreements that run with the land. Usually for statute of frauds purposes, it has to be a written agreement that's going to run with the land that can be recorded. So really what I think they were trying to argue is some kind of acquiescence of the boundary line. Well, that statute, which is at OCGA 44-4-6, it requires 7 years. So it's basically a prescriptive type easement or an adverse possession, which would require even longer period of time, 20 years. This fence was admittedly built in 2020. We're nowhere near the 7-year requirement. Also, I haven't been able to find any case law that says connecting a fence to an existing structure is somehow a waiver. You know, I think it's I think it's clear that everybody thought, at least prior to this survey being done in April of 2020 or in February of 2024, that that was the boundary line. I think everybody agrees to that. But once they were placed on notice that, in fact, it was over the boundary line, it needed to be removed, we needed access to their property, they didn't do anything. And we had to file this lawsuit. So we don't think that the innocent trespasser doctrine applies here. What we're asking the court to award, and I can put it up, I have a demonstrative if the court would like to
Is that
see
in
it.
your binder?
It's number 17.
Okay.
I had to recalculate it based on what Mr. Barnhart sent today.
Oh, it's empty.
So I don't have a copy of it, but I can put it, I can show it to Mr. Miller first to see if he has any objection to it.
I've never seen it.
Well,
I had to create it because of the projections.
And it's not being entered into evidence. You're just using it as a demonstrative. So you can feel free to display it and then we'll go from there.
So this is essentially the calculation that we're asking the court to take into consideration. The total lot size is 19,788 square feet. It's about 0.45 acres. If you look at the Fulton County Board of Assessors valuations, which is at P15, that's where we're getting this land value from. So we're basically taking the total amount of the lot that was affected by these encroachments, which there was testimony that at parts it was 1.5 feet up to 3 to 4 feet. So approximately 3 feet of the encroachment width. The length of the fence is approximately 115 feet. So that comes out to 1.74% of the lot. Very small amount, but still, as a property owner, she was not able to use this portion of the lot. It doesn't matter whether the lot was, or that portion of the property on the other side was not, I think they showed pictures of a can or something like that. That doesn't matter in terms of a trespass claim. And so we're taking from April of 2023, when she purchased the house, to January of 2026, when the fence was finally removed. That's approximately 33 months. And the calculation for total loss of use is about $19,000, $19,817.70. In addition, we were asking for the out-of-pocket costs that she had to incur related to the survey that she had to come out the first time, survey come out the second time, and then the fence that had to be repaired when the pin was being located.
Okay, well, let's focus on damages for a moment here. Just because you started here with the survey. The survey first came about at the request of the landscaper, right? It would have happened, the survey could have come back and there was no fence over the line. It was an open question. So did that really flow from the trespass, or was that something that was just going to happen regardless? And then there's only a second survey because the first one didn't finish the job. Does that flow from the trespass? If it predated even the intentional knowledge of a trespass?
I understand that argument. I think that, again, we would have had to have had a survey.
And then in terms of loss of use, we're not saying the property was damaged in some way. We're not saying it was, there's been a lowering in the property value because there was a fence there for a while. And I didn't really hear evidence that that particular 3 foot was just very crucial to the use. There was talk of maybe a dog. I didn't quite follow why we couldn't own a dog with the fence being 3 foot further in than if it's 3 foot further back. I didn't quite follow that.
Well, I think the testimony from Ms. Martin was that this landscaping plan that she had discussed with the original landscaper, and then landscaping plans that are in the exhibits basically required landscaping to go up into that area. And so she hasn't been able to complete that plan. That's her position on it.
All right. And so, to me, that's now getting into, and I didn't think this was necessarily, I don't know, let me let you put that. That sounds more like a pain and suffering type argument. You're saying that because I lost 2 years in developing my property, that's the measure of damages here? Are you arguing this is a mental damages of some kind because we lost 2 years of landscaping work?
No, we're not arguing that. We're just saying that the only way to calculate this, I believe, is because there was not an existing structure or a driveway or something like that. The only way to calculate it is based on what is the value of the land, what was the portion of the property that was affected, and that's how we're getting to these numbers. It's loss of use. Again, every single person who owns property has a right to use it or exclude people from it as they deem necessary. So this is the calculation that we thought was the most mathematically simple and accurate, because yeah, we're not going to sit here and ask for pain and suffering on a case like this or emotional damages or anything like that. But this is a reasonably calculated number based on the county's own valuation records for only the land, not the house. So that's only including the land valuation, county's own records for that, and calculating it based on the 1.74% of the property that was affected.
1.74% of the property from the date of your demand letter to today?
We have it in there for 33 months. So that would be when she purchased the property.
All right. And that equals $19,000 approximately?
Correct.
Okay. All right. I'll probably be circling back to you on this point because this, again, is, I think, crucial here. And so I'll turn it over to Mr. Miller. Maybe we can start with that, the willful trespasser defense. It's your burden to show that. And yeah.
Believe that we have shown that, Your Honor. If the innocent trespasser is in effect here and it actually bars, and the court should grant a directed verdict on the trespass claim under the case that he cited, the McDonald case. Respondents are innocent trespassers and therefore petitioner's claim for trespass should be dismissed. The innocent trespasser doctrine protects individuals who enter the land of another under the mistaken belief that it is permissible to do so. There was clear testimony, undisputed, that there was a chain link fence.
So I think he's essentially conceding that point, is that the only reason the fence got there to begin with, it's pretty hard to show intent. But his point now is once we gave you that survey and that fence stayed there for another 2 years, that's where that defense gets a little rockier shores here.
Look at the letter that included the survey of April 23rd, 2024. You'll see that they requested two things. They requested to be permitted on the property, and they requested that once we get the survey updated, as the court indicated, that they would ask that the fence be removed. That survey was not updated, not corrected, not provided to us until October 30th of 2025. The fence was removed in January of 2026.
So are you a trespasser in November and December?
So within a reasonable time, you're removing the fence. Within 45 days, 90 days, 60 days, you're removing the fence. And I guess that would be the measure of damages as far as any kind of trespass, because the survey wasn't completed until November 1st or October 30th.
Yeah. Just curious, had you come across anything that shows this, when you are put on notice, how much of a grace period you're given? I mean, it seems to make sense to me that you can't instantly be held to account, but perhaps so. And the longer you take, the more you assume the risk that there could be some damages that result. Yeah.
At that point, in October of 2025, the offer had already been made in November of 2024 that the fence would come down. Forget the updated survey, and if you just prune the tree back for $1,300. And that was November 2024.
And I put that all in a box, so that's going to what we'll get to, which is attorney's fees and those findings. But just on a purely liability grounds, at what point, once you've gotten a completed survey, are you expected to have removed the fence?
I think that once you've got the survey, you've got a lawsuit pending, you've got every attempt under the sun to try to settle the case, and within 60 days of that updated survey, the fence is gone.
Okay.
But I also think that the innocent trespasser rule takes this completely out of the court's discretion or decision because it applies here full force. The Georgia Court of Appeals has defined a willful trespasser as one who knows that he is wrong. In that case that he cited, the Young versus Faulkner case, the fence in Faulkner did in fact clearly mark the boundary line. And the defendant knew that. In the McDonald case, it states the Georgia Court of Appeals has defined a willful trespasser as one who knows that he's wrong, while an innocent trespasser is one who believes that he is in the right in entering the premises in question. I mean, the fence was built 3 years before Miss Martin bought the property. And it was in place and it was never complained about. In fact, it was understood to be on the Thomas's property. So I don't see how an innocent, it wouldn't take care of the innocent trespasser rule, wouldn't take care of any kind of intentional trespass up until November of 25.
Okay. Yeah, any responses to the measure of damages they proposed?
Measure of damages are de minimis. I mean, you've seen the pictures from M1 through M8, which show the way the land looked on March 3rd of this year. There was nothing but dirt, rock, glass, cans, trash on this swath of land, which is about 15 feet wide, right beside where the fence used to be. That land has to be taken into consideration as just basically unused land. And on top of that, the tax assessor exhibit is an improper way to measure damages. That kind of evidence has to come in through a state of Georgia certified general appraiser and a licensed appraiser. And Ms. Martin is not that. In fact, a licensed appraiser does not use the tax assessor mass appraisal, as it's not utilized to determine fair market value of any sort of land at any point in time. And Ms. Martin testified that she heard that it was 5% based on hearsay. So somebody was talking about that and she heard that. She didn't make any calculations of that amount. And apparently opposing counsel has made these calculations based on a 33-month period, when in fact, at most, it was 2.5 months. So we would object to the use of the tax assessor as any sort of measure of damages. And we would request that the court look at the pictures of the actual land to see how it was used, at least the 12 feet or the 10 or 12 feet that was not impinged by where the fence was. It was unused land completely. In fact, it had trash all over. So that value is de minimis at best.
So, Mr. Klein, on the issue of intent, the original letter they get that has the survey that you said, well, that was the moment they were put on notice, is one of the conditions. It says that once the quote updated survey has been completed, that's when you move your fence. So should that actually be the appropriate point of when the intent is shown, or is it more recently in October?
I think it should be that date. It says in my letter that the survey is accurate. We heard testimony from the surveyor that it was an accurate survey. It was signed by a licensed land surveyor. We also heard evidence that the respondents don't dispute anything on either copy of the survey. So they were on notice of this. They said they were going to get a survey in that response letter, July 25th of 2024, and they never did. They could have gotten a survey during the course of this litigation. They never did. So they were put on notice of a trespass as of my April 2024 letter.
This is one other thing I would point out, since again, I think damages are a bit convoluted for this claim, is that under OCGA 51-9-6, damages for continuing trespass. Statute cites that damages for a continuing trespass are limited to those which have occurred before an action is commenced. So meaning once you file that complaint, it stops right there. So already I think we have some issues with this calculation, even if we were to go from April to the moment you file your complaint in October.
Well, certainly, Your Honor, the court can still even award nominal damages. I know.
Yeah.
You know, I had a case that went up to the Court of Appeals, and nominal damages of $50,000 were granted on a trespass that actually benefited my client's property.
When did that, I mean, have you seen the Walmart case on nominal damages last year? They've really reined those in. They now say it has to be a trivial amount.
Gotcha.
Important, not for the sum, but justifying the
Yeah,
award.
mine was ASIH versus Vickery Falls.
But did it ever go up on appeal before last year?
It went up, yeah, appeal in 2020, I think.
Okay. So I think the Supreme Court really reined that in last June. All right. I mean, I would say that, I mean, I'll take a closer look at the record and the exhibits that have been completed here, but I do believe that the innocent trespasser defense has been established here from the date the fence was installed, and so the earliest there could possibly be a finding of intent would be April 23rd, 2024. And that would only continue up until the filing of the action in October. And for that roughly 6-month time frame, the damages that have been established here, and also I'll look more closely at the damages that flow from trespass, but right now I would not be inclined to say that there is anything more than nominal damages that have been proven here, assuming that intent is also shown. Just based on looking at the exhibits and the testimony, I don't see that use was inclined or impaired to an extent calculable to $20,000. I'll take that under advisement. Just moving on to the remaining two claims, nuisance and negligence. Mr. Klein, I mean, is there a different measure of damages that you're contending flow from those, or are those essentially duplicative?
Those would be duplicative.
Okay. And I think there would be other issues with those. I don't know if we really need to get into them, but I think for the record, if you want to preserve that, Mr. Miller, and I think you've already laid out why you think negligence claim fails based on statute of limitations, and for nuisance you said because it was physical encroachment only. Maybe you can repeat that again for me.
That was submitted, Your Honor.
Yeah.
Distinguishing nuisance from trespass. Claim of nuisance may not be brought based solely on a claim of physical taking. In the cases cited there, we would stand on those cases. By contrast, the trespass claim is based solely on the physical taking of the plaintiff's property is itself a wrongful act. Trespass is a distinct direct infringement of the plaintiff's property rights as opposed to an indirect in the case of a nuisance. There's no claim for nuisance on the plaintiff's or the petitioner's part here. It fails to state a claim, and in addition to that, Your Honor, there is evidence certainly now that this fence was put up by Ms. Martin to connect to the other fence. And it would be our position by deriving that benefit of constructing a fence to the other fence, to the Thomas's fence, was in fact a waiver of waiving that location of that fence was in the wrong place. And at least for the year before she had the survey done, she was happy to have that backyard completely enclosed because she erected that fence to connect to it. and then derived the benefit with her and her son of having backyard completely enclosed. And therefore, the covenant and restrictions trial memo does in fact apply here. And the collateral agreement that they had with the prior owners as to the location of the fence would in fact bar their claim because it's a prior agreement that runs with the deed. And Ms. Martin was on full notice of the fence when she moved in, when she visited the property, and then she's on even more notice when she takes advantage of that fence by building a connecting fence to enclose her entire backyard. And it's obvious from the picture. It shows a brand new fence on the side coming off her house. And then it shows a really old fence that was built in 2020 going down the boundary line or going down right next to what they believed was the boundary line formed by the chain link fence, which ran parallel to the wood fence.
Going back to your nuisance argument, is it essentially you're saying there's a distinction here that nuisance has to be an indirect infringement? And so,
Physical taking.
okay. And so how do we break that down when it comes to the branch claim? I mean, because that is physically over the property line. Is that not a direct physical infringement? So does this same argument impact yours?
No, because the branches are continuing nuisance.
Okay. All right, Mr. Klein, anything else you want to be heard on when it comes to the negligence nuisance claims?
Just to respond to that Atlanta Association of Baptist Churches, that's a 1938 case about an implied restrictive covenant in a subdivision development. Again, we take the position, it doesn't have any application here to nuisance or trespass or negligence. Again, there was no evidence put up that there was an agreement in writing. There were some vague contentions that
Or even an oral agreement.
I mean, there were some vague contentions about like the neighbors were okay with it, the prior neighbors, but that was about it. So I don't think any kind of acquiescence or covenant issue would apply here.
All right. Well, I think looking at those cases as well, I don't see this case law on covenants and this waiver argument as defeating these claims entirely. They have other issues, but on these particular ones, I don't think there was any evidence, or if there was sufficient evidence to show that there was any kind of an oral or any kind of agreement rather that's been proven that was in the deed or made between the petitioner and the prior seller. And I think that you need something more explicit to fall within these line of cases. So, the legal argument's preserved, but I don't think that's going to be determinative here. Rather, there's other aspects that a negligence claim I think are going to run into issues here. One, again, usually you have to have proven damages, which already I've kind of indicated. I'm not really overwhelmed by the evidence on that. And as to the nuisance, I'll look at that argument otherwise. Okay, but that I think really comes down to the only reason we're even still here is because assuming you get nominal damages on trespass, that could still support an award of attorney's fees under 13-611. And so before I turn it over to you, you want to make any argument you have as it relates to that, Mr. Klein. I just want to make sure that everyone's on the same page because there's testimony maybe indicating otherwise that the specific type of attorney's fees we're talking about here today isn't a guarantee of every single cost and an hour that an attorney is billed. It has to be tied to the claim that you win on, if you win on a claim. And so, for example, I just point that out, Mr. Miller, because if you were to win, you're going to have to show me if you can segregate between the work you spent on one claim versus defending the action. It wouldn't just be automatically all or nothing. And then I'll also point out that, again, my understanding of 13-611 is bad faith and stubborn litigiousness and unnecessary trouble and expense. It's not just mere refusal to pay a disputed claim. If there's a bona fide controversy, meaning reasonable minds could disagree and things need to be worked out, that's not stubborn litigiousness. That's not unreasonable trouble and expense. And bad faith is not just bad judgment, but it's intentional. It's conscious indifference. ill will. So it's a high standard. The American rule going back centuries is that when people hire lawyers, they're on the hook and they're expected to pay their own costs. It's not that way elsewhere, but that's our standard. That's kind of the presumption in most cases. So recognize that just because you lose doesn't mean you get attorney's fees, or just because you win. There really has to be a showing of that. So with that, Mr. Klein.
I don't want to belabor I would basically be talking about the same things. We sent demand letters in April of 2024. Tried to communicate with the other side. I couldn't get an email address. I couldn't get a phone number. We sent follow-ups to their questions, answered all their questions, and we still couldn't get access. And then we waited another almost 3 months to file the lawsuit. And now they said they were going to get a survey. They never did. You heard testimony from Mr. Thomas that he doesn't dispute anything in the 2 copies of the survey that we had. So it's absolutely shown that there was a trespass here. I don't think that there was a bona fide dispute as to whether there was a trespass here. So for that alone, I think we should be getting the vast majority of our attorney's fees, because throughout most of this case up until a couple of days ago, the only claims that we had were trespass, injunctive relief, and then the ancillary claim for attorney's fees. You heard testimony from Mrs. Martin. She didn't want to be in this position. We felt like we had to file the lawsuit because of the March 27th letter, the text messages, and then the seeming unwillingness to cooperate. And I understand their position on that they were sending these letters via FedEx to be, making sure that, their rights were preserved, et cetera. But why couldn't I get a phone number? Why couldn't I get an email? And not hearing anything for another 3 months after they said a survey would be commissioned. I don't really know what other option was other than to just wait around.
Was there any communication that you sent to them that they did not respond to eventually?
No.
Okay.
But again, the ball was in their court. They said they were going to get a survey. And that's where it left us. So, and by the time that settlement offer was made by their prior counsel, she had already incurred attorney's fees related to those letters. She had already incurred attorney's fees related to the drafting of the lawsuit, filing the lawsuit, serving the lawsuit, et cetera. And there was never an offer made to compensate her for those attorney's fees. Also in that settlement offer, I think there's a dispute I think the term what the arborist specifications are, or, to the arborist specifications, the tree should be debranched, the branch is taken off. What does that mean? Then I had, 4 days to respond to a settlement offer on this particular issue. And then I was told, well, it's being turned over to new counsel. And we did make attempts to try and get something resolved in the course of litigation. But by that point, we were already going out to the property and more attorney's fees being incurred. So we would ask for our attorney's fees to at least be given back on the trespass claim, Your Honor.
Well, just since you bring it up, we might as well just get into it too. The other claim for the nuisance now with the branches. I think your client essentially conceded liability on this. I think she said that I agree that there are branches and that those cause harm. So do you have any dispute that if a tree is entirely on one side of the property, that if the branches go over to the neighbors, that the tree owner has the responsibility for those branches and that tree?
So the case that I cited, the Willis case, 184 Georgia Ave, 349. It says if they're aware of something that they can prune or trim, which they've been aware of it since 2018. They had communications with the prior neighbor since 2018, where they could have gone up there, taken care of the branches that were overhanging. And as long as they didn't damage or kill the tree, which is undisputedly in good condition, then they're under an obligation to do that. That is what this Willis case says.
Is the Willis case, though, distinguishable because the tree is on the boundary line?
I don't think so.
I mean, that's a pretty key point. Like they both owned the tree. And that makes a point of that in the Willis case, saying that they both had this joint responsibility over the tree because it's right there on the line. This one, there's no question who the tree belongs to.
Correct. The base of the tree the tree belongs on her side of the property. But again, there's a self-help doctrine in Georgia, and they were aware of these branches since 2018. They could have gone out there, pruned and trimmed them. They never did. They just allowed, allegedly these branches to come down on their roof, come down on their house.
And they're not even, well, I guess they are now because there's something that happened in March, but up to this point, they weren't asking you for damages that predated the lawsuit. They just said, this is now a nuisance. You need to abate the nuisance. And so, and I think, again, your client said, I agree, it's a problem. And so, okay, set aside the damage that they're saying happened in March. I mean, did your client not admit liability to needing to abate the nuisance at her expense?
No, because again, I think that they've had this issue since 2018. They know that they could have pruned the tree. We have a report from a tree company saying that it has to be done from their side of the property. So as long as they didn't kill or damage the tree, they could have pruned this tree at any time they wanted to. So I think, I don't know what there is to abate when they could have abated it themselves.
So, okay, fine. So they should send you a bill for it? They should do it and send you a bill? The question is who pays?
Well, I think it's their responsibility.
And why so if the tree's entirely on her line and it's her nuisance?
Well, I don't think it is her nuisance. I mean, again, these are overhanging branches. This happens all the time in Georgia. If I have a tree in my backyard where things are overhanging, I just cut it. And that's what you're allowed to do in these situations. So I think they had a responsibility since 2018 to do this. And instead they just had a situation where I guess the prior neighbor was just reimbursing their damages. I don't really understand that, why it was never pruned for the last 7 or 8 years.
So, I mean, I know you cite the Willis case, but is there anything else you can point to me that shows that in this kind of a fact pattern that the branches going over a line become the responsibility, the sole responsibility in your position of the neighbor?
I don't right now, but if he wants to make an argument, I can do some research briefly.
And I'll just point out to the issue he raised in one of these memos about duty to mitigate. I mean, if you look in our pattern instructions for tort claims, it says that with continuous torts, that doctrine doesn't apply. So setting aside the 1909 case that Mr. Miller found, it looks like our pattern instructions and some more recent cases echo that point. So if there is no duty to lessen or duty to mitigate to a continuous tort, what then is the defense to the liability of the nuisance that's claimed here? And right now I'm not seeing one. All right, I'll turn it over to you, Mr. Miller.
Thank you, Your Honor. First of all, I don't know why he's saying he couldn't call Brandy. I mean, Brandy left several voicemail messages, or one voicemail message on the 24th of April with Miss Martin. Miss Martin had Brandy's phone number. So at any point in time during the summer of 24, Mr. Klein could have picked up the phone and called Brandy because Miss Martin had her phone number. So that argument, I don't know where he's coming from with that. In addition, as you pointed out, the Willis case was about a tree that was on the boundary line. Here we have a tree that's definitely located on her property. The law in Georgia is that once a tree owner is put on notice that that tree has dead branches or is looking like it's dead or whatever, if it falls or causes any damage to the neighboring property, it is the responsibility of that homeowner that owns the tree. In fact, it's the responsibility of that homeowner's insurance company to take care of that tree damage that occurred to the neighbor. Now, if the tree doesn't have any noticeable damage or noticeable rot or dead branches or whatever, then the neighbor has to take care of the Thomas would have, their insurance company would have to take care of it. But in this instance, the Thomases did exactly what they thought they needed to do, was to put her on notice that, in fact, once you're on notice that there are dead branches and we got this report from 2021, let's work together and let's do something about it. And that's what that text was about. It was all about sorority sister. Let's get together and let's get the prior owners to do something for you with this tree. And that's what it was all about. And in fact, Brandy, at the end of that text message said, quite frankly, I want to deal with you. I don't want to deal with attorneys. Let's just talk about it. And Ms. Martin refused to do that. She refused to do that to the point where she said, Keith's going to take care of it. Well, Keith blew off Cedric as they were having other trees removed in their yard on the 23rd of March. And then they gave him a letter, official letter, with the text, with the report. And they knew that there was a report from 2021 which showed this is a hazardous tree. Let's do something about it. And the next thing they know, they get an attorney letter from Mr. Klein. And as the court pointed out, that letter stated, once we get the completed survey, it doesn't matter whether the survey was accurate or not. His letter said, once we get a completed survey, then we want you to remove the fence. And that's what the letter said in April of 24. Now, fast forward to November of 24, you've got Ms. Nealis involved, and she quite clearly made an offer to say, forget about the survey, forget about completing the survey. This is November of 24. Let's just prune the tree. We'll pay to have the fence taken down.
And I see that as the bad faith. But if their original position was, hey, look, your fence is over the line, we're going to confirm it later. And once we confirm it, we want you to remove the fence. But then a couple months later, they're told, we're not going to let you confirm it. We don't want you back on the property. How can then they ever follow up and give you that completed survey? And I know you did, it later happened. But at some point in there when it's, nope, you're not allowed back on the property to confirm it. Now, aren't you just left with a survey's already been sent to you and your fence is over the line on that survey? We don't know exactly where, but it is over the line. Why not just remove the fence and then follow up later to figure out exactly where the pin is?
Because at that point in time, Randy was not represented. He could have received a call at any point in time from Mr. Klein. And his letter was sent on June 20th. One letter was sent on July 25th. And nothing's happening in August other than Brandy's trying to get a survey done. And she's getting hit with all the things that
life,
I
get it.
And at any point in time, he couldn't call him. But he turns around and files a lawsuit instead. There was never any demand to say, okay, you've got the survey, now you've got to remove the fence. There was only the demand in April to say, once we complete the survey, then we will ask you to remove the fence.
What are you asking for in attorney's fees?
We were asking for. I don't know that I'd like to see the case on that because I don't know that I have to split out my attorney's fees as to the counterclaim, the nuisance claim, as opposed to the defense of the main claims that came through. I don't know that I can split that out, but our attorney's fees are in the neighborhood of $46,000. And that is after a $15,000 credit that I gave to the Thomases based on the fees that were incurred here. And the majority of those fees are within the last 2 months.
Those are all you, that's all your work? That doesn't include?
That includes the King.
Okay.
As well.
All right.
The majority of those fees are due to the hearing on the motions, the mediation, the inspection, and prep for trial.
Yeah.
That is our claim, Your Honor, and I think it's fully supported by our exhibits, especially Ms. Neal's emails, which I would point out. they never came back to Ms. Nealis and said, okay, you want us to prune back the tree to the satisfaction of an arborist. What do you mean by that? Give us an idea of what an arborist is gonna require us to do. Let's go out there and have an arborist take a look at the tree and, move forward with this settlement. There was none of that occurring at that point in time. It was just a total stonewall at that point in time because Ms. Nealis, as you'll see from these emails, she was contacting Mr. Klein like every other day, trying to find out, what's going on. Let's get this thing settled. We want to get it done. I mean, Ms. Thomas testified she wanted to get this behind her. And that offer was very reasonable for both parties, and it would have taken care of everything at that point in time. And we're talking November of 2024. Now, the extension on the answer. Additionally, trying to get a settlement, and then never were able to do it. As far as the access agreement, they were provided access in January, February of 25. They never accessed the survey pen until September of 25. It seemed like there was a constant delay on the part of the petitioner, and there was a constant trying to get stuff done and trying to get it behind us on the part of the respondents. As far as the answer filing date, as far as the access agreement, as far as the survey pen finally being located and determined to be the actual boundary. And the fence was removed within 60 days thereafter, which I think is a very reasonable amount of time with a lawsuit pending against you, where the other side is refusing to settle the case and or prune back a tree, which is obviously they have admitted was a dangerous tree right over their bedroom, right over their garage, and right over their driveway where they enter their house every day of the week. So we think we're entitled to attorney's fees under 13611. We think we've shown bad faith. And I would point out that in our brief, petitioners claim for attorney's fees should be dismissed. An award of fees is only authorized where the evidence reveals that the defendant acted in bad faith. Attorney's fees may not be awarded if the action allegedly in bad faith was prompted by an honest mistake as to one's rights or duties. Obviously, they put the fence there in the first place because the neighbors wanted it, because they thought and understood that it was on their property because it was on the other side of this black chain link fence, which was a bad one. That's the only reason why they put the fence in that place. And the neighbors were in total agreement with it. They wanted it. There can be no finding of 13611 claims under the case of Brown versus Baker at 197 Georgia Appeals, 466, 467, 1990 case, and also Bowen versus Laird, 348 Georgia Appeals, 1 and page 3, a 2018 case. Here, the evidence clearly indicates the respondent's alleged trespass was prompted by an honest mistake based on a chain link fence that pre-existed respondent's purchase of the property, petitioner's purchase of the property, and the agreement that this formed the boundary of the Martin property. Respondents corrected this mistake soon after receiving accurate notice on October 30th, 2026. So we think we're entitled to attorney's fees for bad faith and for unnecessary trouble and expense, which this has definitely been at least since November 24, when the offer was made, prune back the tree, we'll take down the fence. Thank you.
All right, thank you, Mr. Miller. Mr. Klein, if you just anything and everything you want to address, just have the last word here.
Sure. I mean, I'm performing research right now while we're talking about this waiver issue relating to the nuisance or a mitigation issue relating to the nuisance. Honestly, I would like some time to address that. This is the first time that I saw that in the trial memorandum. So I've been trying to cobble together what I can on that issue.
Well, I'll tell you, the waiver thing I'd already said, I wasn't really seeing any connection there in the case law. The duty to mitigate, I think, is something that is worth addressing.
I just want to correct, the access agreement was not signed until June of 2025. We took steps to get out there as quickly as possible. I mean, if you want to see all the emails, I'm not going to show them to you, but there was a lot of back and forth between the attorneys. Hey, can we do this date? No, can't do this date. And then finally, we got a date we agreed on where everybody could be out there. So it's not like the delay is just completely on our side of the coin here. But I don't think there was bad faith here. She had a reasonable belief that, number one, the tree issue should have been taken care of by them. She had an arborist or tree company come out there in March of 2025. They said that it could easily be pruned, but it had to be done from the Thomas's side of the property.
So if the law is quote unquote well settled, that if a tree's on your side, you're responsible if it falls, how's that a bona fide controversy?
Well, the tree didn't fall. I mean,
Well, or I think that could be extended to a part of a tree falls, which would be a branch, right?
branch.
Yeah.
I mean, again, I think that a branch and a tree falling are two different things. I mean,
Yeah.
tree falling and splitting a house in half versus a branch that may or may not have caused some damage to a roof. I think that's completely different. It's definitely different in a situation like this, where this has been going on since 2018, prior to us even purchasing the property.
Okay. Is there anything else you wanted to address?
No, Your Honor.
So are you requesting to supplement on some of these legal points?
I just need to supplement on the waiver issue that we want to talk about relating to the nuisance and their actions since 2018. Yeah, I'm finding some case law about this, but again, I haven't had enough time to research the issue.
All right. How much time do you want?
I mean, I can get it to you by Monday at the latest.
Okay. So I think I've already kind of given you some preliminary rulings on some of these claims. Again, the one I would be most interested in hearing from you, Mr. Klein, is how you think that and why you would think that it's a bona fide controversy that, I know we've said this over and over again, but that if the branches go onto your land, then that makes you responsible for what happens, even if the tree is located entirely on the other side of the boundary line. And without having done too much of a deep dive, we pulled up Georgia DOT versus Smith, 2012 case, 314 Georgia Appeals 412, just giving that vanilla statement of it's well established that if there's a defective tree, here are the rules of negligence that Mr. Miller outlined, where if there's knowledge that there's some defect, then and that tree falls, who's responsible? I don't see why those same principles wouldn't apply to branches if they're falling from a tree. And again, there's knowledge that there are issues with it. And so the claim you made that the reason there's a bona fide controversy, the reason she didn't offer to prune and pay those pruning fees immediately was because she thought that they're the ones who should have to pay that. I would just like to see the legal support for that. And then if you said you wanted to follow up on this duty to mitigate issue as it relates to nuisance claims, you can do that too. And today's Friday. If you really, are you going to spend all day Monday on that?
No.
We can just do end of the week next week.
Yeah.
And I don't know, Mr. Miller, if that's something you want to respond to or not. I mean, I think I've got your arguments. You can if you want to. I don't want to tell you to spend more time on this than you already have.
Me too, Your Honor.
Okay.
I'll reserve the right once I read his brief, but I doubt it.
All right. So we'll say Friday next week, close of business for any written response. From there, I'll enter a final or non-final judgment as to the specific claims. Let me put it this way. If I find that there is liability on the attorney's fees, then we'd follow up and I'll have the parties confer, but essentially have you submit whatever prevailing side, whether it's, you can submit what your fees are. If there's an objection to that amount, preserving the issue of the reasonableness of them, but to the amount, we'll schedule for a hearing as is required. So I don't know if am I clear on the procedure there? All right. I'll enter a finding on the claims. I'll direct you to file evidence of whatever attorney's fees you have to support them. And unless there's an objection, that will then be made the final order. But if there's an objection to the amount, we'll have a hearing on the amount and we'll go from there. All right. Thank you, counsel. We're off the record.
Thank you, Aaron.